For judgment, JCRLA 50 of 2005 and CRLA 338 of 2004.
We've only modified the sentence for Bayana and Babwa, where the 20 years minimum imprisonment, that alone is removed. But otherwise, the conviction is confirmed. The sentences to life imprisonment are confirmed. The appeals are dismissed. They have to surrender within a period of 2 weeks, failing which the concerned IIC will immediately take steps to have them arrested in order to serve out the remainder of the sentence.
Item number 2, WPC 14469 of 2005.
The writ petition is dismissed. No orders to pass.
Item number 3, WPC 19416 of 2014.
The writ petition is dismissed.
In item 3, we have produced the original records that way.
The original records. Yeah, just we'll return it.
I may be pardoned to mention your
Fixed for 10:30.
Ah.
Matter fixed for 10:30. Weekly list. WPC 2746 of 2016. Weekly list item number 20.
My lord, for the CMC, my lord.
Yes. Tell us.
My lord, I had a discussion with all the concerned officers. My lord, it now transpires that this main drain 1 which is now under construction, is to be completed.
Ah.
The work for that main drain 1 is now stopped under this Matru Bhavan junction because there is a railway overbridge there, and that drain is not getting completed because the OISIP authorities, the sanitation improvement authorities, have deposited some 14 crore rupees to the railways because as a railway overbridge, they have to do that work. So the deposit is made from 2014, but they have not yet completed it for some reason. Now the link drain that discharges water into the wastewater into Kajjodi River is supposed to actually connect the main drain that is supposed to go to the sewage treatment plant at Madgajpur. Now, because the main drain is stuck over there below the railway bridge, the railways are not doing the needful. That's why that drain water is not being able to discharge into the main drain.
So we issue notice to the railways then.
My lord, Railways, East Coast Railways, Khurda division. That is
There's a Mr. Mishra who keeps appearing. Where is he? You can ask him to come. We'll ask him to come and accept notice.
ASG will appear. Mr. Patil.
All right. Mr. Debashish Nayak, Learned Counsel for the Cuttack Municipal Corporation, bracket CMC, informs the court that the discharge into the Kajjodi River is happening through a drain, which is in fact a, what is it called? Subdrain.
It's a branch drain, man.
A branch drain, which in fact had to be connected to the main drain. Full stop. He states that the work on the main drain is stuck due to supposed construction of a railway overbridge.
The overbridge is already existing. The main drain has to go below that overbridge. And because the structure
stuck because the main drain is supposed to pass under a railway overbridge. And despite money having been deposited for the work with the railways since 2014, but the work is not progressing. See, notice be issued to the East Coast Railway. Mr. Padi accepts notice for the East Coast Railway and states that he will seek instructions. Can we have it on Friday, Mr. Padi?
Can let's see by next week.
No, Friday, sir. This is East Coast Railway, the headquarters in Bhubaneswar.
Yes, I will got you. Yes.
List on Friday. What about the Watco?
Yes, my lords. The managing director is present, my lords, and he has to submit what the developmental work.
Sure.
Sir, namaste. Sir, till today we have completed all the Amrut projects which has been taken care by the Amrut, and the entire will be completed by June 22, sir. Water supply to the affected area by June 22. The ESR of 28 number has under commission, and it will also be completed by June 22. By Watco till today we have uncovered area of 100 kilometers of pipeline has been laid, and the missing.
No, but what does this actually mean? Because you are using some language which is not clear. Just tell us again. Can you remove your mask, sir, if you do not mind, and speak into the mic, sir? The way I am speaking, you are able to hear?
Sir.
Likewise, I want you to speak.
Sir, in Amrut, we have 19 packages, out of which we have completed 19. And in this packages, we have 18.3 kilometer of pipeline, and we have a district of 370 zones, and house service has 39316 has been completed. And the entire elevated reservoir, high altitude reservoirs, which has been completed under Amrut, and it will be commissioned by June 22, sir.
I have no idea, sir. Suppose in my house in Cuttack, I open the tap, I'll get drinking water.
Sir, it will.
No, are you so certain? In every house in Cuttack, if you open the tap, you'll get drinking water?
That is, sir, drink from tap. It is only affected in ward number 48 till today. And it will.
I'm not able to understand. What is
Only in ward, they have provided this.
Ward 1.
Only one ward.
Municipality ward.
Municipality Ward 1.
Ward number 48, sir.
Ward number
How many wards are there in Cuttack?
59 wards.
So all 59 will get by June end.
Sir, it will be completed by December 24. Target is there.
December?
24.
So you have to file an affidavit.
Yes.
Everything, the way you are saying, everything is over by June 20.
Sir, Amrut work has been completed. And Watco.
So this,
Sir.
bureaucrats have a wonderful way of presenting things, sir. You'll never know what they're actually saying. So why don't you put it down in an affidavit?
Sir.
Huh? Please do that.
Sir.
He said the managing director of Watco is present in court, and he says that the drinking water availability in Ward 1, Ward number 1.
Ward.
That
That
is
is ward
48.
number 38.
48. Sir.
48, I'm sorry. Ward
Number 48 in Cuttack will be completed by the end of June 2022. But the provision of drinking water to every household in Cuttack is slated to be completed by the end of December 2024.
Right.
He will place an affidavit, the detailed time schedule, which has been drawn up by Watco for provision of drinking water in Cuttack city. The affidavit be also filed by Friday. By Friday, you file it.
Sir.
My lord, I have
So you do not have to be physically present. You can even come virtually.
Sir.
He must have told you.
I have filed the affidavit by Member Secretary Pollution Control Board as directed your lordship. "11 river systems are being monitored. Out of 129 monitoring stations, 19 are not confirming, and they are at Cuttack, Rourkela, and Bhubaneswar mainly.
So what are they doing for that?
Your lordship may kindly.
So we'll issue notice to all those municipal corporations, Bhubaneswar and Rourkela also.
Yes. So far as cardiology is concerned, I have given paragraph 11. Your lordship may kindly see paragraph 11, 12, and 13. Two STPs are commissioned in Cuttack, and one is under construction. If that is commissioned within the stipulated time of June 22, then the wastewater volume of wastewater will be.
So NGT is already dealing with it.
Yes.
F by 5. But this is an overall.
Honorable NGT is also monitoring. There was 19.
No, but after April 2020, they don't seem to have taken up the matter. That's for all over the country. Not particularly for Orissa.
No. That is mainly Ganga and Yamuna.
So who is responsible for this construction at Mata Gajpur, 16 MLD STP?
That
Para
is the
12.
water- that is the water supply and sewerage board, my lord.
Yes.
Who's representing them?
They'll
So they say that if they complete the construction of the 16 MLD STP sewage treatment plant at Mata Gajpur, there will be no untreated discharge of wastewater into Katjodi River.
no. My lord,
So ask them,
that's
when will this get completed?
that is already complete. My lord, if I'm not wrong, it's the linking of the drain that creates the
But I have
problem.
the instruction because I have.
No, but here this affidavit seems to indicate that after completion.
Yes, that is scheduled to be completed by June 2020.
Let them tell us the
This is
Dr.
as per
Murugesh,
information
the
by
Secretary of
HLDB
the
department.
Odisha State Pollution Control Board has filed an affidavit where inter alia it is indicated that deteriorating water quality is found at the downstream of major urban local bodies such as Cuttack, Bhubaneswar, and Rourkela. And the reason therefore is due to discharge of partially treated or untreated domestic wastewater into the river bodies. Stop. There are 129 stations of the SPCB monitoring the water quality of 11 major river systems of the state, such as Mahanadi, Brahmani, Baitarani, Rishikulya, Nagavali, Subarnarekha, Budabalanga, Vansadhara, Kolab, Indravati, and Bahuda. Full stop. The water quality at 110 stations conform to Class C rivers, whereas water quality at 19 stations do not conform to Class C with respect to either biochemical oxygen demand (BOD) or total coliform (TC) or both. Full stop. The orders passed by the National Green Tribunal (NGT) Principal Bench, New Delhi, in OA number 673 of 2018 concerning the remedial action for 351 polluted river stretches in India, and in particular the order dated 6/12/2019 of the NGT has been placed on record. So it is seen that there is a central monitoring committee constituted pursuant to the orders of the NGT. So this CMC held its 12th meeting on 4th February 2022, where states have been asked to take up proposals under AMRUT 2.0, Amrut 2.0, open quotation, for bridging the gap between sewage generation and treatment capacity with regard to sewerage network connections, unquote. This Mata Gajpur, it says running smoothly. Just come to
My
page 50.
Yes, one is running, another is under construction.
I see.
Oh,
One in Madhugajpur and one in CD are running, but one in Madhugajpur is under construction, which will be completed by June 22 as per the information given.
no. May I just place a line, Mano?
Yes, please.
Well, my instructions on this are the 16 MLD capacity sewage treatment plant at Madhugajpur has been completed, and it's presently treating approximately 2 to 3 million liters of sewage per day from 3 areas in Cuttack.
So why is Dr. Murugesh saying something else then?
Probably the instructions given to him are not proper.
This is the storage board's status. Orissa storage board has given this status. On that basis, we have written.
Anyway, you can clarify, Mr. Das.
Yes, but I'll file a detailed application.
You see,
Page 52, you will see that.
no, that's what we're seeing. But his instructions seem to be different. You see, the Orissa Water Supply and Sewerage Board, represented by Mr. Das, will inform the court on the next date of the current status of completion of the 16 MLD sewage treatment plant (STP) at Matagajpur. A representative of the OWSSB shall remain present in the court. Paragraph notices are also issued to the Bhubaneswar Municipal Corporation as well as the Rourkela Municipal Corporation. What about Sambalpur also is a municipal corporation?
Yes, yes.
Sambalpur.
And the Sambalpur Municipal Corporation. Returnable on Friday through their respective secretaries. To inform the court of the steps taken for installation of sewage treatment plants and complying with the norms specified by the SPCB regarding discharge of effluents into the rivers within their jurisdiction, respective jurisdictions. These secretaries will also remain present online on the next date. We'll call it on Friday at 10:30 a.m.
My lord.
Yeah.
Special weekly daily list. All matter item number 1.
Please allow. But this is challenge to the notification which was issued by the government in the Ministry of Labor regarding the revision of minimum wages. But earlier this matter was heard by this honorable court. The writ petition was allowed. However, the Union of India went in appeal to the Honorable Apex Court. And before I go to the brief, my lord, I'll just read out the order that has been passed by the Honorable Apex Court while reminding the matter. If your lordships would have it on at flag C, if your lordships would. I'm also giving a copy of the order that has been passed so that it will be. Well, the entire issue revolves around one particular expression which has been given. If your lordships would come to page 27 of the brief, then I'll go to that judgment, my lords. Because what is the dispute, if your lordships would know, page 27.
Yes.
Here, my lord, while giving a difference between open cast mining and underground mining, while for the open cast mining, the new provision which has been added, which is under challenge, if your lordships would come to para 7 of that.
Yes.
At page 27. A person working or employed in or in connection with a mine is said to be working or employed below ground if he is working or employed in a shaft which has been in the course of being sunk, or in any excavation which extends below superadjacent ground, or, this third one is under dispute, in an open cast working in which the depth of the excavation measures from its highest to its lowest point exceeds 6 meters. So this only the third, which was added to the definition of below ground, that was challenged. Now I'll take your lordships to the order that has been passed. If I take your lordships to the second page of the order, In the first page, the definition has been given, or the particular provision which has been integrated, that has been quoted. After that, my lord, if your lordships would come to second, that lord, midway, Mr. Dushyant Dave, learned counsel, if you, in response, if your lordships would see in the first paragraph itself, towards the bottom. In response, Mr. Dushyant Dave, if I, your lordships got.
Yes, yes.
In response, Mr. Dave, learned senior counsel appearing for the respondent company, submitted that the classification contained in clauses 1 and 2 of para 7 of the notification do not pose any problem. But clause 3, which was impugned, creates a class of employees which is not recognized under any statute relating to mining activities, and therefore there is no sanctity in the notification so far as that part is concerned. Now, the, my lord, operating portion of the judgment, we find that though the High Court referred to various statutes relating to the mining activities, that is Mining Act, etc., it did not indicate any reason as to why it was of the view that the authority issuing the notification lacked statutory power to issue the notification. Though the judgment runs to several pages, after noticing the rival submissions, the High Court in a very cryptic manner disposed of the writ petition coming to the aforesaid view. It is not the number of pages in a judgment which is relevant, so and so, my lord. Then in the fitness of things, therefore, the High Court should rehear the writ petition and dispose of the same by a reasoned order. We make it clear that we have not expressed any opinion on the merit of the case, and then since the interim order was there, that was lord extended and the matter was remanded back. Now, my lord, I'll just take your lordships to the impugned notification and the sections, and vis-a-vis the section under the Minimum Wages Act under which the notification has been issued. If your lordships would come to page 18,
Yes.
your lordships would see that the notification has been issued in exercise of power of section 3, 4, and 5 of the Minimum Wages Act. In the third paragraph, my lord, now therefore.
Yes.
So I'll just take your lordships to section 3. What is there in section 3?
Yes.
Yes. Fixing of minimum rates of wages. The appropriate government shall, in the manner hereinafter provided, fix the minimum rate of wages payable to employees in an employment specified in part 1 or part 2 of the schedule, and in an employment added to either part by notification under section 27, provided that the appropriate government may, in respect of employees employed in an employment specified in part 2 of the schedule, instead of fixing minimum rate of wages under this clause for the whole state, fix such rates for a part of the state or for any specified class or classes of such employment in the whole state or part thereof. Then, my lord, I'll take just your lordships to, lord, subsection 3. What are the criteria that is to be seen, my lord, or to what extent in fixing or revising minimum rates of wages under this section? The lordships got different minimum rates of wages may be fixed for different scheduled employments, different classes of work in the same scheduled employment. Adults, adolescents, children, apprentices, different localities. Minimum wage rates of wages may be fixed by any one or more of the following wage periods, that is by an hour, by day, by month, or such other large wage period as may be prescribed. Then your lordships may see section 4. Minimum rate of wages. Any minimum rate of wages fixed or revised by the appropriate government in respect of scheduled employment under section 3 may consist of, so what will form the part of the minimum wages that has been explained in section 4. So which has nothing to do with the rate here which has been fixed. But they have relied upon section 5 to exercise that power.
Yeah, tell us one thing.
Yes, my lord.
So these rates that were fixed,
Yes.
you were required to pay how many people and how many employees, and they have not yet got it, or you already paid them under protest? What have you done?
No, my lord. That is because of the stay order.
They didn't get this payment.
Yes, my lord.
So there was a stay of the notification itself.
All over India, my lord, it has been stayed by almost 5.
What are today's CPI index? If you say
No, that payment is being made. My lord, only this differentiation of wages, because those who are working in open cast mines, they are getting whatever their minimum rate is fixed. In below ground, they are getting. This artificial differentiation was only that to that extent it was stayed.
No. So how many employees were working at this level of the?
My lord, if all the entire mining industry would be taken, would be in my lord, the multiple thousands.
No. For a certain period, right?
No, my lords. This is not for a certain period. This has been continued from 94 till date.
You mean they've not revised the rates at all?
No, they have.
So revised rates are also stayed.
No. My lord, they're being paid those rates.
So those revised rates you have no problem paying?
No, we have absolutely no problem paying.
I don't understand.
I'll just explain your lordships. What is the differentiation? What is under challenge? Lord, there are two different categories of mining. One is the open cast mining.
Right.
One is the underground mining.
Correct.
So now in the open cast mining,
some pits are dug.
All the payments are being made, which we are also paying. Everybody is paying. Now, so far as this underground rate is concerned, this underground rate, my lord, if your lordships would look at the definition under the Mines Act, what is the underground and below ground and what is, my lord, open cast, I think that would be.
Before we get into definition and all that, we're looking at 3 levels of work. The open cast people in a pit which has been excavated.
My lord, it is not called a pit, it's called a bench.
Bench, all right. So the height of that topmost depth of the excavation measured from the highest to its lowest exceeds 6 meters.
6 meters.
Let's say 20 feet.
Yes.
6 meters is approximately 20 feet. So there is a trench or a bend or whatever you call it. That height is 20 feet. There are people working there.
Yes.
You have no problems in people working above that? People working
no, my
under
lord,
that?
It is not that way done. I'll just explain if your lordships would look at the region. I have given a picture of the mining, my lord, the working of the mining. That is why, my lord, I said, if your lordships would see, there's a page which is folded. That would be, I think, my lord, annexure 5, internal page 24 of my rejoinder. I think running page would be 93.
Yes, correct.
So, my lord, in every stage or every bench, the height and the width is given, and the approach is through road only.
Right.
And normally in the mines, the more the mining is done, they are taken by vehicle.
Correct.
So the working of at that particular height, because it is at a plane, the bench. So there is no difference between whether 6 meters or 8 meters. Because once the blasting is done, after that, everybody works on that bench only. Right. So irrespective of the height of that particular bench, the working is at the same level.
Okay.
For every workman.
Right.
So now what the differentiation here it makes is, like the moment I blast below 6 meters in a particular bench, then I have to pay a different rate of wages. Now, if somebody is working in the morning, let's say at 5 meters, and then the blasting is done, he does at 6 meters, then he gets a different rate of wages.
What is a different rate? How much more does he get? What does he get per hour or per day?
No, per day.
How
that
much
was
more does he
almost
get per day?
the recommendation, my lord, was 20%, which was accepted by everybody. In fact, during the discussion process before the change was made. But in effect, what has been done, if your lordships would see, The difference is more than 30%. It is almost more similar to what a below ground worker gets.
I've completely lost Mr. Nanda. All right. I must plead my ignorance of my inability to understand in rupees and Naya Paise what you're trying to say.
My lord, it is the difference.
The total bill that you will get, your SL, what are you?
SL mining.
SL mining. Is your bill running into 500 crores, 1,000 crores, 2,000 crores? What is it? Because of this differential wages that you will pay, how many mining workers are there?
That figure, my lord, I don't.
No. You should know something. Suppose I tell you there are 10,000 workers, you will say, sir, it is not that much, or it is too low, it's actually 1 lakh workers.
No, my lord. This applies to all the mines, not only
How
me.
many mines do you have in Orissa?
No, not me only, my lords. There are a number of
You are representing the class action for all mine owners everywhere in Orissa.
Because this was the only case which had, was adjudicated and gone up.
No. Is this case a class action case? No. Let me try and understand. This is a new development then. We've had PIL class action for slum dwellers.
All the mines owners had challenged this notification.
No. Before us are all mine owners there.
No, my lords. Only one.
So we are not supposed to decide for all mine owners. No, we are only supposed to decide for SL mining.
The notification applies to all.
Sorry?
The notification applies to all.
No, but this is like luxury. Then some major mining industry will just ride piggyback on your stay order. That's extraordinary, sir.
No, my lord, that has been.
They will not file a petition here, but because SL mining has got a stay, they will also enjoy a stay.
No, my lord, they are all before your lordships. Those writ petitions are also pending.
Where is it?
Because earlier it was disposed of in line of the earlier judgment which was passed by this honorable.
Before court. Us, are they there or they are not there?
No, as of now they are not there.
So we don't have to worry about them. You don't have to worry.
No, I don't have.
You have to worry about yourself.
Yes, ma'am.
So let us decide your case. You worry about yourself.
Yes, ma'am.
How many workers are working for you? 10,000, 50,000, 1 lakh workers? How many workers?
Roughly will be, if I take, my lord, all the 3 mines which they had. Now, of course, they don't have anything. Because after this change in the mining laws, now the auction process, they don't have a single mines in Orissa. But it will have a retrospective effect because the change is from 94. So that is why the litigation.
So what is your bill, sir? So your bill is 10,000 crores, 20,000 crores.
I'll my lord, give the details of the persons employed.
You want to know the scale of the liability that you are talking of?
Yes, my lord. That I'll give the numbers.
Is it in thousands of crores?
My lord, might be over a period of time would be in thousands.
What is the period of time?
My lord, from 80,
as far as I understand,
94
minimum wages fixed in 94 cannot be the minimum wages in 2022. So this is I don't have to be Sherlock Holmes to know this.
No, my lord, that I also admit.
So 1994 minimum wages would have been revised in 1995, would have been revised in 1996.
Every year it is revised.
And unless you challenge each of those revisions, we are only dealing with one revision of one notification for 1994.
No, my lord, that is where, my lord, the difference of opinion is because we are not dealing with the revision, my lord. It is the categorization. The revision is already paid.
No, even the categorization, sir, you've got a stay of one notification for one period for that categorization.
If your lordship should just look at the order passed by the Honorable Apex Court, I'll just read that. I think. Lord, after the portion of the order where it said that the High Court should rehear, then.
Oh, it only says there is a further notification of 3/1/2002 and the High Court should consider that also.
The same notification. Similar lines.
No. A notification containing similar stipulation has been issued. Which you have not challenged.
No, that is I have brought on record.
What is that bringing on record? I mean, doesn't mean bringing on record means you've challenged it. You have not challenged it. You have challenged before us. This is a 1994 writ petition. You have challenged a 1994 notification.
Yes, my lord.
Which in 2005, the Supreme Court has sent back to us to reconsider.
If your lordship should just see my additional affidavit, which I have brought on record, there I have specifically mentioned.
All right. Let's see that.
That is Lord dated 12/8/2019. at flag D.
So this SL Mining and Industries Limited is right now operational or not operational?
The company is existing, it doesn't have any mines in Orissa as on date.
So even if you lose this litigation, you'll end up paying nothing.
No, my lord, I have to pay.
What will you have to pay and
My lord, I have
how do we ensure you pay?
No, my lord, that I have to work out and that has to be
No,
given
no.
because all are, my
Let's
lord,
not have a luxury. No, let's be
registered
serious.
employees.
Let's not have a luxury litigation.
No, my lord,
I just want to understand something.
Yes, ma'am.
This is going to be a 30-year-old case very soon. The workers who are supposed to get this differential wages have not got it because you got to stay. What is the total tab? What is the bill? Suppose you lose the case, how much will you end up paying? Where are the workers to whom you have to pay? And do you have the money to pay?
Lord,
you answer these three questions now.
Lord,
They're not proceeding with this. No, they're not proceeding with this. It can't be that we dismiss your writ petition with one lengthy judgment. Nobody ends up getting paid anything.
No, my lord, I'll just, my lord, to that extent, I'll give the entire figures if your lordships will grant me 7 days time. Your lordships may keep it.
No, but let's be very clear. Let's be very clear. We are not here deciding one whole case, at the end of which the worker who's supposed to get some money gets nothing.
No, they have
because you turn around and say that worker is dead, gone, untraceable.
No,
so I cannot say.
It cannot be because they are all registered workers and with all their accounts and every details with.
Sir, if it was that worker was 50 years old when you filed this litigation, you got to stay. What is his age today?
My lord, if he is not there, his legal age might.
Do we know that? Do you have records? Do you have the money, sir? First of all, do you have the money?
Lord, I'll find out. Your lordships may keep
no,
it
we
Monday.
Can't have a luxury litigation, sir. If at the end of all this, you'll say, throw up your hands and say, I'm supposed to simply argue a case because Supreme Court has sent it back. But even if I lose this case, I have to pay nothing.
No, my lord, that is
so
not,
it's like
otherwise I would have withdrawn, my lord.
Heads up
in that case, I would have withdrawn.
No,
because
heads up
they don't have the money, so I would have
we
withdrawn
don't have figures. So it becomes heads up and tails you lose.
My lord, I'll give the figures, my lord, before your lordships.
Actual work, this is our wages fixed by the hour, or let's see that impute notification you're showing us.
Yes, on day basis.
Day basis. So above ground was 9 paise per hour.
No, my lord. That is special allowance if your lordships are
Achha. The above one is 28 rupees. That one.
Yes, my lord.
So above ground is 28, below ground is 34. Correct?
Yes, ma'am.
Now, how does it change?
Lord, the below ground is a completely different kind of work where it is done underground, like in a coal mines or a coal pit and everything. Lord, that is the below ground.
So the difference between above and below for an unskilled is 6 rupees. For a
about 20 to 20, within the range of 20 to 25%.
Forget percent, sir. Actual rupees, it's some 6 rupees if you're unskilled. If it is 7 rupees if you're semi-skilled. It's 9 rupees if you're skilled. Clerical people get the same. Highly skilled gets 40 rupees more, is it? What is that? That typing is not very clear.
Highly skilled again, my lord, would be about
10 rupees more.
10
so
rupees,
the scale of difference between underground and above ground is between 7 and 10.
Yes, my lord.
what does it actually work out to, sir? Paying somebody more, 7 rupees more per day. Per day.
My lord,
I mean, I'm appalled. I didn't know it was so low. Honestly,
no, my
I mean,
lord,
I may be completely.
because during those period of the
No,
days,
no.
the
Whatever. I have
prices
also
were
grown up.
completely different.
In 1994, somebody told me to work in a underground mine. You're going to get this princely sum of 35 rupees a day. In 1994 also, I would have balked.
My lord, that is the
Do we know
difference.
what the risk is? You've seen all those accidents, right?
No, my lord, in fact, I had the privilege of seeing both the underground as well as the open
No,
cast
you would
mining.
have. I'm just
physically
saying those
with-
accidents that we've had and continue to have. What is 35 rupees even in 1994?
No, that is
What
for the
35
below
rupees
ground,
a
my
day?
lord. Below ground, there is absolutely no dispute.
No,
here.
you don't want to pay. You're saying these fellows are working in that shaft.
Open cast, they are not working
So we
below
should treat
ground.
them as the same as the above
Below
ground and
ground.
not below ground. I'm saying, what does it entail? Which means you're going to pay these people working in those benches 6 rupees more, 7 rupees more, or maximum 10 rupees more per day.
My lord, when it counts to thousands and over a period of years,
That is the point. That is the point. See, this stay you invited upon yourself, right? The stay is something that you invited upon yourself, undertaking the risk that even 30 years later, if I lose the litigation, I have to pay this money.
yes, my lord.
So today it will work out to some big sum, which you will now turn around and say, sir, I am not operational. I cannot pay. So you have won both ways.
My lord, I challenged it.
You have
I
already
got
won both ways.
the order. I got the order from this honorable court only when
Correct,
it
correct.
was allowed.
Correct, sir. Ultimately, it comes on us. We are responsible for everything. I'm just look at the justice of this whole situation.
My lord, holistically looking, that's a different issue. But so far as the
No.
legal aspect is
The writ
concerned,
petition allowed, you win. You go back smiling. But if the writ petition is dismissed, also you go back smiling.
no, my lord, that won't be the case. That is the only. Otherwise, I would have withdrawn it. Or rather, I would rather now even suggest my client.
No,
that
we
withdraw
don't do
it
it. See,
because there
today's stay orders, we create an escrow. We say you better deposit the differential amount into that. You've not even done that, sir. So that money is lost. Interest on it is lost.
there was
And
no-
you have gained. By withholding this 10 rupees from every worker, you've earned on that
my lord, if
for
it is-
all these years.
my lord, on the other way around, if it is illegal, then also.
What is illegal, sir? Somebody who goes 100, 200 feet
No,
down
no,
under
I'm
the
not on the
ground.
amount. I'm on the issue of the legality of that notification.
I know, all that is fine, sir. I'm just saying a stay order should have compelled you to deposit at least a differential amount into an account. That was the least.
My lord, I won the litigation, then the matter went to Supreme Court, then it was remanded back, where the interim order was also continued.
Why can't we now require you to put that differential amount in an account? If we want to continue to hear you now. At least now we should do it. I don't want a situation. Really, we should be conscious as a court what we are doing. Suppose you lose this litigation, those workers end up getting nothing. What is the justice of the situation?
My lord, the workers have got, after the subsequent notifications, everybody has got it, and the notification has continued. Last notification, that's why I said, my lord, I have filed of 2017. But the same clause remains and they have been paid.
So you don't have any problem paying for the subsequent notifications. Only
Because-
this 94
no, because that
notifications
was-
somehow hurting you.
My lord, that was the challenge that time made.
No. What is the logic to this, sir? All the subsequent notifications you have paid. You've had no problem.
No, because we had no choice, my lord, because that was brought
Why you
into
could have
the central
kept on
government
filing
into
writ
the part
petitions?
of the, part
No,
of
you
the
could have
mining
kept on
agreement
filing writ-
itself.
Huh?
That issue was brought into the mining agreement itself. So for that reason, that's why,
Then
my lord,
why don't you graciously give up this? All subsequent years you've paid, only 94, you have to make a principle of it.
I'll, my lord, take instruction if they want to withdraw.
That's
then
right.
All right.
So the condition is this, sir. If you want to continue fighting this litigation, the entire differential amount, and we'll add some 6% simple interest on it. You calculate it for 94, we'll add 6% interest, you place it in escrow account. Then we'll hear you.
All right. I'll accordingly.
All right. Mr. Nanda states that he will seek instructions on whether the petitioner wants to persist with the present petition.
Let them, if they file that copy may be served. I don't have that copy.
Sorry.
Additional affidavit they have filed, regender and additional affidavit who don't have a copy. I request my Mr. Nanda to serve a copy to them.
So the better thing, Mr. Pari, I'll ask him to do that. Better thing is if you send a pen drive to our registry, they'll give you a soft copy.
Then it is very more helpful to me. I will do this. Yes.
Ah, free. You're getting it free.
I will- It is very
All right.
helpful.
All right. It will be open to Mr. Pari, learned ASGI, to collect a soft copy of the entire paper book
Obliged, man.
on a pen drive from the registry.
Otherwise also I'll serve, my lord. Otherwise also I'll give it.
So next Monday or what? When do you want it? You tell us.
Your lordship
Because it's a
can-
94 case, let's not have too long a date.
In the third week of April, if your lordships can fix it to the week commencing, my lord, 18th.
But you'll bring all those figures. If you're persisting with the
Yes.
petition, you have to bring
That-
those
That
figures.
is the reason why if they want to persist, then otherwise, my lord, if withdrawal, then also there will be
Nothing, not
So-
much. 18th April.
18th.
the prayer of the petitioners are premature. Besides, to say that the individual claim of the petitioners will be taken into consideration by the competent authority in consequence with the provision of enlarged in the Land Acquisition Act. Further, it goes without saying that the value of the structure standing on the acquired land will be assessed and proper compensation will be paid to the real landowners. They have admitted that. And it is pertinent to mention here that these matters will be taken into consideration and receipt of the petition objections pertaining to such apprehension. Further, with regards to the petition apprehension regarding payment of compensation amount to other persons who are not real landowners, this deponent will humbly submit that the compensation amount will be paid to the land lessors after taking into consideration their title, record, rights, as well as their possession. In this premises, the petitioners ascertain embodied in the writ petition regarding issuance of revised notification in view of the consolidation operation are grossly misconceived. So, my lord, my grievance is that they have mentioned that. They have also admitted that if in case, my lord, they will give compensation as per the consolidation check, then, my lord, the Sabik plot has been changed in the possession also be given to some other persons. So, my lord, suppose, my lord, one person has a dwelling house or a lift irrigation construction is there, and it has been allotted in the consolidation to some other person, so that the actual.
I'm not able to understand anything, sir. I'm pleading my complete ignorance. As far as I know, if there's a Land Acquisition Act notification under Section 4, it will be followed by a Section 6, then there'll be an award. Has these three things happened or not?
Now, my lord,
no, just educate me, sir. I told you I'm completely ignorant. All right. If there's a Section 4 notification, it will be followed by a Section 6 declaration, and it will be followed by an award. Have these three steps been completed?
As only revealed from the counter, it has not been completed even.
So then you want to withdraw this writ petition if it has not been completed?
Because now they are saying that
whatever they are saying, let them be. What are your facts, sir? What facts do you know about your case?
We have not got our compensation, even though.
Sir, what have you found out? You are not talking like the petitioners. I am asking Mr. Jena, the lawyer, who knows the law, who knows the Land Acquisition Act.
So far, my submission in this writ application, my lord, my prayer is that.
Sir, I did not ask you what your prayer is. I've asked you the three steps which is there in every land acquisition case. Have those three steps been crossed in this case?
Actually, it has been already crossed, and they have taken and the
land. No, what is the date of the award, sir?
Date of the award, my lord.
Where have you pleaded that this is the award? This award contains my name. This award specifies this compensation against my name.
That was in the year 2001. That was not there, and they have not mentioned anything. This is the writ application of the year 2001. At that time, it was not there. At that time, when they have taken a decision to.
So, how can you ask for compensation even without there being a land acquisition award?
No, we have given our after the land has been acquired. They have given.
What is the meaning of acquired, sir?
There is a
what is the meaning of acquired?
My lord, as per Annexure 1, my lord, the notification was made on 23/12/2000.
Under what act?
On the Land Acquisition Act, my lord.
Under what provision, sir?
That was act under Section 4 of the Act.
What should happen after that?
Thereafter, my lord, we have given our objection.
No. Is an acquisition complete by only a Section 4 notification, sir?
No, ma'am.
What should happen?
But thereafter, my lord, we have provided our objection as per the notification.
All right. After that, what should happen, sir?
My lord, we have given our objection. My lord, we have given our objection that the land, the proper compensation should be given as per our Sabik land, not as per the Consolidation Act.
Sir, when you're objecting to a Section 4, you're not talking about compensation, sir. What is your objection under Section 5, capital A? What will your objection be?
Objection might be given that our land we should be given our compensation as per the.
Sir, that won't be the objection, sir.
That
will not be the objection. When the Section 4 notification is issued, is compensation already determined?
No.
That may not. That I cannot say.
You cannot say. I can tell you.
My lord, he.
When a section 4 notification is issued, no compensation is determined at that stage.
No, that's not.
Huh.
But
My
there-
lord,
If you do
directly
not
and-
mind, if you do not mind, can I explain how the Land Taxation Act works, or you are already very well versed about it? Then I will not waste my breath.
No, I don't know.
You do not know how the Land Acquisition Act works.
No, that basically, no, but the grievance of the petitioner. is
1 minute,
something
sir.
else.
Let us go step by step. Are you in a hurry or something?
No, no, man. Not that.
Okay. How does it, the Land Acquisition Act work? Step by step, you tell me, sir.
There was a notification to notification and thereafter. my
So
lord,
you give us the dates. Section 4, there must have been on a certain date
Under annex 1, that is 23/12/2000 is the notification.
of section 4.
My lord.
At that stage, is compensation determined, sir?
No,
No. What will happen after section 4?
my lord, we have given our objection.
Under which section?
Objection. No, it will be under annex 2, we have provided our objection, but which section I can,
So do you have the barrack?
I have not.
We'll give you the barrack notes.
There is a stage, section 11, where the award is to be passed.
1 minute, sir. You are still jumping. We are still in section 5,
Section
capital A.
6 is there, section
Yes,
5
section
is
5,
there.
capital A, sir. Please give it to me. Please turn to section 5, capital A, sir.
My lord.
Give me a copy.
With regards to the publication of 5, my lord, hearing of objection. 5A is the hearing of objection. Any person interested in any land which has been notified under section 4 subsection 1 as being needed or likely to be needed for a public purpose for a company may within 30 days from the date of publication of the notification object to the acquisition of the land or any land in the locality as the case may be.
So what is the objection? The objection will be, sir, please do not take my land. Please take some other land. That will be the objection.
No, my
At this stage, sir, at this stage, nobody knows how much they're going to get for the land.
my lord.
The only objection they will say is, this is not a public purpose. Or the second objection is, okay, if it is for the public purpose, do not take my land. It's all happened. Some people will say, this is very rich land, sir. You do not need this land. Change the alignment.
My lord.
So the objection at section 5A stage is not about the compensation. Please do not mix up.
Yes, yes. my
They have
lord.
not even reached that stage of compensation yet. Compensation will be determined after section 6 declaration.
Yes.
Section 6 declaration says, yes, we need this land for a
Which
public
purpose?
purpose.
Exactly, my lord.
Correct?
Yes, ma'am.
So at least we are in agreement on that.
Yes, yes. ma'am.
Very good.
The section
Then comes section 11.
my lord. Section 6, my lord, which land they will acquire, they will decide. And section 11, my lord.
So
Section,
when did section 6 declaration happen, sir, in your case?
Lord, I have a small submission. Subject to Lordship approval. Lord, this land has been acquired under National Highways Act.
All right, we go same procedure only there also. National Highways Act.
3A, the notification.
When I asked him, he said it's section 4. He
Yes.
said it's Land Acquisition Act. You're so confident of that. When I asked you which notification under what section, which act, you said Land Acquisition Act.
because I have taken that point in the petition.
Without even seeing the notification is not under that act.
Yes, Lord. That is under Annexure 1.
Annexure 1, your Lordship may kindly.
Annexure 1 is the notification.
Do you have the NH Act with you or should we give you a copy? You do not have that also, sir, I'm sure.
No, I have not. got it.
All right.
Here,
Now come to the NH Act.
The capital N.
Parallel provisions you have there also.
my lord.
If you have a section 4, you have a parallel provision there.
3 capital A.
3A, my lord, the notification is issued, my lord. Then
5A, the parallel is 3C.
3C is hearing objection.
Then section 6 parallel is 3D.
3D.
My lord.
What's the date of the 3D notification?
The annexure 1, it will reveal that the notification, that is 23/12/2000 is the notification for the expansion of on Baleshwar Lakshmanath Road.
Give me the date of the
20
declaration under section 3D. Date of declaration under section 3D, sir.
Under annexure 1, it has been mentioned that letter of 17/3/2001.
This is 3A.
Yes. The notification is, that is mentioned that the notification dated 23/12/2000, my lord. As will reveal.
Sir, I'll just repeat the question.
My lord.
Is this a section 3D declaration?
Now, this is notification section 3A.
Now I'll repeat the question for the third time, sir.
My lord.
What is the date of the section 3D declaration?
That is not there. It is not available.
All right. Are you aware that there is such a declaration, sir?
Yes, my lord.
You are clear.
The villagers are aware and they have.
Which paragraph have they aware that there's a section 3D declaration?
Not mentioned with regards to that section.
Nothing is mentioned.
No, that has not been mentioned. However, my lord, it has been mentioned that after the land acquisition was there.
No, there's no acquisition yet, sir. You are going far ahead of where I am. A mere declaration will not complete the acquisition, sir.
My lord.
What should happen after the declaration?
They will acquire the land, my lord.
No, sir. They will pass an award.
3G. If your lordship will give me some time, then I will.
You're not familiar with the branches of law?
No.
You're new to this branch, sir?
I will prepare the note, my lord. Because
No. These facts are important, sir.
Yes. This is important.
We won't keep adjourning for these things because he's waiting to tell us the facts.
Yes,
because you are the petitioner, we thought we should hear you first.
What happened, my lord? This is a old transfer brief, and immediately I came to know that this. So, my lord, if your lordship will give me some time, so that I can prepare.
We are not giving you adjournment, sir. We have already spent some 20 minutes trying to hear the matter.
True. But immediately.
Then it's better you take your seat. We'll get all the facts from the other side.
Yes,
all right.
Okay.
Yes, Mr. Das.
Lord, in 2010, 2001, Lord, the notification was issued under section 3A.
Yes.
And subsequent, I have also given another paper, Lord. The correspondence I have received in the year of 2019. Lordship will see that the amount has already been paid. The compensation amount has already been paid to all those petitioners. Since my learned senior has entered appearance in the year 2021, probably that fact has not been brought to his knowledge. But my lord, here the only issue that my learned senior is raising, that when the advertisement, when the acquisition notification was issued, the Sabik plots, the identification, the lands were not the plots which are marked as Sabik plots, Lord. Those Sabik plots were not included in the notification. Rather, the HAL plots are being included. And that is why the problem, what my learned senior was saying, that those persons who have actually held the property prior to the settlement, some of their names might not have been included. But my lord, in our counter, as well as in that paper, my lord, I have also shared that paper with my learned senior. We have stated that in between the settlement proceeding, my lord, from Sabik plots to HAL plots, my lord, there is one proceeding, there is one proceeding in which the plots are marked as land registered plots, and the land registered plots which corresponds to annexure 5, the plots which have been erected, the petitioners' plots are there. The plots owned by the petitioners are called are also included under annexure 5. Those have been included in that land registered plots, and compensation have been paid according to the land registered plots in pursuance to the annexure 5.
Mr. Das, appearing for the opposite parties, has placed before the court a letter dated 13/2/2018 of the Tahsildar Basta, stating inter alia that payment of compensation on the basis of the land register plots have already been paid to the landowners, which has been mentioned in Annexure 5 of the writ petition as Sabik plots. Full stop. In that view of the matter, it is stated that no fresh notification is required for acquisition of such SABIC plots. So no further directions are called for as far as the present petition is concerned. It's disposed of.
If they have paid as per the SABIC, then we have no objection because we have also paid for that. Just now they have saw the copy. I don't know what is the
Weekly daily list item number 3.
Paltry amount.
Alright,
14,000.
the amount involved is insubstantial. Petition is disposed of. The
Item-
tax amount involved.
Question of law may be okay.
Yeah, the question of law is left open for decision in appropriate.
On item number 7. that is
What about 4, sir?
Well, item
Item
number 4, but that is 62,000, but I don't have the.
Yeah. You say the amount involved is not insubstantial. The question of law is left open. Then 5,
My lord, no instruction.
no instructions.
My lord,
disposed of.
item 10 also no instruction.
All right, 5 and 10, no instructions. 6, what do you say,
Item
sir?
number 6.
Your Lordship, 6, 7, 8, all these are defects and those defects have not been removed by my predecessor.
None of the defects have been removed. Despite the pendency of these petitions for over 15 years, dismissed for non-constitutional.
Item 9.
Item 9, I have no instruction.
No instructions, disposed of.
Special weekly list item number 11.
May I please, my lords? Your lordship may kindly see the paper book. The question framed, my lords. Your lordship will find at page 9, my lords. That's
Yes.
page 9, yes. Whether in the facts and circumstances of the case, purchase tax is leviable on equivalent paddy, out of which rice obtained and sold to project directors, World Food Program, which is exempted as per entry 30 HH of list A of the schedule of rate of tax under the OST Act. 2, whether in the facts and circumstances of the case, rice, which is a notified first point goods, being exempted by notification under section 6 of the OST Act under entry 30 HH of list A, whether paddy used as input is subject levy of purchase tax. 3, whether in the facts and circumstances of the case, levy of interest under 12(4)(a) of the OST Act lawful. That's in order to consider this question, my lords, there are certain relevant provisions I will like to bring to lordship's notice, my lords.
What is the tax effect here, sir?
3 lakhs amount, my lords. That's this paddy, my lords, unlike other items, this is subject to levy of purchase tax under section 3B of the OST Act. The source of legislation, as your lordship knows, for levy of tax, the state legislature is entry 54. Entry 54 precisely speaks levy of tax on purchase or sales other than newspaper subject to entry 92 of list 1. That is precisely what 54 speaks. It can be on levy of tax on sale or purchase. Because here the subject matter is levy of tax on purchase as per section 3B. So before I take your lordship's attention to that, 3B provides that if you are paying tax on purchases, section 3B, your lordship kindly. 3B. Goods liable to purchase tax. The state government may from time to time by notification declare any goods or class of goods to be liable to tax on turnover of purchases, provided that no tax shall be payable on sale of such goods or class of goods declared under this section. So there must be a notification in order that the goods will be subject to levy of tax and purchase. There is a notification and there is a list of, if you also will see the OST Act, there is a list of items which are subject to purchase tax. Those are there, you will also find before rate of tax on different chapter 2, list of goods liable to tax and minors. You will also kindly see item number 15, paddy. Serial number 15, paddy. It starts from serial number 1, broomsticks.
No, this is the schedule or?
There is a schedule of tax and purchases. Nomenclatures, list of goods liable to tax and purchase turnover. SRO number 206/82. May I pass on this book?
Yes. Is that rate chart?
Red chart is for before that. Red chart is for taxable sales.
No, all are also in the rate chart. All are also in the rate chart. Rate chart भी अच्छी.
Oh, see, that is different. Again, purchase the
अच्छा.
This is so provision, relevant provision. Serial number 15 minus.
Right.
Minus.
Paddy, 4%.
Then in the rate chart, also your lordship may kindly see rate of tax on rice. That is entry 149. 149 dollars. Serial number 149. Rice including broken rice.
Right.
Minus. That says that rate of tax is 4% and any tax paid on paddy shall be set up, adjusted.
Right.
Means the differential one has to pay.
Right.
Now, my humble submission before lordship is this paddy, which your lordship is considering, that is, may not say goods of special importance. May not covered under section 14 of the Central Sales Tax Act and under Article 286 of the Constitution, some restrictions are being imposed on the power of the state legislature to levy tax on paddy millers. Your lordship may kindly see what are the restrictions. When we see this item millers, Article 286, 3. Article 286, 3 millers.
Yes.
Millers, any law of a state shall, in so far as it imposes or authorizes the imposition of a tax on sale or purchase of goods declared by Parliament by law to be of special importance in interstate trade or commerce, or a tax on the sale or purchase of goods being a tax of the nature referred to in subclause B of subclause C of subclause D of 29 of 366, be subject to such restrictions and conditions in regard to the system of levy, rates, and other incidents of tax as Parliament may by law specify. But the restrictions imposed by the Parliament under section 14 and 15 mirrors. 14, if your lordship will see the Central Sales Tax Act mirrors, section 14.
Goods of declared goods.
Yes, declared goods. Certain goods to be of special importance in interstate trade and commerce, but this is declared to be a goods of special importance.
Paddy is part of it.
My lord. 14.1 paddy and 2 rice. Section 14.1 paddy and 2 is rice millers. Then 15, section 15. Restrictions and conditions in regard to tax on sale or purchase of declared goods within a state. Within a state. Every sales tax law of a state, shall, in so far as it imposes or authorizes imposition of tax on the sale or purchase of declared goods, be subject to the following restrictions and conditions, namely, A, the tax payable under that law in respect of any sale or purchase of such goods inside the state shall not exceed 5%. It has been mentioned it is 4% because 5% came later. Your lordship, the period is concerned, it is 4% then. 4% of sale or purchase price thereof. That law means that's the OST Act. Then B, where a tax has been levied under that law in respect of the sale or purchase inside the state of any declared goods and such goods are sold in the course of interstate commerce, and tax has been paid under this act in respect of the sale of such goods in the course of interstate commerce, the tax levied under such law shall be reimbursed to the person making such sale in the course of interstate trade or commerce in such manner and subject to such conditions as being provided in any law in force in that state. Then C, where a tax has been levied under that law in respect of the sale or purchase inside the state of any paddy referred to in clause 1 of section 14, the tax leviable on rice procured out of such paddy shall be reduced by the amount of tax levied on such paddy. CA is important, where a tax on sale or purchase of paddy referred to in subclause 1 of clause 1 of section 14 is leviable under that law, and the rice procured out of such paddy is exported out of India, then for the purpose of subsection 3 of section 5, the paddy and rice shall be treated as single commodity. That's the D, your lordship, is the pulses section. No, this is not. So, mirrors, the purport of this provision, section 14 read with section 15, mirrors, the state has power not to levy tax in excess of 4%, that is one, and not at more than 1 point, that will be 1 point. Second, mirrors, in case of the tax, if it is paid on paddy and put to interstate sales, the levy of tax on paddy shall be reimbursed in the manner provided. And in case of export millers, the provision says that that is to be there will be no levy of tax where the goods are put in course of export. But in this case, the findings of the tribunal, if your lordship may kindly turn to the findings, that is page 27, internal page 4 millers. Yes, I am extremely sorry. One point I omitted to make a mention. There is a list of goods subject to first point levy of tax bills. That is also very important. Section 8 of the Orissa Sales Tax Act provides the point. Because it can be either on the first point in the state or in the subsequent point. And that is applicable both for purchase and sales bills in terms of entry 54. Here bills, there is no that is rule 93D, as per which this paddy, rice and broken rice are exigible to tax at the first point. Rice and broken rice is to be first of sales affected.
Tax on sale, that's not.
No,
tax on sale.
No, I am explaining. Please. So now, my lords, so far as the paddy is concerned, under section 8, there is no notification. Rather, the provision itself is self-sufficient to refer to find out what is the point, millers. Because so far as paddy is concerned, it says that paddy is only a notification when declared, that is subject to levy of tax on purchases. And if purchase tax is paid, there will be no tax on sales. But there is no point fixed, millers. But there are notifications, millers. Let me clear on this, millers, which says, supposing goods are coming from outside the state, whereas the buyer in the state, he is not the first purchaser. So therefore, the point fixed, I am somewhere missing, I will refer to that. So, yes, that says that when the subsequent purchaser will purchase from the person importing goods from outside the state, he will be the first purchaser. Because the person getting the goods, purchasing goods from outside the state is not the first purchaser inside the state. So therefore, the first purchase effect, supposing paddy I am importing from Kolkata, I am not the first purchaser. Person who will purchase from me under section 3B, he will be first in the library. Now, millers, you also may kindly see the findings of tribunal, page 27, paragraph 4.
No, actually, the facts are not clear. What are the facts here?
Yes. Fact is, you will also kindly see what is the main point of dispute account tribunal. We have heard both the parties at length, gone through the orders and fora below, and the materials have a record. We have also gone through the grounds of appeal, written submission filed by the advocate. Main point of dispute revolves around 5 points. Your lordship is concerned only on point number 1 and 4. Levy of purchase tax on paddy, out of which rice obtained and supplied to project director, World Food Program, sales tax on which has been exempted as per entry 30HH of list A of the red chart. Then 4, interest charged under section 12(4) of the West Act. Now, precise fact, I am only putting in 2-3 sentences, milords. Because here, I have I own a rice mill. Because I purchased paddy, converted to rice, and for the period in question, I have supplied under this World Health Program, constituting turnover of 30 lakhs somewhat, belongs to the forest department according to 30 HS belongs the relevant entry. If the rice is belongs purchased for the purpose of use in belongs activities in forest notified activities in forest department or Odisha Forest Corporation, and subject to giving a certificate by the competent issued by the competent authority, then the exemption is made available. That is no denying the fact that my entitlement to 30 HS is in dispute. Department accepts. That part is clear. That I am entitled to exemption in respect of rice which I have sold after converting from paddy to the forest department based on certification. So that part is clear. Now my claim in this case is that when the rice sold is exempted as per 30 HS, because the paddy from which I have converted is not liable to purchase tax. Because rice is not grown in the field. Because what is grown in the field is paddy. And after dehusking rice, this rice is sold. So therefore, if rice, otherwise, supposing you had this exemption not available at all, supposing 30 double H, you will also kindly think for a moment, is not available. Then also, if tax is paid on paddy, on purchases, then there will be no tax on sale of rice.
No, there will be a set-off.
Balance. Only
There will be a set-off.
There is a set-off, yes. No, the set-off, that is, even the statute says that there will be no sale.
No.
Entry says set-off. But your Lordship may kindly reread section 3B that if you are paying tax on purchases, then there will be no tax on sales in respect of that goods which is declared under section 3B. Whereas 3B, once again I am reading.
No, but what you're buying is paddy, what you're selling is rice.
Rice.
So that section 3B will not strictly apply. It's not the same commodity anymore. Paddy is different from rice, right?
Paddy is different from rice. Now the question is, when I am purchasing paddy and selling rice which is exempted, am I liable to pay tax on paddy? That's the precise question. In terms of section 14, 15, 18.
Why not? Why can't you pay purchase tax on paddy? You're anyway getting the exemption. It's getting it set off.
Only for the balance payment, he is getting exemption. He will get exemption. Because the statute is very clear.
Question of balance payment income, when the rice is, I will be selling rice as taxable sale. But here, under 30 HH, I am selling rice as exempted sales. Because 30 HH, probably you also have read, yes. 30 HH in that book. 30 exempt, not a taxable sale, it is an exempted sale. In that book, it is there, which I gave to lots of mirrors.
In the tax-free schedule.
30 HS of the tax-free schedule. Yes. Under the World Food Program, your Lordship will find out. In judgment, yeah.
That's free.
And I have come across with a judgment of our High Court way back in 6.
So what prevents you from paying purchase tax? I don't understand.
Because essentially, I will not get any exemption. My Lord's knows there's paddy. Your Lordship, kindly imagine the situation. Paddy I am purchasing, converting rice. Rice is exempted, but paddy is taxable. Same thing, Lords. Otherwise, supposing had this exemption not been available, I would have been availing the benefit of setup.
But you will be passing it on anyway.
I cannot pass on either, because to whom I am selling, he gives me a certificate to avail exemption.
No, only exemption. He's paying for the paddy. He's paying for the rice.
He's paying only
without any tax. A small example I may be permitted.
You are selling food grains to the World Food Program.
Yes.
Your sale price will include the purchase tax that you've had to pay. I'm saying you'll build it, that component you'll build it into your pricing of the paddy.
That also.
Pricing of the rice. I'm sure you do. Come on.
That also.
Of course you do. Nobody's going to sell it without accounting for that, whatever you've incurred as purchase tax.
Because that is also may not be permissible. Because one
example.
Let me complete. One paragraph I am placing here. Our High Court judgment. Yes, you also kindly see Dhirendranath Das case.
Right.
In 1964, 1916, decided on 1969, paragraph 6 belows. This question has arisen then. What Mr. Bhattacharya, paragraph 6 minutes.
Yes.
What Mr. Bhattacharya wants to contend is that if the sale of the fish, that is a case of fish, which is also liable to purchase tax under 3B, sale of the fish by the assessee in the aforesaid case in Calcutta could not be taxed, then the purchase of the fish inside Orissa for exporting them to Calcutta for sale cannot be taxed by virtue of section 3B of the. For reasons challenged by me, this contents has no force. The language of section 3B is clear, and unless there is any ban, either in the Constitution or the Central Sales Tax Act, tax is leviable inside Orissa on the purchases of fish made by the assessee. All the assessing authorities held that the petitioner was a buyer of fish from the fisherman and was not a commission agent, as claimed by him. On such a finding, purchase tax is leviable and section 3B doesn't stand in the way. So therefore, only they say that had there been any ban, now your lordship, there is a constitutional ban under Article 286.
No.
No, I couldn't find any other judgment because.
All right. Although the present revision petition was admitted on 17 July 2008, no question of law was framed at that stage.
But 12(4)(a), your lordship may kindly consider, that's a penal interest. Unless somebody, the language is, if somebody knowingly furnishes incorrect return, then only. This is a penal interest. And that is to be calculated for 90 days. You can't be calculated for whole year. 12(a), before your lordship notes.
Withheld of admitted.
What is the interest amount must be insignificant, sir.
19,000. 17,000.
Nothing, sir. The interest amount is nothing. Following questions are urged consideration by the assessee in the present petition. Take from para 8, page 9 and 10. 3 questions. As far as questions 1 and 2 are concerned, bracket Roman small 1 of the Central Sales Tax Act 1956, read with Article 286 bracket 3 of the Constitution of India. And read with Section 3 capital B of the Orissa Sales Tax Act 1947. No purchase tax as such is leviable on the purchase of paddy. He points out that paddy is converted to rice by the petitioner. And for the purpose of the present case, it's the sales by the petitioner of rice to the World Food Program. Is under consideration. Full stop. Under entry 30HH of the tax-free list appended to the OST Act, such sales are wholly exempt from sales tax against a certificate to be furnished by an officer duly authorized by the Forest Department. The short question that he seeks to raise, therefore, is if the made from the paddy is itself exempt from sales tax, then correspondingly the tax on purchase of the paddy should also be exempt. Paragraph. Section 3B of the OST Act reads as under. Reproduce Section 3 capital B. The state government has admittedly issued a notification under section B, 3B, subjecting paddy to 4% purchase tax. Full stop. Entry 149 of the
Entry 15. 15 tax on purchase paddy.
no, purchase, yeah.
Mal.
Entry 149 of the rate list appended to the OST Act specifies 4% tax on the sales of rice, permitting set-off of the purchase tax paid on paddy against such sales. So, however, in the present case, the sales to the World Food Program project falling under section entry 30HH of the tax-free list, no such exemption would be available to the petitioner. Paragraph.
The
Mr.
exemption
Sahu,
is not in dispute, my lord. I'm
Sorry?
sorry. The exemption is not in dispute that they have allowed. Exemption under 30HH is allowed, my lords.
that's right.
Yes.
Yeah. Paragraph. The above argument does not impress the court, namely that because rice sold to the WFP is exempt from sales tax, correspondingly the paddy purchased by the petitioner should also be exempt from purchase tax. Full stop. There is no complete ban on the imposition of purchase tax. And in fact, section 3 capital B expressly permits levy of purchase tax on classes of goods. The proviso only states that no tax shall be payable on the single quote sales of such goods. Declared under this section. Unquote. Mr. Sahu drew the attention of the court to the following observations. In Dhirendranath Das vs. State of Orissa, 1970, 26 STC 522. The above passage, in fact, reinforces the view that section 3 capital B of the OST Act permits the levy of purchase tax on paddy, notwithstanding that the rice prepared from such paddy is itself exempt from sales tax. Paragraph. The view taken by the tribunal in the present case, which is in favor of the revenue of the department and against the SSC, does not appear to suffer from any illegality. Consequently, question 1 is answered likewise, that is in favor of the department and against the revenue. The holding that purchase tax is indeed levied on the equivalent paddy out of which rice is sold to the WFP, which sales may be exempt under entry 30HH of this A of the schedule of rates and the OST Act. It also therefore answers question 2. Namely that even though rice may be a notified first point goods being exempted by notification under section 6 of the OST Act, equal paddy must still be amenable, exigible to purchase tax at 4%. As far as question 3 is concerned, the amount involved being insubstantial, the court leaves the question open for consideration in some other appropriate case. The revision petition is disposed of labour.
Special weekly list item number 12. Special weekly list item number 13.
And for the opposite party, 12.
None appears dismissed in opposition.
Special weekly list item number 14. May I please the person? My lord, here the petitioner challenges the order of resumption or determination of the lease. Hide annexure 4 at page 25, my lord. My lord, the fact remains, your lordship may kindly see annexure 1, the registered lease deed executed by the then political and service department in favor of one Ramchandra Kaur. Your lordship may kindly turn to page 14, my lord. Annexure 1, the lease deed.
So there are 2 repetitions and 1 FAO.
My lord, FAO is regarding the lessee before his death executed a will. Then I filed application to probate and get letter of administration of the will. That is rejected by the trial court. Then I have filed the FAO here challenging that. Once it was allowed, but later on some respondent filed application that we are not had, it is an expertise for us, so it was recalled. Then the FAO is pending.
No, you have filed 2 repetitions and 1 FAO.
I have not filed.
He is
Because
pressing 17732. He is pressing.
I am on 17732.
So you have to say that, sir. Always, when you begin, you have to say which petition you are appearing in.
My lord.
So you are appearing in 17732.
My lord.
So the page number you are referring to is that paper book.
My lord.
Which page are you referring to, sir?
Page 14, annexure 1 is the lease deed, my lord.
Are you able to read it, sir?
My lord.
Are you able to read the document?
I do not know what is the condition, but here it is.
It's a good condition.
Some difficulty, my lord.
All right.
Then your lordship will permit, my lord, I will give a typed copy.
Sir, all that will take another 10 years. So we might as well do it, make do with whatever we have today.
My lord.
We will both spoil our eyesight together.
Sorry, my lord.
All right. Yes.
My lord.
Which clause you want to read?
No, my lord. First of all, your lordship may kindly say page 14. This is the first party lessor is the governor of Orissa. And page 16, my lord, the lessee is and Ramchandra Kaur. This is in dispute, my lord. And Ramchandra Kaur, son of Banchanidhi Kaur, managing proprietor of Matrubhumi. This was, so my submission is Ramchandra Kaur was the lessee. Then your lordship may kindly turn to next page, my lord, clause 1. The purpose of lease. Clause 1, my lord. In consideration of sum of rupees 5,000 paid as premium, hereof, the execution of these presents, the receipt of which the lessor hereby acknowledges, and of the rent hereinafter reserved, and the covenants on the part of the lessee hereinafter content, the lessor hereby demises to the lessee for the purpose of, this is important, my lord, for the purpose of building a house or houses and using the same for residential purposes only. Then my other things are not necessary. Your lordship may kindly turn to next, my lord, page 18, clause 3. So the lease was for residential purposes. Then, my lord, your lordship may kindly page 18, clause 3. That he shall at his own expenses.
Anyway, you'll build a house. Basically, it says a residential.
My lord, instead of a building, my lord, with RCC roof, I constructed 4 asbestos roof house
All right.
with brick wall. And I continue the lessee continued in possession for 60 to 96 till his death.
All right.
During this period, there was no objection at all.
All right.
Then, my lord, your lordship may kindly see annexure, the impugned order. That is annexure 4, my lord.
No. How are you? You are the legal representative of this car.
My lord.
The petitioner is the legal representative of this
No.
car, Ramachandra Kar.
My lord, she is the beneficiary under the will. Since Ramchandra Kaur has expired, the writ petition is filed by the beneficiary under the will, my lord.
No, but isn't there a thing of probating the will? You never probated the will?
That probate proceeding was dismissed and she has prepared the affair.
Probate proceeding was dismissed, madam.
Ah.
I'm in the second FO.
Ah.
Probate proceeding dismissed, they came up in appeal.
Ah.
In the appeal, without making a party, the probate was granted. I filed an application for recall. The judgment was recalled.
Ah.
Now the FAO is pending.
Ah. FAO by her?
Yes, by me,
Yes.
my lord.
Ah. So if you do not succeed in the FAO, then this whole thing goes.
My lord,
No,
FO
another
and this thing is authorized, my lord. Different, my lord. FO is only for the declaration that the will is genuine and for issue of letter of administration.
No. How do you become a legal representative if the will is just not proved?
My lord, because the will is in my favor.
Exactly, sir. So if the will is not proved, then how do you maintain this petition?
But to protect the property, my lord, I can maintain, my lord.
On what capacity, sir? As a trespasser?
My lord, may I be permitted to submit one word?
Ah.
Your lords may kindly find the lease deed was granted in 1960. Lease was granted in favor of Ramchandra Kaur. Then resumption order was passed in 1991 when Ramchandra Kaur was very much alive and he was issued show cause notice. And and that is there in the annexure 4. That
was not challenged.
That is not challenged.
Oh.
He executed this petitioner came to light in 1995 after resumption order was passed.
I see. So anyway, it doesn't. So
he
by
did
that
not
time
challenge.
itself, yeah. So even in the will, if something is left to him, doesn't make a difference.
Yes,
Yeah.
91 the will was the property was
but
resumed,
no notice
and in
to show cause-
96 the person died. The lessee died during 1991 to 96. He never challenged this resumption proceeding. Now he is the beneficiary under a will which came into light after 4 years of the resumption order.
Ah.
So by the time the alleged will was executed by Ramchandra Kaur, this land has already been resumed to government khata.
Correct.
4 years prior to that by virtue of annexure 4. So he has no locus standi at
Right.
all.
But fact remains, my lord, no notice for resumption or cancellation
That's
of
okay.
the.
You're not challenged it, sir.
He did not challenge. Who are you?
My submission is it is not issued to Ramchandra Kaur, my lord, at all. Your lordship may kindly see annexure.
Oh, you're now displacing Ramchandra Kar himself.
So, what is that to you? What is your locus standi?
Then why trouble yourself with the will and all that?
But no notice has been issued to Ramchandra Kaur, but it is issued.
Page 25.
to the
You better be
managing-
clear. Is the will in favor? Is the lease in favor of Ramchandra Kar or not?
My lord. Will is by Ramchandra Kaur, the
No.
lessee.
The lease.
Lease in favor of Ramchandra Kaur.
So that you are not disputing.
No, my lord, I am.
If lease is in favor of Ramchandra Kar, and if there is a resumption of that lease
In 91.
in 91,
But
which has
no,
not been-
without any notice to Ramchandra Kaur, my lord.
all fine, sir. You have not challenged it. Neither did Ramchandra Kar challenge it, nor did you have, nor have you
Because
challenged.
no notice was issued, my lord. Your lordship may kindly page 26.
No.
Here is resumption order has been issued.
That will
to
be the
managing
ground of
director.
challenge, sir. That will be the ground of challenge. But there should be a challenge.
But my submission is, my lord, I have constructed a house, residential house there with asbestos roof. So only on the ground that I have not constructed the house there, it is resumed.
My lord, may kindly
After
see page
30 years.
25.
Not
Page 25.
I meaning not.
I, what is
What is this I?
Who are you?
Yeah.
Malad, he has absolutely no locus standi.
No, I know, sir. He's already in trouble. So,
Malad, if at all can challenge, that can be challenged by us who are the legal heirs.
correct. All right. Yes. Anything else, sir?
My lord, my submission is
Ah.
that the ground of cancellation by the annexure 4.
If you are Mr. Kara, we'll listen to you. If you are not Mr. Kara, we can't listen to you.
That if that is, then I have no case, my lord. But my submission is,
Ah.
since the will is in my favor,
Ah.
I have to protect the property till it is probated.
No, no
My
person
lord,
can.
suppose I will succeed in the will, my lord.
Still, you will not succeed in this petition, sir. From what he's saying,
It is
the land
4
was
years
already
after.
resumed in 91 before the will
Ma-
was written.
I oblige, my lord. But fact remains, my lord, in 91, no notice has been issued to
You have
Ramchandra
to
Kar.
challenge that, sir. By alleging that as a ground, you have to challenge it.
Here, yeah, in the petition I have said so.
No, not
notice
this
has been
petition,
issued.
sir.
Ramchandra Kar
Ramachandra Kar has to challenge it.
My lord, had there been any notice to show cause to Ramchandra Kar,
Yeah.
he would have challenged.
Yes.
But there is no notice, my lord.
My
So the
lord,
prayer in the present application is what? Let us see.
I passing annexure 4, my lord.
No, annexure 4 is not the resumption notice, sir.
resumption order.
Resumption order, my lord.
Oh, you are now challenging it.
90.
Now your resumption order, my lord.
Page 25 may kindly be seen for a while.
Yes.
Page 25, last but one para.
Yes.
And whereas the lessee was directed to this department by letter number so and so to show cause as to why the lease shall not be terminated under clause number so and so on aforesaid ground. The cause showed in the letter dated so and so is not at all satisfactory. What he is saying, that is not correct. He was so cause notice was issued to the then lessee, Mr. Ramchandra Karo. He filed a reply and that was not found to be satisfactory. Thereafter, this will, the petitioner came to picture in 1995. 4 years after this order was passed, the original lessee was noticed. He filed the so cause. He never challenged the resumption order before.
What's the date of the will, sir?
Date 95.
Oh.
4
My lord,
years
your
after.
lordship, for a moment, my lord, see the notice to show cause, my lord. From the second writ petition, page 45. Because it is not with me, I have not annexed it. But in the second writ petition, the show cause notice has been issued. Annexed, my lord. That is issued to the managing director of Matrubhumi, not to the lessee. Your lordship, can you see?
Yeah.
He is the lessee.
Yeah.
It is to the Matrubhumi managing director, Mr. Karo.
No, my lord, no. Your lordship, can you see that? Page 45.
How does that help you, sir? How does that help you?
Because of that manner, Ramchandra Kar Dilesi could not challenge the same.
All right.
Because no notice has been issued to him. And Matrubhumi has ceased to operate since 1978.
Anyway.
Your lordship, can you see for a moment, my lord? Page 45 from the second writ petition.
Who is appearing for Bikash Kara?
He is dead, to my instruction that he is dead since last 6 years.
So that petition goes anyway.
He is not pursuing.
So 14635 of 2007. The court is informed that the petitioner has died. There has been no application for bringing on record any LRs of the petitioner. The petition accordingly appears and is disposed of as such.
My lord, for a moment, your lordship,
kindly permit me to address. It's Vikas Karo who was there in your lordship has seen. This Vikas Karo was made as a beneficiary, as a legal heir in the will probate case. Whereas he is an imposter to the family.
Anyway, sir, his petition is over
he is
now.
not there.
He is imposter. They are imposter. Original owners are we.
Anyways,
We
all right.
we don't question it.
All right.
lordship, for a moment, my lord, page 45 is of Vikas Kar read, my lord. For a moment, my lord.
No, why
That
should we
you
look into
cannot
that, sir?
rely
We don't have to look into it. He's not there. You are not appearing for him. Yes.
No, my lord, they are the resumption notice to show cause is there, my lord.
It's all right. Even here it is there. It is
not to
mentioned in the
address to
preamble.
Ramchandra Kar.
It
It
is
is not
mentioned.
addressed to Ramchandra Kar, my lord.
Anyway, you cannot take advantage of all that, sir. There's no challenge to that by him when he was alive. You say in the main 17732 of 2010, the challenge in the present petition is to a notice dated 29th August 1991, issued by the General Administration Department, Government of Orissa, determining the lease of plot number 3, unit 3, Bhubaneswar, allotted in favor of single quotes Dabatra Bhumi. The managing proprietor of which was one Sri Ramchandra Kara, son of Banchanidhi Kara. Paragraph, the plea of the present petitioner is that she was a beneficiary under a will executed by Mr. Kara on
Will letter 14/11/1995.
Yeah.
Annexure
14th
3.
November 1995. She had applied for probate of the said will by filing probate miss case number 5 of 2003. So that case was allowed in her favor, and therefore she was validly stepped into the shoes of Mr. Kara as lessee. Stop. However, by judgment dated 13th January 2010,
The trial court refused the probate.
yeah, the probate was refused by the trial court
On 15/5/2004.
by the order dated 15th May 2004, but that was reversed by this court in FAO number 251 of 2004 by a judgment dated 13 January 2010. And the matter was remanded to the trial court. Full stop. It appears that said order dated 15th May 2004 has been challenged by the present petitioner in FAO number 251 of 2004. Paragraph. It has been pointed out by Mr. D.K. Mantil and AGA, appearing for the state in WP Civil number 17732 of 2010, that even during the lifetime of Sri Ramchandra Kara, the lease stood cancelled and the property in question was resumed. It draws attention to the third unnumbered paragraph of the preamble to the office order dated 29th August 1991, which reads as under, start from, and whereas the lessee was directed in this department letter dated 24/6/91 to show cause up to satisfactory. Paragraph. He accordingly points out that the resumption of the lease became final on 29 August 1991 during the lifetime of Sri Ramchandra Kara, with him not challenging the resumption at all. The locus standi of the present petitioner is accordingly questioned. Paragraph. Learned counsel, the petitioner sought to urge that no proper show cause notice was in fact issued to Sri Ramchandra Kara prior to resumption of the lease. Stop. Unfortunately, Sri Kara himself raised no such grievance. Stop. He appears to have filed a reply on 1st July 1991 to the notice issued to him on 24 June 1991. Stop. Therefore, it is factually incorrect on the part of the present petitioner to assert that no notice was issued to Sri Kara during his lifetime. Paragraph. At the date when the will was executed on 14 November 1995 in favor of the present petitioner, the validity of which in any event is questioned by the contesting respondents in FAO 251 of 2004, who claim to be the real legal heirs of Sri Kara. Sri Kara had no right, title, or interest vis-a-vis the plot in question to bequeath it in favor of the present petitioner. Full stop. Therefore, notwithstanding the outcome of FAO number 251 of 2004, the present petitioner lost the locus standi to question the resumption on the basis of deriving a status from the bill dated 14 November 1995, since on that date, the lease already stood resumed by the state. Paragraph. With there being no challenge to the resumption during the lifetime of Sri Kara, it is not possible to entertain a challenge on behalf of the present petitioner, only because in the will dated 14 November 1995, she is shown as a beneficiary vis-a-vis the said plot. So that was not a valid bequest at all at the time when it was made, and has therefore, and such a bequest is therefore unsustainable in the eye of law. For the aforementioned reasons, the court finds no merit in the present petition, and it is dismissed as such. This FAO 251 of 2004. The challenge in the present petition is to an order dated 5th May 2004, passed by the which court is that?
That is civil judge.
Senior
Civil judge, senior division, Bhubaneswar.
Civil Judge Senior Division, Bhubaneswar.
FO is pending here, my lord.
Yeah.
After remand from the Honorable Apex Court, it is pending here.
My senior is not correct. The trial court judgment was set aside by the honorable this honorable court in FAO. I came up that we were never noticed. This honorable court recalled that judgment. Now the FAO is pending.
Yes.
The question is, the probate was not granted in favor of the present petitioner, who is the claims to be that I am the beneficiary. There, the learned trial court refused the probate. This honorable court set aside the order and granted the probate. That judgment was questioned in a recall application. The order was recalled. Now, the fact is that till date, there is no probate.
But the FO is pending.
Yes, I don't dispute it. I don't dispute it.
FO is pending.
FO is listed also today. But till date, there is no probate in favor of the.
No. The FAO has to be decided by this court.
Yes,
No, single judge.
Honorable
Single
judge.
judge.
Yes.
It is to be placed before a honorable single judge.
All right. In the FAO then say, placed before the roster bench of the learned single judge on 9th May.
Now, technically, my lord, nothing remains to be decided in FAO because that property which is now he is claiming, my lord has already heard that the Kaur family having not challenged it. Now, nothing remains to be decided in FAO.
That was the only property covered
That was
in
the only property.
Oh,
But
So,
let
my
it
lord,
be
it has
decided.
now become a completely technical issue.
Ah.
My lord,
My lord's judgment.
in the FAO, it will be decided only whether the will is genuine or not. Nothing more.
But
No
property
title to
was- my lord
property.
may see the property.
If the-
Property is
After
you
there.
get
get-
nothing under the will, sir.
There is nothing under the will. It's a
But
document.
my submission is, if I succeed in the probate of will, then I can go to the property. And if there is no property, it is of no able to me.
That's what he says. There is no property.
There is no property today in the IFA.
But will has to be probated.
All right. Anyway,
Obliged.
Weekly list item number 15.
Item number 15, no instruction.
no instructions disposed of.
Weekly list item number 16.
16, my lord, in this case, the petitioners have challenged the illegal action of the opposite parties by taking forceful possession of the plots of the petitioners, my lord. for expansion of irrigation project without due process of law, my lord. Annexure 1 is the ROR, stands in the name of the petitioners. That is under Annexure 1, page 8.
No counter, nothing filed, sir.
My lord, the
Notice also not been issued.
my lord, office shows that the copy has not been served.
Yeah. It's a 2011 matter.
Copy has not been served on our.
Sir, are the petitioners around? When did you speak to them, sir?
Petitioners are two brothers, my lord.
When did you speak to them?
Pardon, my lord.
କେବେ କଥା ହେଇଥିଲେ ତାଙ୍କ ସାଙ୍ଗେ?
When did you speak to them?
My lord, I have not.
It's a case of 2011.
Last occasion, 1 month back, I have talked to him.
Both the brothers are there. Repeat. Doesn't understand what I'm saying.
You talked to both the brothers a month back, as you mentioned.
All right, you argue your merits now. Yes. What is the matter?
Annexure 1, my lord. The ROR stands in the name of two brothers, my lord. Their land has been illegally taken away for the construction of embankment of the irrigation project, my lord, without following any due process.
When was it taken, sir?
Yes, that.
Just ask him.
When the possession was taken over?
My lord, possession was taken in prior to 2018, my lord. 8, my lord. In the year 2008, another writ application was filed by the petitioners. This honorable court also directed to dispose of the matter, directed the opposite parties to consider the case of the petitioners after following the.
Mr. Counsel, kindly listen to us. When the specific date, mention the date on which the land was acquired.
No, my lord, that has not.
It has not been mentioned in the writ petition.
No, my lord, I have not. Lords may give me some time, man.
It is then barred by latches.
Pardon, man?
It is then barred by latches.
I may be excused, my lords. In this case, what happened, my lord? Lords is putting the question, but that is right, my lords. But my lords, a particular date, my lords, what Lords is saying, my lord. I have not mentioned the particular date on when the possession was taken by the opposite party, my lords. I have not mentioned, my lord. In this regard, if lordship should date, my lord, I will take instructions, my lord, from my client, my lords.
So we are not giving you time for all that.
This is the second round of litigation, my lord. Earlier, it application filed by the petitioner, which are disposed by the Honorable High Court, my lord, saying that consider the case of the petitioner.
So that is always standard. Everything under all problems under the sun, we pass those orders.
In spite of that,
whether maintainable, not maintainable, whether early, late, we pass that same order.
My lord, what happened?
You are very happy. We are very happy. State is very happy. Petitioners are very happy. Everybody is happy with those kind of orders.
But what happened?
You go away smiling from the court. You tell the client, we have succeeded.
No, my lord, I'm not saying so, my lord.
Then you have to come back. After some years, you have to come back because nothing is happening.
My lord, what happened, my lord, in the meantime, they have taken, my lord, taken away the land of the petitioner.
So one very important fact for which we are not granting adjournment, you have to tell us when exactly was possession taken.
Prior to my lord, 2000.
That is not sufficient for us, sir. That is not sufficient for us.
But ROR stand in the name of annex, my lord. ROR stand in the name of the petitioner.
So you feel happy, sir?
They have taken.
The ROR is in your favor.
My specific, my limited prayer, my lord.
That prayer you cannot get unless you tell us when you lost possession.
Therefore, my short date may be given so that.
No, certainly not, sir. There has to be actually a word specifically in your petition.
Omin report also, my lord. Omin also, my lord, as per directions, some of the Omin report was in favor of the petitioner.
All right.
Everything is, my lord, petitioner.
Everything is in your favor, sir. So you want to withdraw the petition? I will record according to everything is in your favor.
But only I pay, my lord, so lands already taken, my lord, and embarkment already, my lord, they have already made an embarkment expansion of an embarkment, my lord, on my land. Only specific prayer, my lord, that some money may be given so the towards compensation. So
the problem is none of these petitions are based on any law. You come into a law court, you want to treat it as a lok adalat. Whenever you think you walk into the court, whatever you say, some relief must be granted.
No, that I'm not.
All that happens in lok adalats, not in the law court.
No, that's my lord, I'm not saying, but lordship.
So you can go, you can still try lok adalat route. You can withdraw and you say, I will try some other route.
Writ petition.
But if you want to file writ petition, Article 226, then some problematic judge will ask you all these problematic questions. Then you have to answer.
Now, there was writ court, lordship, my lord, chief justice court, writ court, my lord.
So we can do anything under the sun.
None.
We can keep aside all constitution, law. I have to say, I am chief justice. I can do anything I want.
Writ court, your lordship.
Writ court, everything can be done, sir.
Not a simple, but poor petitioners.
Everybody. So one ground, poor petitioner. 2, I am chief justice. 3, this is writ court. 4, petition allowed. Look at the arguments you are advancing. You are advancing arguments before a law court, correct? What are the arguments? Petitioners are poor.
Now, before argument, I've already
you are chief justice. This is writ court, right? These are the 3 major arguments.
Argument by lordship says, my lord, that particular date, my lord, I am unable to say, my lord, because I am not.
That is the first step, sir. That's first step. First step is actually setting out proper facts.
My lord. That
only that is only the problem in the petition. No facts, no proper facts. That is the only problem in the petition.
Date, my lord, is I'm sorry.
What do you want to do, sir? Because we are, you know, now the writings on the wall, right? You know what we are going to say.
Only lordship direct the opposite party.
We are not directing anyone anything because facts are not clear. We cannot direct.
Only 2 days time may be given so that I'll take.
We cannot do that. Then what is your third plea?
Approach my lord once again below lordship's liberty.
Whatever. No liberty. You will say, you say the counsel, the petitioner wants to withdraw the petition to approach the authorities, if so permissible in accordance with law. Dismisses, withdraw. With the liberty is paid. All right.
Special weekly list item number 17.
Yes, Subhash.
May please, Your Lord. So this matter, in this matter, there was an earlier order of 18/8/2021. Sir, you may kindly see. Am I audible, sir?
Yes, yes.
So you may kindly see the last order of 18/8/2021,
yes,
where opposite party number 3 has been impleaded and notice has been issued. This is Orissa State Financial Corporation. The cause list doesn't appear to have marked appearance of the said opposite party. The principal grievance in this petition is against the opposite party number 3. So we await their appearance.
No, who's for the petitioner, sir? You're for the petitioner.
I'm for the petitioner.
He is for the petitioner and I am for the ITCO. Yes. His main grievance is against OSC, and OSC I don't think has appeared in this case. So unless they appear and file a counter, though it's a very old case, but I don't know.
No, let us see what the case is about.
So this matter, the background of this case, sir, is that OSFC, that is the impleaded party, OSFC had sanctioned a loan to one CASA Industries, and the IDCO had allotted a plot to that CASA Industries. Thereafter, CASA Industries defaulted in OSFC loans. As a result of it, OSFC seized that IDCO plot under the State Financial Corporation Act 1951 and put it up for sale. I approached as the subsequent purchaser of that plot. I purchased it from OSFC.
When?
Sorry, madam.
Which date, please?
1908 to 1998. At page 16, Your Lordship will see, when I was handed over.
We have to, this is a letter that is written by the branch manager of OSFC to IDCO. We have to inform you that the industrial assets of CASA Industries have been sold in favor of Mrs. Excel Packaging, such and such. After execution of necessary legal agreement, the buyer have taken over the physical possession of the assets of on 19/8/1998. We would therefore request you to transfer the land and building in favor of Mr. Excel Packaging, plot number such and such, and issue re-allotment letter with mortgageable right permission for taking further action at our end. So this is a letter where by virtue of which it is recorded that I have been handed over possession on 19/8. Thereafter, Mallots may see page 70. The petitioner wrote a letter, which your Lordship will see on 29th August. It was written to IDCO. We inform you that the industrial asset of Messrs. CASA Industries have sold to us, Mrs. Excel Packaging by OSFC, and we have taken the physical possession on 19/8. Therefore, we request you to take necessary steps to transfer the said land and building of CASA Industries to Excel Packaging, for which act we shall be grateful to you. Thereafter, my lords, there have been subsequent letters at page 18, 19, 31, 32, and 33, where a letter, your Lordship will see page 18 for a moment, your Lordship, where they say that there are some outstanding dues of OSFs insofar as the previous previous allottee is concerned, and that unless that is recovered from IDCO, unless that is recovered from OSFC, that cannot be transferred. Your Lordship sees, please refer to this office letter number such and such, dated 12/11/98, addressed to the Joint General Manager OSFC, in which we requested for remittance of a sum of rupees 9,08,801 towards payment of arrear hire purchase dues and water rent under intimation to you in the next memo. Meanwhile, more than 10 years have already been passed and we are yet to receive our dues, as the same had been seized and sold by OSFC in favor of Excel Packaging. However, as of 31/3/2008, a sum of rupees 9,71,000 is receivable by IDCO towards arrear hire purchase dues of such and such. Besides, arrear recurring statutory dues are also receivable by IDCO. The purchaser is now pressing hard. Purchaser is me, Lord, is now pressing hard for transferring the lease of shed number such and such immediately. In order to consider the transfer, the leasehold interest in IDCO shed number such and such in favor of the purchaser, the outstanding dues has to be cleared by your corporation. So, my lord, this is Milord's letter from IDCO to OSFC, where IDCO says you clear your dues, the corporation's dues. Thereafter, Milords, there is another letter on similar lines at page 19. Your Lordship will just see the last para. You are requested to make necessary arrangement for
the dues arise from the plot itself, from the use of the plot. So the subsequent purchaser picks up the tab attached to that plot. As simple as that.
No, Milords, the final consideration that was decided between the parties was what was payable by me, and that has been paid.
You paid the 12.5 lakhs, correct?
Yes, Milords. So,
no, apart from 12.5 lakhs, what was not communicated to you was that the previous lessee owed IDCO something.
Yes, Milords, and that was, and therefore, Milords, the sale letter says that this is the final consideration. There is nothing, and your Lordship, interesting to notice that the dues, Milords, is requested by IDCO to the corporation, not to me. But what the corporation does, that is OSFC, which is yet to appear before your Lordship. OSFC suddenly changes stance and says and writes a letter to me, which is at page 20. Milords will see. OSFC writes a letter to me that you pay this amount.
Yes.
Now, Milords, all these letters, which is at 18, 19, as well as in IDCO's counter affidavit, which is running page 31, 32, and 33. All these letters, Milords, say that IDCO is writing letters to the OSFC to make payment.
Right.
Now, my lords, therefore, my lords, we have made OSFC a party, and my lords, perhaps that's the reason, my lords, OSFC, my lords, needs to clarify this before your lordships.
Yes.
Turn to page 14, madam.
14.
Sale letter, annexure 1, 30, 31, 3, page 14, clause 5, madam.
Clause 5.
The
Yes.
purchaser will negotiate with IDCO within 1 month of taking over possession of the assets for transfer of the leasehold interest of the IDCO land said in his their favor with mortgageable right in favor of OSFC. OSFC shall, however, recommend to the IDCO for such transfer of ownership, the IDCO, the industrial land and building shall be utilized for bona fide industrial use. Accordingly, my lord, we have annexure 2, we have written 28 to 19, my lord, 98. After the 1998 sale was handed, possession was handed over to the petitioner, my lord. Thereafter, my lord, 28, in persons to clause 5 of sale letter, my lord, we have issued this letter to IDCO.
Should this petitioner pay that? That's the whole question. The petitioner is saying, why should I pay it? It's something owed to you to IDCO by the erstwhile lessee.
Erstwhile lessee is not also a party. That erstwhile lessee is not also a party here.
The application has been filed by individual.
My lord, your lordship may see what is the prayer, my lord, here. Because of the defective petition, we are unable to file a kind, because in paragraph 1, my lord, all were paragraph 1, my lord, he has written the opposite party number 2 has issued letter 2012-2009, my lord. We are paragraph party number 3, my lord. Then your lordship will find paragraph 3, my lord. Everywhere is written the opposite party number 1 had sanctioned, IDCO has not sanctioned loan. We are confused when we
There will be confusion between you and IDCO anyway.
Yes.
The prayer is that you should be directed to recover the arrears of IDCO from the previous lessee. But the previous lessee is not made a party, Mr. Acharya.
Yes, previous lessee should have been a major party.
Actually, all this should be like a civil suit. It can't be in a writ petition.
If your lordship will read second prayer, my lord,
yes,
he is necessary party, my lord.
Yes.
And further, be pleased to direct the opposite party 3 to recover the area dues of the erstwhile occupier of the land and building.
Correct.
Milords, may I make a prayer, Milords? Milords, in that event, Milords, may I make a prayer, Milords, to allow me to implead that party?
What will happen? He will come around and say, I have no money, I'm not obliged to pay. I was not told of these dues.
Milords, what is happening, Milords? My right to be registered as the lessee. Milords, that right is being...
See, the only thing is to pay up that amount and seek to recover it from the other erstwhile lessee.
Milords, then the question, Milords, will arise.
Because you're desperate. The value of your plot must be huge. It must be much more than this dues that is being asked to be paid. You just pay it and you recover it from the other man, reserving your right to recover it.
Milords, the question that will arise is, Milords, do I even have any privity with that other person to recover it?
Yes.
So it is, therefore, Milords,
you're paying his dues, that's why.
Yes, Milords, I am paying his dues. Milords, I do not have any privity with that other person.
No, you don't have privity in that sense, but since you've cleared his dues, you'll trace out that his liability that way towards you.
Milords, in that event, Milords, may I just make this humble prayer, Milords, that let me make a party, let the other person appear and
express. It's not going to solve the problem. He's not going to pay up. See, if you're desperate for this property to be transferred in your name, correct?
Yes, your Lord.
What's the value of this property? It must be huge. Where is this in Bhubaneswar?
Yes, my Lord. It's in Bhubaneswar.
What are the dues of the erstwhile lessee? What is the amount that they're claiming?
9,71,000.
There must be nothing. I say the premium on this property must be huge. What is 9 lakhs? It's nothing.
Would your lordships then adjourn this matter to allow me to seek instructions? From
that you can do. Yeah. Counsel, Mr. Acharya wants to seek time for instructions. list on 17th May.
Very well. Grateful.
Special weekly list item number 18.
Your Lordship. Am I audible?
May I please, Your Lordship?
Your Lordship. Am I audible?
Yes, yes.
Your Lordship. In this case, my Lord, the petitioner has challenged award.
You have to speak louder.
Your Lordship, infirm award. Am I audible, my Lord?
You have to speak louder. Yes.
Your Lordship. The petitioner has challenged the impin award under Annexure 1, my Lord.
Yes.
That wherein, my Lord, the labor code that passed by labor code directed for reinstatement of opposite party workmen and directed for payment of compensation in lieu of back wages, my Lord. Then background of the case is like that, my Lord. Your Lordship, under Annexure 2, Your Lordship, page 14, kindly see that the opposite party was appointed as junior engineer. Page 14.
Yes.
Sorry, my Lord, page 21. Page 21. Page 21, yes. Then Your Lordship kindly turn to page 22, clause 14, my Lord.
Yes.
There is a clause that after confirmation, this was a provisional appointment letter, my Lord. So clause 14 was there. After confirmation, termination of service will be by the 1 month notice or 1 month salary in lieu of notice by. Then thereafter, my Lord, under Annexure 3, that was confirmed. Your Lordship. Annexure 3, page 22. That was confirmed that towards last, my Lord, that terms and condition that was stated in the appointment letter, my Lord, that they under terms and conditions stipulated in our appointment order that will, however, confirm to hold good. That
continue to hold good.
Continue to hold good. So therefore, my Lord, the opposite party that accepted that terms and condition and continued in service. So ultimately, Your Lordship, that under Annexure 6, Your Lordship, Annexure 6, page 31. Page 31, that is under Annexure 6, that he was relieved from the service on the ground that the management no more required his service, my Lord. But the fact is that the others have not been engaged in that clause, only, my Lord, that not required. So 1 month's notice, in lieu of 1 month's notice, that 1 month salary that was given, he encashed and accepted without objection, my Lord. So thereafter, my Lord, he approached the labor authority and the conciliation failed, and that dispute has referred to, my Lord, labor court, that Your Lordship, that Annexure 1 was passed, my Lord, reinstating the petitioner, my Lord. My Lord, management stand is that, Your Lordship, that page 41, that he management filed, the petitioner management filed his WS, that is under 2 grounds, that here, page 41, in fact, page 41. Two grounds have been taken that the OP workman is OP opposite party employee is not a workman because he is of administrative character and nature of judge is supervisor in nature, and so labor court has no jurisdiction to decide this matter under as a workman, my Lord. And the second thing, my Lord, that Your Lordship, kindly see the page 41, that para 11b, my Lord.
Yes.
That this termination letter was issued as per clause 14 of appointment letter. So 1 month salary has been given. That 1 month salary, that is 6,900 something, that was given. It was accepted. Then, my Lord, clause D, that the opposite party, the petitioner has not recruited any other person in the place of management only. So management does not require any no longer any service of opposite party. Then Your Lordship, kindly page 42, my Lord. Page 42, that the claimant second party as belonging to executive cadre. This is most important, my lord. This is the executive cadre of the management. So he is not workman. So the Industrial Dispute Act that raised by the Labour Court has no jurisdiction. That is the. Then your lordship kindly say in order that has been allowed in favor of opposite party workman. Your lordship, para 7 and 8 is a finding of Labour Court. That before that, I am going to point out one thing, my lord. Your lordship, page 52 of evidence of OP1, opposite party, sole opposite party, 52, wherein he admitted 52, my lord.
Yes. 2 juniors to me were working.
Your lordship, your lordship, page 20.
I was supervising their work.
As is supervising nature, I am of administrative cadre that he has.
Yeah.
Then your lordship kindly turn to my lord, page para 7. Para 7 is the finding of labor.
Yes.
Para 7, that the dispute raised, my lord, that is there. The dispute raised whether this order of termination is legal and justified. That is the dispute. But finding, my lord, your lordship, page 12 of the running page, my lord. That is there in the cross middle after 5 line. My lord, only relevant I am placing, my lord. In the cross examination, the workman has admitted that this department, in this department, 2 juniors were working, namely so and so under him, but he has denied that he was of executive cadre. But it is contrary to his evidence. He admitted that he is of executive cadre. Then your lordship, para 7. Your lordship, then finding is, conclusion is para 8. Conclusion in para 8, in your lordship, in page 14, the section 2S as mentioned in this judgment itself. But 2S, the workman, whether he is coming under the workman as per section 2S or not. Your lordship, that is page 14, that was last.
Let's ask Mr. Month. Yes. There's an admission, sir, in your deposition.
Lord.
That 2 juniors are working and you're supervising their work.
Admittedly, the petitioner was initially working as a junior engineer under the opposite party.
Correct.
I mean to say the present petitioner.
Yes.
But subsequently, the nature of work he is performing, that is not the advisory or supervisory.
No, come to the evidence. Come to the evidence.
Yes,
page 52.
Page 52. In cross-examination.
Yes.
I was confirmed in service as assistant engineer on 1/5/2001. In my department, 2 juniors to me were working. Out of such 2 persons, I remember the name of one person, that is Samir Kumar Jana, and another is Somesh. I was supervising their work. It was, my lord, supervising the work means whatever they are doing,
yes,
I am taking care of this thing.
Correct.
So I don't
How
have
are you a
any
workman?
right. I don't
How
have
are
any
you a
right.
workman, sir?
My lord, kind of a glance to the definition of workman, which has been quoted in page 15 of the award itself.
Right.
Workman means, may I read me?
Yes.
Any person, including an apprentice, employed in any industry to do any manual, unskilled, skilled, technical, operational, clerical, or supervisory work for hire or reward, whether the terms of employment by express implied for the purpose of any proceeding under this act in relation to an industrial disputes, includes any such persons who has been dismissed, discharged, or retrenched in connection with, or as a consequence of that dispute, or whose dismissal, discharge, retrenchment has led that dispute, but does not include any such other persons. So clerical, supervisory work for hire and reward also. So the persons, those who have been employed by the petitioner, Miller, they are working below me, not that I was the appointing authority or I am making any.
Not for appointing authority, sir. Look at the exception clauses.
And that has been taken.
3, subclause 3.
Subclause 3 of the?
Does not include.
Does not include, Miller. Who is subject to the Air Force, Miller?
No. Below that, sir, subclause 3.
Who is employed mainly in a managerial or administrative capacity. So I don't have
What
any.
were your wages? Then the fourth one also.
Who being employed in a supervisor capacity draws wage exceeding 1,600. That has been subsequently amended. That has been amended.
No. Amended when and what were you drawing?
That amendment came into force later on. It became 10,000 million. Who being employed in a supervisory capacity.
We are talking of which year, sir? We are talking of which year?
Well, this is an amendment of.
No. The year in which you were employed, sir.
I am employed in the year. I am employed
when
in the
you got that payment of 1 month's salary in lieu of notice, what was the year?
97 million. And termination is of 2003.
That's right. So 2003, what was the provision of law? Was it 1600 or what was it?
It was 10,000 million.
Where do you find it? Just in this list. See. 1984. So you were earning less than 10,000.
Yes, ma'am.
All right.
And that apart, this has been.
So then 1 month's leave of notice you got. 1 month.
No notice. Directly they have issued this.
No, in lieu of notice, sir. The condition of your employment itself was.
Can you have a glance to that later? Can you have a glance for a moment? It is at page 31.
Yes.
It is at annexure 6.
Correct.
We are constrained to inform you that your service is no longer required.
Correct.
By this organization. You are relieved from duty forthwith.
Yes. Correct. So this is how, this is in lieu of notice, sir.
So
1 month space given in lieu of notice. Lieu meaning instead of.
My lord, if at all 25F will be complied, then notice has to be issued much prior to that, my lord. This is forthwith, my lord. Duty forthwith.
No, it's a condition of your appointment letter itself, sir.
I'll kind of a glance to the award part, man.
No, come to first your appointment letter.
Letter of appointment.
7697.
Yes, ma'am. At annexure 2, it starts from page 20, ma'am.
Yes.
The last part. After confirmation, termination of service will be by 1 month notice or 1 month salary in lieu of notice by the either side. And this has been issued in October 2003.
So this is after confirmation. Clause 14 says after confirmation, termination will be by 1 month's notice.
Yes,
so this is your condition of service, and this is continued.
Without
when you are confirmed,
again.
Next page 22.
Yes, ma'am.
These terms and conditions continue.
But without making any giving any opportunity to me, straight away they have said
that is the terms of conditions, sir. That there is no question of notice to you.
Without making
once they give you 1 month salary, you accept that.
I have accepted with protest, my lord.
Where do you say that? Where have you protested?
That has been taken care of in the award, my lord. The reasons of termination has not been mentioned, my lord. That has been.
No. 25FA. Come to 25FA. 25FA also says the same thing.
Condition precedent to the retrenchment of the workman. No workman employed in an industry who has been in continuous service for not less than 1 year under an employer shall be retrenched by the employer until the workman has been given 1 month notice in writing indicate the reasons of retrenchment. So here, my lord.
No, you're reading halfway, sir. Please read the entire
reasons
clause.
of retrenchment. I'm sorry, my lord. And the period of notice has expired, or the workman has been paid in lieu of such notice, wages for the period of notice.
So this is satisfied.
My lord, here, my lord, there is no reasons.
No. Or the workman has been paid in lieu of such notice, wages for the period of notice.
My lord, this is forthwith, my lord. Prior to 1 month, kindly have a glance to that notice.
Mr. Monty, you're not understanding. This letter is in lieu of notice. Lieu means what? Without notice. If you pay 1 month's salary, you do not have to give notice. That is why it's called in lieu of notice. Come to 25FA. It uses the same words. Has been paid in lieu of such notice. It's a challenge, the present petition.
But here, I have not been given any chance, my lord. My humble submission.
Where's the question of chance, sir? This is the term of your appointment letter itself.
Well, after working for much years,
that is the point. This is all part of your conditions. You're not compelled to accept an employment like this.
This is a hire and fire basis, my lord.
It is.
Even after working.
This is written into the law, sir. 25FA has been written like this. In lieu of notice.
That should be a reason for my termination.
No. Or the workman has been paid in lieu of such notice. The challenge, the present petition is to an award.
Sorry, my lord, I want to point out one thing, my lord. In 2011, that impune award was stayed subject to compliance of 17B. 17B is complied. The opposite party is receiving salary last wages. That is to be noted.
All right. You said the challenge by the management in the present petition is to an award dated 22nd September 2010, passed by the Labour Court Bhubaneswar in dispute case number 27 of 2007. Paragraph: the dispute referred to the Labour Court for adjudication was under take from para 2. Paragraph: the background facts were that the opposite party was appointed as junior engineer by the management on 7th June 1997. On the scale of pay of rupees 1975-3935 with a total salary of 4761.75 per month. He was initially on probation. Full stop. Condition 14 of this letter stated, open quotation, after confirmation, termination of service will be by 1 month's notice or 1 month's salary in lieu of notice by either side. Full stop, unquote. Subsequently, on 13 July 1998, the opposite party was confirmed as a junior engineer in the company with effect from 7 June 1998. The letter stated that, open quotation, other terms and conditions stipulated in our appointment order will, however, continue to hold good. Full stop, unquote. Paragraph. The petitioner's services were terminated by a letter dated 25th May 2000. Sorry. The petitioner was thereafter promoted as assistant engineer (ENC) on a monthly salary of 6008.79. Full stop. On 8th October 2000, services were terminated by paying him a check paying him by way of check rupees 6995.65, being 1 month salary in lieu of notice. Paragraph. Questioning the termination of services, the industrial dispute was raised by the opposite party, which was referred for adjudication to the Labour Court. Paragraph. 2 issues were considered by the Labour Court as under. One, whether the opposite party was a workman within the meaning of Section 2, bracket 1,
yes, man.
bracket S of the Industrial Disputes Act 1947 bracket ID Act, and 2, whether the termination of his services violated Section 25 capital paragraph. The Labour Court negated the plea of the management that the petitioner was in a supervisory capacity and therefore outside the ambit of Section 2 bracket S of the ID Act, and therefore the Labour Court had no jurisdiction to decide the dispute. The Labour Court further held that the termination of the opposite party's services were in violation of Section 25F of the ID Act. Accordingly, the Labour Court directed his reinstatement with compensation of rupees 75,000. In lieu of back wages. Paragraph. By an order dated 2011, this court stayed the operation of the impune award, subject to the opposite party being paid wages under Section 17 capital B of the ID Act. The court is informed today that by the Council of the Management that the said interim order has been complied with. Paragraph. This court has heard the submission of learned counsel of the parties. Paragraph. As regards the first issue, whether the opposite party is a workman, Section 2 bracket S, which defines the expression, reads as under, reproduce 2S. What is exempt from the definition is a person working in a supervisory capacity who earns above rupees 10,000 per month. Paragraph. Council of the Management drew the attention of the court to the reply given by the workman, who was examined as WW1 in the Labour Court in his cross-examination. There he states that there were 2 persons working under him whose work he was supervising. Stop. Paragraph. The main part of the definition of single quotes workman under Section 2 bracket S of the ID Act includes a person working in a supervisory capacity. Full stop. It is only where the wages payable to such person exceeds rupees 10,000 per month that such person would fall outside the ambit of the definition of single quotes workman. In the present case, although the opposite party workman may have been engaged in a supervisory capacity, since his monthly wages at the time of the termination of his services was less than rupees 10,000 per month, he does not fall outside the ambit of single quotes workman. Stop. To that extent, the court finds no error having been committed by the Labour Court. Paragraph. However, as regards the second issue, The Labour Court appears to have erred in holding that, notwithstanding specific terms and conditions of the appointment letter, the management still had to give reasons for termination of services, failing which there would be a violation of Section 25F of the ID Act. Stop the relevant portion of Section 25F bracket A, which is relevant for as far as the present case is concerned, reads as under. Reproduce 25FA. It is seen that the above provision itself contemplates the workman being paid in lieu of notice, wages for the period of notice. Full stop. In terms of clause 14 of the conditions attached to the appointment letter, as noticed herein before, the workman was required to be paid 1 month's notice in lieu of 1 month's salary in lieu of notice, which in fact has been paid to him. Full stop. The Labour Court overlooked this fact in holding that there was a violation of Section 25F of the ID Act. Full stop. Consequently, the court is unable to sustain the impugned award to the extent it holds that the termination of the services of the opposite party workman was illegal. So consequently, the impugned award, to the extent it requires the opposite party workman to be reinstated and to be paid compensation in lieu of back wages, is hereby set aside. The petition is allowed in the above terms. No orders to cause. We'll continue after lunch.
I may be pardoned to mention, my lord,
My lord, I beg your pardon to mention, my lord. My lord, I beg your pardon to mention, item number 10 may be taken up tomorrow or day after tomorrow, ma'am. Weekly list, item 10, ma'am.
Well, we are in the midst of something else. When it's taken up, you mention this. Yes.
My lord, I may be pardon to mention, my lord. My weekly list item number 4, my lord, the lady has become ill and sleeping outside, my lord. So
No, you can ask her to leave, sir. We can have it on some other day.
My lord, it is a content matter, my lord. Order is complied, my lord.
Who's the other side? Who's the other side, sir?
Government. Union, madam. Union of India, madam.
Where is he? Which is his item 12? Item 4.
Weekly list item 4.
Oh, item 4, I am appearing for the state, my lord. That Subhas Tripathi. But they have to personally appear, all of them.
A lady is actually ill, sleeping outside.
No. How
My
many
lord, I am
petitioners are
appearing
there?
in that case.
How many petitioners are there?
My lord,
3.
4 petitioners. 4 petitioners, my lord. One is representing 3 and lady is separate, my lord.
So only the lady can be exempted. The others can be present.
Yes.
The
The lady can move. The others can remain present, sir.
My lord, the other person is the husband of the lady. my lord.
So
She's only accompanying her only. Nobody else is accompanying her, my lord.
How
That's
many
why in the
persons are
launch-
there, sir? There are only
launch-
2
launch,
persons.
my
How
lord,
many contemners are there? How many contemners, sir?
2. Actually,
I think 3.
no,
Daughter is also-
four parties are there.
One is company.
One is company.
Husband, wife, 2, 3. Then 4 is, who is the fourth?
Fourth is the lady.
Yes.
1, 3, 4 is the.
Sir, they are all residents of
and 2 is the
Cuttack.
Lady, my lord.
They are residents of Cuttack.
My lord.
So you can send one of your colleagues to accompany her. The man can remain present, sir. Yes.
Weekly list.
Hmm.
Weekly list item number 22.
May I please?
746 now to 22.
Yes, ma'am.
22, Lordship, before my land friend starts the argument, Lordship, I glance to order dated 22/12/2021, Lordship, for a moment. Lordship, on the relevant day, Lordship, can see para 6 of the order. Lordship directed Lordship, just I'm reading the operative part. In order to test whether the system is able to effective, the court directs Mr. Dalai to contact at least 5 of the villagers who have been instructing him to send to the collector and SP Puri photographs and video clippings of any of the illegal prawn gheris operating in the Chilka area on daily basis for at least 5 days. Details of the action taken thereon will be placed before this court by the collector, SP Puri, and by the next date, Lordship. And my lord, the relevant, the collector did not respond. And I make a statement here, Lordship. I made a statement. And Lordship directed to give the same information to Lord Council appearing for the state, Mr. Mahanti, and I supplied them. And last occasion, Lordship, they furnished an affidavit stating therein they have complied that they have demolished the relevant gheris, Lordship. And Lordship, kindly see, just I have sent it to video clippings of the same gheri, Lordship. Nobody had visited me, Lord. Whether the affidavit perhaps not sub to me, but if that is so, my lord, it is a false affidavit before Lordship. Nobody had visited, no demolition, still that gheri is still intact, Lordship. Lordship, kindly have sent the gheri, the photographs and video of that relevant gheri, Lordship.
Is the collector there?
Yes, the collector is here.
Or
Mr.
play the video.
Samar. Puri collector.
When was this taken, sir?
Just let 1 hour back, Lordship. Perhaps it is 12:30, perhaps, Lordship. 12:30 a.m. PM, sorry, Lordship, today.
Be a case of re-emergence.
Where is the exact location? Which village is this?
Location, that is, Lordship, that source name is Podakhia, village Siandi, Lordship, that is village Siandi. And Lordship, kindly say peculiar facts. They are constructing road in between Chilka, and this is government funded land roads, Lordship. Lord, it's very shocking news, Lordship.
Department is doing the construction of that road, Lordship. Beginning from Balugan to Komandol in Chilka block, Lordship.
No, it is not.
The higher irrigation department, that is under department, they are spending money for constructing that road. It is not the private person, they are spending money for constructing that road, Lordship.
1 minute. Which village is this?
This is village Siandi, Lordship, Siandi, under Krishna Prasad block, village Siandi.
How do you spell it? SCLD. Mr. Verma, are you there?
Sir, good afternoon, sir.
Good afternoon. You watched the video just now?
I did, sir. Sir, we received a complaint regarding village Khiri Sahi area, sir. And on 16th of January, sir, the demolition was done, sir. And on 25th of February, it was again re-inquired regarding re-emergence of illegal carry, and no re-emergence was there, sir. So if this is the same place, sir, then we have taken action, sir. Further, sir, I would like to intimate Honorable Court, sir, that during the past 2 months, sir, the Gram Panchayat and urban local body elections were there, sir. The entire police machinery were minutely engaged in that
They
election.
took advantage of that then, clearly.
Sir, now the field level machinery is free for action, sir. We have already started and made a detailed plan.
No, you saw the video. This is in village CLD.
Sir, Khiri Sahi area, sir, which is where we did the demolition in January, sir.
No. Mr. Verma, did you see the video just now?
I did, sir.
This is taken just 2 hours ago.
Sir.
So will you send a team today to demolish this?
Within 24 hours, it will be demolished, sir.
So then how will we know? We'll call it tomorrow morning?
Sure, sir. I'll send the videos, etc. Right, sir.
We'll do one thing. We'll call it day after morning.
Let's see.
All right. You say Mr. Dalai has played before the court video clips showing the existence of illegal prawn gheris in village CLD in Krishna Prasad district. Krishna Prasad Tehsil.
Krishna Prasad
Tehsil, Puri district. The video has been watched by Mr. Samat Verma, the collector Puri, who assures the court that within 24 hours, these illegal prawn gheris would be immediately removed. Call this matter at 10:30, day after tomorrow.
Yes.
On Wednesday. Let's do it one by one.
My lord, I may be permitted to place IA number 18800 of 2021 at flag 117, and my counter.
You say
to
Mr.
that,
Verma will keep ready the video clips showing the same area to the court, which will show that which will in compliance with the direction. Yeah. Right. Sorry. Which IA is this?
18800 of 2021 at flag 117, and my reply is at flag 130. Mr. Kaur's petition. RP Kaur's.
Flag 117.
I've received a copy of the objection filed by the state, lords. So may I just pray for some time to respond to that? Lords?
No. Let's go on with this, because this will go on and on, Mr. Kar. What is happening? These interim orders are just stopping everything.
My lord, this is relating to 900 acres of illegal prawn gheris. They are undertaking the illegal prawn gheris over there and obtain the status quo order. My only submission in my counter affidavit, the collector has shown the affidavit that there is no lease, nothing, and it is within the prohibited zone. They are liable to be evicted, but due to the status quo order, we are unable to remove it. They are not filing any document, save and except registration certificate that it is a registered society. They are not filing any document showing that they have got any legal status so far as the lease or something else over the land in question. So they are not entitled to any status quo order. So I pray that that status quo order may be varied.
All right. Yes, Mr. Kar.
My humble submission, my lord, is this is a capture source, not a culture source, my lord. All along, my learned friend has been canvassing that these are culture sources, my lord, and they are demolishing culture sources, my lord. These fishermen, my lord, are traditional non-fishermen community, my lord. If your lordship would remember, my lord, this honorable court recognized the rights of traditional fishermen as well as non-predator.
All that is fine. But
True, my lords. But what has happened, my lord, is these people, my lord, they're engaged in capture, not in culture, my lords.
No, but capture or culture, if it is within the prohibited
No,
zone,
it's
go.
no,
Capture or culture no longer.
this is a source of livelihood for these people. my lords.
Yeah, but then
So
you have to move,
I'd only humbly pray,
you
my
probably
lord,
have to move the Supreme Court or God knows the government. Then you have to amend the law.
to my lords, but
All this is coming
since
through
your
the law.
lordships are considering Chilika as a whole, my lords, my humble contention, my lord, your lordship would also consider the economic fallout of this, my lords, because
there
these
will
people, my lord, they reside within the
See, it's
area.
gone far beyond what the carrying capacity of this place is.
True, my lords.
When we call
My
it
lord,
sustainable
after that,
development,
my lord,
everybody's jumped into the fray.
I'd only humbly pray,
Because
my
the
lord,
earnings are good, everybody's jumped into the fray.
my lords, these people are residents of that Chilika area, my lords.
Maybe even them, they have to do something which is
No,
permissible.
they have to sustain, my lords. Because
they have to do something that is both
the
sustainable
only-
ecologically, environmentally, and they'll probably
No,
have to
their
diversify
rights-
into other livelihoods then.
No, their rights, my lord, by virtue of certain inquiries conducted by this honorable court, the rights of these non-traditional fishermen and fishermen, it was
You
recognized.
have to show that you have a valid lease or a license
So
or a
what has
permission.
happened, my lord, unfortunate part of it, my lord, the government, my lord, is not
As
coming
and
out.
when what we'll do is we'll permit that we'll vacate the status quo order.
Even there is no schedule in the petition.
No,
They have
no.
obtained the status
We'll
quo
permit
without
you
any
to
schedule.
petition the government for permissions.
No, your lordship, then
If the government then the
in that
Chilika
case-
Development Authority will grant you permissions if it is all within the four
in
corners
that
of the
case,
law.
no, unfortunately, my lord, the government is yet to come up with a Chilka policy, my lord.
All right.
And once,
But
my
they are
lord,
not going to
now
permit
they're-
the illegality to
No,
come.
no, we are not, my lord, we are not there. We are one with your lordships, my lord, that the protection of Chilika has to be there.
Yeah.
Unless Chilika is protected,
The
our
minute we
livelihood.
dilute, there are some 10,000 people waiting to take advantage of that.
Yes, my lord, because by this process,
No,
others-
They
also-
simply have to show the order in your thing. You'll have everybody claiming that they are traditional fishermen doing culture.
No, this is, my lord, our rights have been recognized way back in 1994 onwards, my lord.
Yes.
This honorable court, my lord, has given an expert committee, and relying on the expert committee's report, my lord, a Chilka policy was in place.
Yes.
Thereafter, it was not extended. My lord.
Yes.
And my lord, it's that Chilika has to be protected. The ecosystem has to be protected because our
So
livelihood.
we are not going
depends-
to stop. We are not going to stop the government from framing a policy. All right, for the traditional fishermen.
But
By all
unfortunately,
means,
a
let them do
direction-
it. Till the policy comes in place, we can't say that let the status quo continue till the
No,
policy.
unfortunately, my lord, unless a mandamus is issued by your lordships,
Maybe
the
we'll
government
do it.
is never going to come out with a policy.
So we'll say that. We'll say that in our order today. No difficulty.
Then your lordship may only permit me to intervene and say, canvass my case so far as these non-fishermen community is concerned, whose rights have been already protected by lordship's orders, my lords. Unfortunately, my lord, after the Supreme Court's order, the only emphasis is on clearance, my lord.
Yes.
The area has not been demarcated, my lords.
Yes.
Rights which were recognized by this honorable court, my lord, that
My
was,
lord-
my lord, done away with.
My lord,
The
so far
Chilika
as
policy.
intervention is
please, sir,
concerned.
please, sir.
Yes.
So far as Chilika policy is concerned, it continued for a period of time, and thereafter it was not done, my lords.
Right.
And now, my lord, the only emphasis is break and smash the entire area, my lord.
Correct.
We are with your lordships, my lord, to protect. Otherwise, my lord, our livelihood is dependent on Chilka, my lords. And unless Chilka's ecosystem is not protected, the fishing shores will be destroyed for all times to come. Our livelihood is at stake.
Right.
And your lordship would also, my lord, consider this aspect, my lord. Your lordship may vacate the interim order or pass any other appropriate orders, my lord. I'd only say, my lord, that we are not into culture. We are only exploiting the capture source, my lord.
Yes.
And capture for our own livelihood, my lord. It's not that we are earning for foreign exchange for out of this, my lord. And your lordships have seen, my lord, time and again, my lord, this encroachment. And why is it happening, my lord? Because the entire area has not been demarcated, my lord. People living in the vicinity of that area, my lord, they do not know which area is Chilka, up to which area the government, my lord, is desirous of protecting, my lords. And they say we are encroachers because there's no demarcation, my lords.
We have submitted the application for demarcation in Tangi Tahsil under Lordship.
And your lordship may only.
Our prayer is that let that area be demarcated. Thereafter, they start the demolition drive on our private land where the paddy cultivation is not possible. And
One
we
by
are
one,
doing
sir.
this
One by one.
phase-
One by one,
let
sir. One by
Mr.
one. We'll
Karas
deal with this
take care
application.
once.
IA number 18 and 18800 of 2021. This is an application by the Ma Mangala Primary Fishermen Cooperative Society Limited, praying inter alia that they should be permitted to intervene in the matter by filing affidavits. Is there only one application that you filed?
No, my lords, I have filed, your lordship would take
No,
up
for
a
Ma Mangala.
flag 116. That is my application for appropriate orders.
All right.
That is IA 18797.
That is
There's
for
another
intervention,
application
I
being
think.
18797.
My interim application is 116 at flag 116.
Correct.
For
There's
appropriate
another
orders.
application being IA 18797 of 2021 by this society for a direction to the Puri district administration not to evict the petitioner's society from the Chilika Sairats and thereby allowing them to undertake peaceful thereby not disturbing their peaceful possession. Stop. The applicant society claims that after the orders passed by the Supreme Court of India on 3rd April 2017 in writ petition civil 230 of 2001, bracket MK Balakrishna versus Union of India, they've shifted to single quotes capture and quote fishery instead of culture fishery, and that their traditional means of fishing inside Chilika in no way affects or disturbs the Chilika wetland. Full stop. They are concerned that their livelihoods may be at stake as thousands of families depend on this form of fishing. Full stop. A grievance is made by Mr. R.P. Karel, learned counsel appearing for the petitioners, that earlier, pursuant to the judgment passed by this court, the right of the petitioner society had been recognized and a policy has also been formulated by the government protecting the livelihoods of traditional fishermen. So stop, he submits that after the orders of the Supreme Court, the emphasis is entirely on removal of illegal fishing farms and culture farms, with no attention being paid to protection of livelihoods. He accordingly urges that this court should issue directions to the government to formulate a proper policy. To stop, the third grievance made is that there's no proper demarcation of the areas in Chilika Lake where the petitioner society may be permitted to carry on the capture fishing practices. A reply has been filed to these applications by the state. That is flag 120.
Melon?
Flag, what your reply is, which flag?
Reply is at flag 130. Objection to the IA number 18800 of 2021. Sri Samarth Verma, Collector Puri.
Your lordship may only mark, Lord, they say culture fishery, Lord. At internal page 3, they say it's culture fishery, which I object, Lord, we are only captured.
A report has been filed by the Collector Puri to the present applications.
At flag 130.
It's at flag 130.
While it is admitted that the applicant families are carrying out fishing activities from the Chilika Sairat, the policy decision has been taken by the Revenue Excise Department of the Government of Orissa by letter dated 18 June 1999 that no lease shall be granted or renewed within the lake area, either in favor of any primary fishermen cooperative society or in favor of groups, societies of non-fishermen inhabitants for culture fishery for the time being. Full stop. Consequently, no lease has been sanctioned by the competent authority in favor of any PFCS, including the present applicant. Full stop. It is pointed out that the fishing activities carried on by the applicant society is without the authority of law and without any prior permission from the competent authority. Full stop. In other words, there is no valid Chilika Sairat which has been recognized by the competent authority. Full stop. Further, it stated that villagers of Tichini in Krishna Prasad Tehsil have constructed unauthorized zero net gheris and are doing shrimp/prawn culture in outer Chilika area, which also affects the breeding ground of natural fisheries and hampers the free movement of the Irrawaddy dolphin/fish juveniles and hampers the habitat of shore birds. Full stop. Accordingly, the vacation of the status quo order passed by this court in these applications is prayed for. Paragraph. This court has heard the submissions of Mr. R.P. Kirtland and counsel of the applicant, as well as Mr. D.K. Montil and AGA. It appears that although the applicant society is a registered society, it has no formal permission from the competent authority to carry on any fishing activity. It is also plain that after 18 June 1999, 18 June 2009, is it? 1999, no such permission has been granted to any PFCS, including the applicant. Consequently, the question of permitting the petitioner to continue with its activity, fishing activity, does not arise. Full stop. Considering the plea of the petitioner society that earlier there was a policy by the state concerning the traditional fishermen, a direction is issued to the
traditional non-fishermen. We are traditional non-fishermen.
Okay, traditional non-fishermen. A direction is issued to the Chilika Development Authority to examine the entire issue and submit its recommendations to the state government within a period of 3 months for the state government to consider whether any such policy needs to be reformulated, consistent with the judgments of the Supreme Court in the issue and the prevailing legal regime. Full stop. No further directions can be possibly given at this stage on this issue. Paragraph. The status quo order is accordingly status quo order passed by this court on
22nd of December 2021.
22nd December 2021 is hereby vacated. IA number 18797 of 2021 is dismissed, and IA number
18800.
No, 18800 is my intervention application. My interim application is 18797.
That we're dismissing. So IA 18797 of 2021 is hereby dismissed.
May I just make a humble prayer, my lords? Your lordships have directed for submission of a report by the government, my lord. At least
by the Chilika Development Authority.
Chilika Development Authority. So may I pray, my lord, this interim order to continue at least till then, my lord?
No.
Otherwise, my lord, they'll be finished, my lord. Your lordship would appreciate because they do not know any other trade.
What is happening is we make this kind of a concession for one group. We'll continue making it for everyone. Everyone will want to get advantage of this. As it is, you're seeing that. We passed some status quo orders that has continued on and on and on.
Then may I pray, my lord, let this Chilika Development Authority file its report after hearing us, my lords.
All right. It will be open to the petitioner society
let
to
them
make its
give a notice to
submissions, oblique representations to the CDA, which will give them a hearing on a mutually convenient day.
And let them submit that report before your lordship.
No.
That is.
Or your lordship may say that I may approach your lordship, my lord.
No, we don't have to give you liberties, please. You can always
my intervention application may be kept
No,
pending. No?
Not necessary. You can always file a fresh application.
No, my intervention application, because only to assist and protect the interest of these people.
So whenever there's a policy, then you can do that. You say these
But Lordship,
applications are
policies,
disposed.
cabinet has approved the policy, Lordship. In fact, policy is there. But why they are not publishing and the Lordship?
1994.
Policy is there, Lordship.
No,
Cabinet has already
apparently
approved.
after 99, there is no such.
No,
policy.
Lord. Now, my Lord, in 2000, after 2000, perhaps 13, Lordship, they have framed a policy. That is
Anyway,
there.
this affidavit doesn't say that. All right.
Like in 1994, there was a Chalika policy.
Yes.
They continued. My lords.
All right. 18,800 is disposed of. Right. Which is the other one?
My intervention is also disposed of. Beg your pardon.
Yes.
Much obliged.
Intervention is also dismissed.
Disposed of. Yeah.
No.
Then your lordship may kindly come to the last order. The complaints I have made from para 3 of the order may kindly be seen. Last order. Mr. D.K. Mantri also submits that the satellite maps for the district Puri and Khurdar for the Mahakalpur, which is under Kendrapada districts, are available with him. He states that the maps as regard the other 2 tahsil, Rajnagar and Rajkanika under the same district should be available within next 2 weeks. Mr. Mohit Agarwal, the amicus query, is permitted to inspect the aforementioned map. He has already inspected. So far as these 2 maps are concerned, Rajnagar and Rajkanika, I have filed the affidavit of the collector today in physical board. Oh, I'm sorry. On 30th March, I have filed the affidavit of the collector Kendrapada.
Have you seen that affidavit?
Yes, my lord. There are around 800 points have been identified by the
Yes.
NSCM Chennai, where probable illegal culture is going on. So they have to do the ground truthing and give us the final report.
Is the
It's a
collector
huge area.
Kendrapada here?
Kendrapada.
Good afternoon, sir.
Good afternoon.
Yes, sir. Sir, we received the NCSSM data for Rajkanika and Rajnagar, sir. 796 probable points they have pointed out, sir, for Rajnagar, and 128 for Rajkanika Tehsil with geo coordinates, sir. So
Right.
after receiving that, sir, we have formed 2 teams, sir. One team will go and verify it with the cadastral map, sir, so that the superimposition can be done.
Right.
And the second team, in a joint collaboration with forest and fishery and revenue, sir,
Right.
they will just ascertain how many actual cultured prawn gillies are there, sir, and how many are traditional farming, and also within the eco-sensitive zone, sir. So 2
Right.
teams will simultaneously
So
work.
one thing I thought we can do,
Sir.
Once you identify such of those farms now, and according to the cadastral map, which you need to demolish, you just give them 1 week's notice.
Right, sir. Right, sir.
We'll vacate the status quo order. You
Right,
give
sir.
such of those farms which you identify 1 week's notice. Then they can file whatever applications they want, whatever. Right?
Right, sir. We'll do accordingly.
I think that's the
My
best
lord,
way now
one
to go
thing.
about it.
My lord, I have filed for the Rajkanika and Kendrapada.
Right.
Rajnagar.
Right.
Their application, they have filed for permission. The DLC have recommended to the Coastal Aquaculture Authority Chennai. In some cases, intervention, I have filed 10 to 12 intervention petition. There, the Coastal Aquaculture Authority informed the interveners that approval is necessary. We are very soon issued the registration certificate. In some cases, my lord, the application is pending before DLC for consideration till today, my lord. As per the complaints report filed by the government on 16/12/2021, they have recommended most of the cases to the Aquaculture Authority, my lord. In
Whatever.
that case, my lord, your lordship might
We'll
they are
vacate,
my-
sir, wherever they are granting permission, we are not stopping that.
No, not permission, my lord. Now pending consideration is for Aquaculture Authority. Recommended
Whatever,
by-
sir, we are now vacating the status quo order. All right, because you should also, if you are getting permission, you should be able to carry on.
In
A
one-
status quo order means you can also not do anything. Suppose the authority is permitting you to carry on with your prawn culture.
Yes.
Because of status quo, you will not be able to carry it on.
Yes, my lord.
So it's better to vacate the status quo order so that you can also carry on. Suppose they are permitting you, you carry on.
My lord,
Suppose they are not permitting you, suppose they have identified your area for demolition, they'll give you 1 week's notice.
My
Then
lord,
you file a fresh petition.
1 week may not be sufficient.
No,
to
more
approach
than
this
enough.
honorable-
For
this honorable
Mr.
court,
Manoj
my lord.
Mohanty, more than enough.
My lord, one pair, my lord.
Yes.
My lord, the applications which are pending before the DLC,
Yes.
that in that case, let them consider our application either to recommend or to reject it before
Whatever.
issuing the notice for demolition, my lord.
Yes. Yes, yes.
One thing, my lord. Second thing, my lord, those applications have already been recommended. They should not issue the eviction notice, my lord,
Sir,
demolition. notice.
whenever you get some notice and you also got permission, you point out to them. If they still don't listen, you will come to us.
My lord, your lordship is fixing a date for listing of this case, my lord.
No, this will go on and on, sir.
In the meanwhile,
Where are the Kendrapada applications? You have all those applications.
Yes,
Kendrapada.
I have given all the applications, my lord. I have 10 to 12 intervention applications.
All these applications pertain to Kendrapada district.
Affidavit dated 21st December 2000, 16th
12
December,
2021.
16th December 2021. There the detailed chart is given as annexures.
Yeah. You see, as
Page
per the
12 onwards.
As per the affidavit dated 16 December
I have got a
2021 of
submission, my
the
lord.
state government, the list of applications pertaining to Kendrapada district are as under. We produce a list. In all these applications, the prayer has been for interim protection, apprehending demolition of the shrimp farm being carried on purportedly by the applicants on their own land. Paragraph. This court had required the collector Kendrapada to prepare a detailed mapping of the area with the help of satellite imagery. Stop. Pursuant to the orders of this court, the satellite images have been obtained by the collector Kendrapada. He appears in virtual mode and assures the court that within the next 10 days, how much time do you need, sir?
Sir, Rajkanika 128, sir, 2-3 weeks, sir. Rajnagar will take 1 month, sir. 796 locations for superannuation.
Within 4 weeks from today, the complete mapping, the mapping of the area of Rajkanika and
Rajnagar.
Rajnagar tehsils in Kendrapada will be completed with the help of cadastral maps so that the precise location of the farming activity can be ascertained. Full stop. Such of those farms in respect of which permissions have been granted, such of which permissions have not been granted, will be given at least 10 days advance notice, stating that if they do not themselves remove the illegal farm, the authorities will be constrained to remove it. Full stop. This will enable those who have received notices to seek appropriate remedies if they are aggrieved by such notices. Full stop. It is pointed out by Mr. Manoj Mohanty that some of the applicants are yet to hear from the authorities. That is the district
Kendrapada and Rajnagar.
What is that authority called, sir?
Rajnagar and Rajkanika block.
DLSA, is it? What?
DLC Kendrapada, my lord. DLC, district level committee Kendrapada.
The district level committee Kendrapada on the fate of their applications for permission to carry on the farming. Full stop. All such applications be disposed of within a period of 4 weeks from today, with intimations being given to the applicants. Full stop. The status quo order passed already by the court will continue till such time the above exercise is complete and any event not later than 4 weeks from today. So by which time the above directions would have been complied with by the authorities. It will be open to persons aggrieved by the notices they might receive to file individual applications in these matters. Full stop. The applications are disposed of.
My lord, one thing, my lord. In which case DLC has already been recommended to the Aquaculture Authority, my lord, Chennai. In that case, my lord, your lordship may clarify. Till the decision is taken by the Coastal Aquaculture Authority, Chennai, till then the status quo may continue.
That will be an indefinite.
That is pending, my lord. In some cases, already they have intimated on the recommendation.
Let them also complete within 4 weeks.
Yes,
sir.
that also.
Wherever recommendations have already been made by the DLSAs to the what is that?
Coastal Aquaculture Authority, Chennai.
Yes, Coastal Aquaculture Authority, Chennai, the CAA Chennai will complete the exercise of considering such recommendation and communicating its decision thereon within this period of 4 weeks. The applications are disposed of.
My lord,
I have got a submission, my lord.
Applications, Kendra Bada applications are disposed.
my lord, I may be pardoned to
I have got a
mention,
submission on
Learned
this.
ASG may be
Your
directed
lordship
to
can mention, my
communicate
lord.
this order.
My
To
lord,
the learned ASG may be directed to communicate this order to the CA because
A copy of this order be communicated forthwith by the learned ASGI to the Chilika Aquaculture Authority, Chennai. Right.
my lord, your lordship can mention the interim application numbers, my lord.
Yes, you give us the numbers and
Yes,
we'll mention it.
yes, yes,
Yeah,
I'll
we take it from his affidavit.
Yes, I will give the.
Lordship, so far as this Tahsildar Chilika, Lordship, I mean, pardon to mention, I mean, pardon to submit Lordship, the Tahsildar Chilika and the Tahsildar Tangi, in presence of the collector Khordha, they have conducted field survey and they have found that no such prawn cultivation is going on under Tahsildar Chilika and Tahsildar Tangi. That is the learned collector Khordha was appearing on the last date, he has submitted clearly. Lordship, in the meantime, what they are doing, they are in my private lands, what we are doing, they are coming, we are doing fish cultivation. That is much away from the Chilka Lake.
Which is your
they are
application
illegally
number,
demolishing,
sir?
Lordship.
1 minute.
Lordship, with the
Which is your
collector,
application number? You first start with your application number.
Lordship, 13647 by 21.
1 minute. What is this? 13?
IA number.
That's right. 13?
13647 by 21, Lordship.
No, there is no interim order in your application.
Lordship, that I pray, Lordship, what they have done, because
you just answer the question. Is there an interim order in your application?
Lordship, because there is no interim instruction to the Tahsildar Tangi, they have illegally, they have demolished my pond, Lordship.
You're not answering the question, then what do we do?
Lordship.
In your application, is there any interim order?
Lordship, your Lordship passed the order that as on to all the IAs, the no kind of status order shall be continued. That we, Lordship.
No. Which is his IA?
13647 by 21.
Wherever there's an interim order, in those matters it will continue.
Lordship, collector Khordha, he has conducted a fields, Lordship, they have sorted all the ponds randomly across.
What is your IA number? 1 minute.
13647 by 21, Lordship. Then 18110 by 21.
13647.
Now, what is the relief you're seeking? There is no interim order, so what relief are you seeking?
Lordship, we pray that as on today, what they are yesterday also they have taken the Coquelin to demolish the pond. My prayer is that
no, but unless there are some directions, what are your instructions, Mr. Monty, on this application?
Lordship, collector Khordha is in the perhaps in the virtual mode.
Copy of that petition is also not available.
You make available copies of the application.
Lordship, before filing the IAs, we usually serve the copy to the government.
So
All right, I'll serve the copy. I'll serve the copy.
Whichever your application you serve a copy, let him take instructions.
Lordship, I'm serving.
Then we'll call it out next time.
Yes.
What
That
about
may
the
be
other
recorded.
applications?
That IA may be recorded. This IA copy may be served, and I will give my response. That may be recorded.
I will give the numbers, Lordship. I'll serve the copy.
But that's not the only IA. He's got several IAs. How many IAs do you have?
10, Lordship.
See.
God.
So which are the other IAs we have to deal with?
May I submit, your Lordship?
Yes.
My Lord, this relates to Kendrapada, my Lord. Rajkanika.
So we have just disposed of all those applications, sir.
I am in the category, my Lord, out of the 16 interveners, 8 have already received their 17, my Lord, 8 have already received the permission and rest are under consideration. That is what I have been told.
So that is all covered by what we have dictated just now.
Yes, that is what your Lordship has indicated.
So just
I'll be covered under that.
What are your numbers, sir?
Flag 75, your Lordship.
Only one IA?
Yes, my Lord. 8648.
Millard, I have also filed 10 number of cases.
Kendrapada.
Millard.
You give us the numbers.
I'll give the number, Millard.
Just take down all those numbers.
And regarding Millard, one IR number 7321 of 21 at flag 65, Millard. Your Lordship, kindly see. In that case, the government has filed counter. I am cultivating the prawn culture on my own land and it is outside the coastal area, Millard. So no registration is necessary. Your Lordship, kindly see.
No, they have admitted that you are outside the area.
Millard, in their counter.
Get the number.
IR number 7321 of 2021.
7321.
At page 12, Millard.
1 minute, sir. 7321.
At flag 65.
Private comment.
Private land on lease inside.
Inside. Page 46 may kindly be seen. It is clearly noted that it is inside the coastal area and no registration is available. So far as
He's
this
saying exactly
page
the opposite.
46.
You are saying exactly the opposite.
What he is saying, that is exactly the opposite we have stated in my affidavit, in our affidavit.
Millard, Your Lordship, kindly see page 12. Page 12 of their counter. Millard, IR number 7321 of 2021. Lilima Maiti. Millard, the aquaculture private land outside the coastal area.
7321 is Vibhuti Mandala.
No. Lilima Maiti. IR number 7321 of 2021.
Oh.
The 7 number of the petitioner are doing the prawn culture in the one land and outside the coastal area. So no registration is necessary.
Outside coastal area, but no registration.
It is outside. They have applied for it is pending before the DLC.
It's not necessary. Once they're outside the area, they don't need permission. Is that not right?
Not permitted. My lord, may kindly see the last column. Whether violated any provisions of CA Act. Yes, coastal aquaculture beyond coastal area not permitted on section 13.4, 13.1 and 14 of CA Act 2005.
No, my lord.
That is
that section does not provide any restriction, my lord. Your Lordship, kindly see 13.1 of the Aquaculture Authority Act, my lord. One said, save as otherwise provided in this section, no person shall carry on or cause to be carried on coastal aquaculture in coastal area or traditional coastal aquaculture in traditional coastal aquaculture farm which lies within the coastal regulation zone referred to in subsection 9 and is not used for coastal aquaculture purpose on the appointed day unless he has registered his farm with the authority under subsection 5 or
if it is not within the zone, then this doesn't apply.
My lord,
if it's beyond the zone, it doesn't apply then.
The species culture is Vanamai and P. monodon. This is required for registration, as I understand from Mr. Dare, he is saying. Actually, I have no idea.
Even if it is beyond the zone. Beyond the zone, why do we need permission?
It is beyond the zone. What has been reported?
Why do you need permission if it's beyond the zone, sir?
Beyond the zone, your lordship heard the matter at length and came to conclusion. Beyond the zone, it is not necessary.
Correct.
Your lordship heard the matter.
Otherwise, there's no meaning, sir. If within zone, beyond zone, then the zone has no meaning.
Yes. Yes.
So 7321, IS 7321. The reply, as far as this application is concerned, is that the activity is being carried on the applicant's own land and beyond the coastal regulation zone. In that view of the matter, the application is disposed of by directing that the applicant need not be disturbed and is not required to obtain any permission or registration for carrying on the activity. So what are the other, you've mentioned only a few for vacating status quo, not the others.
No, all the IAs I have mentioned in that last affidavit, 16/12/2021. The summary of all the IAs, page 12, annexure 1.
All right. So as far as the remaining applications in that IAs, in that 16,
All
12,
the IAs in annexure 1 series.
these applications.
There are total
disposed of,
16 number of IAs.
Yeah, by directing that whenever the authority decides to demolish an illegal farm after completing the mapping exercise, 10 days advance notice will be given to individual farm owners. To wherever applications are recommended by the DLCs to the CAHNI, the CAHNI will dispose of such applications not later than act on such recommendations and communicate its decision not later than 4 weeks from today. 3, till such time the status quo order passed by this court will continue. The applications are disposed of.
All the 16 IAs may be disposed of.
Yeah.
May I pray, my lord, all the certified copies may free copy may be supplied to the office of the ASI in order to supply.
So you collect it, sir. You collect it, just send a pen drive and you collect it.
My lord.
My lord, in that affidavit, my lord and brother has not mentioned my interim applications.
You
And I
serve him a
am
copy, he will mention. You give him a
I
copy.
number at flag 112 and 113, 18360 and 18661. My lord, the land was provided by the government to the fishermen.
You give him copies, sir.
Since last 7.
You give him copies of the application.
Yes, I have already sought my lord copy. And a status quo is there, my lord, in my application.
We'll take instruction in those 2 IAs, we will file reply. Lordship may mention the numbers of those 2 IAs.
Which are the 2 IAs, sir?
18360 and 18361. Flag
Copies of these
112
applications be supplied to Mr. Monty, learned AGA, for him to obtain instructions.
Tahsildar Chilika. Under
All right, call on Friday, 10:30. All right.
My lord, I am giving.
My lord, status quo continue in that.
If there is no status quo, it can't continue.
My lord, my I am continuing.
Let's see, before Friday, if they demolish, you can come to us.
No, my lord. Your lordship may kindly bear. They have not filed counter, my lord.
Correct.
They have to take
We are calling on Friday, sir. Right.
Till Friday, my lord, the status quo.
My lord, I am giving that 12 IA numbers which have been disclosed.
So you have to make sure all these IAs are taken off from the list.
My lord,
they should continue in the list.
My lords, we have filed 3 affidavits today. Collector Khurda, Collector Puri, and Collector Ganjam. Your lordship may indicate in the order. These in physical mode I have filed hard copies.
The affidavits filed by the collectors of Puri, Ganjam, and Khurda are taken on record.
Lordship, I mean, pardon to submit lordship, under Tahsildar Chilika and under Tahsildar Tangi, they have conducted field survey. They are not any kind of prawn cultivation, and they are now going to demolish these ponds, lordship. They have already demolished few, and the balance.
Give your applications to him, sir.
Lordship, I am
let him take the instructions. We call on Friday.
In the lordship, what I pray, they are present at the ponds, lordship. They will demolish. What I pray. Till that date, the status could be continued. In the
Friday, we are calling it no more interim orders. We are calling on Friday now. Yes.
Lordship, Dr. Adish Agrawal is there, Lord Senior Counsel. Lordship will address, I think we may address is there.
Now no need when you let it Friday. Permit us, yeah, Friday. Yeah, yes. Okay, madam.
As a Lordship, please.
Weekly list, item number 19.
Interim order is there. Interim
That's also we passed this orders.
My lord. Special weekly list, item number 19.
Interim order continue till Friday, my lord.
So between today and Friday, if something dramatic happens, you come to us. The only dramatic things that are happening, according to us, are new farms are coming up everywhere. All right.
No, sorry.
You tell your clients not to start putting more and more farms. That you tell them.
No, my application is not in connection with Chilika. The Palur Canal is concerned.
Whatever, sir, it is all about illegal shrimp farms, correct?
No, I have a license.
Very well,
I'm a
sir.
licensee.
All right.
I'm a licensee.
All remaining matters on Friday. Right.
Intermediate to continue, my lord.
Yes. Let us see what happens between today and Friday. All right.
My lord,
Sorry? 6th. All right. Day after.
Item 19, special.
may I please, your lordship. Under that other day, the similar matters has been decided by my lords only to the extent of compensation which has been ordered by the learned labor code is 25,000. My lords has been pleased to enhance it to another 25. I am supplying that copy of the order. The same
same order except the dates will change.
My lord, only
The name only
your
changed.
lordship, their lordship has considered he has completed 13 years of service. That is why your lordship has a 25,000 compensation has been awarded, my lord. But here he has only 7 years service.
It's all right.
That is only.
It's all right.
Special request item now 20.
20 minutes, please, your lordship. Lordship, it's a rather small point is involved. The opposite party number 1, he filed an application before the labor code under section 33C2, claiming differential wages, unpaid wages at differential rates for a particular period of time. Thereafter, the impugned order, lordship, may kindly have a look. It's at annexure 4 at page number 23. Actually, let me begin by saying that the amount involved here is 90,000. It's a paltry sum. I will not be going into the merits of the case. I just have to bring an issue of law before your lordship. The lordship kindly sees page number 24 of the brief. At para number 4, the learned court has fixed up 2 issues for consideration. First one being whether the applicant was working as a night watchman under the opposite party society, and second being whether the applicant is entitled to the amount as claimed. Now, the lordship, there's a long line of judgment passed by the Honorable Supreme Court, which says that a proceeding under section 33C2 is essentially in the nature of an execution proceeding.
So there must be an award first of all.
Lordship, predetermined, I have given those judgments, the latest of which I have found.
You say considering that the amount awarded is not very substantial, the court leaves the question of law raised open for decision in an appropriate case. The order is vacated, the petition is disposed of.
Special request item 21. Special request item now 22.
Item 22, Mr. Ashok Mishra is on VC Hill address for the opposite parties.
No. Who's for the petitioner? Who's for the petitioner? None appears dismissed non-person.
Item number 23.
My lord, may I mention? My name may kindly be mentioned. Ashok Kumar Mishra.
All right.
Item 22.
All right, sir.
Item 23.
Mr. Sungaduji may accommodate my lord. He has gone to Gujarat some personal difficulties.
You argue, sir, if you want to. Item 23.
22, my lord.
22 we've called out, sir. You argue if you want to.
The challenge was made to the hour at Annex 1 that is dated 22nd October 2010 passed by the CGI from Labor Code of Hunsur.
Right.
Where they turned down the refer dispute and disentitling the workmen to be regularized. And your lordship only on the ground that is your lordship is finding because there is in the High Court, in this Honorable High Court, some employees, there is a Delhi Voyager and Kaju and of a messenger category, they came before Lordship for a regulation of their service. And this honorable court has been declined, that it is rejected, and they, as per the bipartite settlement, they are not being regularized, my lord. By taking that advantage, only on the basis of the judgment of this honorable court, if the petitioners, only petitioner has not been regularized, and they answer the negative to the reference, my lord. Your lordship may kindly see the admitted position, my lord. The finding at.
But you did not come out successful in the interview, sir.
My lord, that I call you,
Ah,
the lordship.
that's the end of the matter.
My lord.
You were not successful in the interview.
No, that is, my lord, I am selected in interview. In the 1988, I was faced the interview, I was selected.
Not in 88, sir, subsequently.
My lord?
For the purpose of regularization, you had to be successful.
No, that I am calling, my lord. You will also may see how it is perverse, the total finding is perverse. And if the wow is based on the perverse finding, my lord, you will also may kindly see the only the labor court descended the applicant for the regulation only on the basis of the judgment passed by this honorable court in the OJC number. You will also may kindly see that is page 17.
2787.
Yes. And whereas this work is not involved. And this matter was regarding the regulation of messengers. Messenger category who are working as casual, temporary and daily wages, my lord. But not petition was appointed or engaged as a cook cum canteen boy, my lord. Cook cum canteen boy. Your lordship may kindly, that is admitted question, and that your lordship may kindly have a glance. Page 11. That is the fine. Issue number 2, they have decided. It is an admitted case of the dispute and workman that he was appointed as a cook cum canteen boy in the zonal office canteen on the State Bank of India at Bhubaneswar after being selected in an interview held on 2/3/1988. Thereafter, he was given employment as temporary cook cum canteen boy for 15 days from 18/7/88 to 1/8/98 with the condition that the appointment may be terminated earlier at the bank's discretion without assigning a reason and shall come to an end on the expiry of the aforesaid period. His appointment was extended from time to time and has been continuing till date. During this period, for a little spell of time, he worked on daily wages. So, my lord, thereafter, my lord, what his service were not regularized, though the chief manager, the Office of Administration, by his letter at 10/10/95, marked as Exhibit 7, who wrote to the chief manager personnel of the State Bank of India, Journal Office, Bhubaneswar, to make necessary arrangement to fill up the vacancy of the canteen boy by posting permanent comments. She also quoted the name of 5 temporary canteen boys, including the name of the disciplinary workman who have been working since July 1994. So, my lord, it is admitted that I had faced the interview on I was selected. And I am working in the bank, and I am working employee of the bank. You will also may see that is also common. So, also page 14, my lord. That is finding of the CGI, my lord. The canteen is managed by the management of the State Bank of India, where there are more than 100 employees. The management would know two Srimant Kumar Das has also admitted in his cross-examination that the canteen is a bank-run canteen. In view of it, the first party management cannot deny the fact that the disputed workman is a State Bank of India employee. So, we will also make page 14, my lord, last paragraph. Thereafter, my lord, para 10, my lord, there is a statement of management witness number 2, Sri Simanta Kumar Das, where he has stated that the writ application was for the only messenger. There is a statement of management witness 2, Sri Simanta Kumar Das, in his cross-examination that the judgment of the Honorable High Court marked as Exhibit J is in respect of temporary messenger, but not in respect of the canteen balls. So, and your lordship, the last finding on which basis the Lawrence CGIT decentralized the workmen to be regularized only on the basis of the your lordship, the Honorable Court judgment that is passed in budget number 1, my lord, that is 271. But here your lordship may kindly see each witness, their witness, my lord, bank's witness has categorically stated that it is for the only messenger, not for the canteen ball.
Anything else, sir?
My lord, your lordship, and I have cited some decision.
All right.
Paragraph 11, page 16, my lord.
All right.
Before the Lawrence CGIT come labor court, my lord.
All right.
He has not dealt this only all these decisions only on the ground that this issue, the regulation has already been decided by the Honorable High Court.
All right.
Only on that point.
Okay.
Your lordship.
And
the only finding is based on the basis of the judgment of the Honorable Court, my lord. Whereas their witness stated that is your lordship, that is the Exhibit J, your lordship can see this is only for the messenger who are working as casual, temporary, and also daily wage basis. Their case was decided. But my case, I was selected, your lordship, I was selected by interview in 1988 and worked continuously till, my lord, pass of hour, my 2001, my lord. Till that day, I have continued. Till now also, I am continuing, my lord, with the full wages.
All right.
With full wages, except some benefit they have not given, my lord.
All right.
I am going to retire only 2-3 years, my lord. They are left. And for 34 years, from 1980 till today, I am continuing, my lord. At that time, if I will not regularize, what I am continuing, my lord. So, lordship may consider.
May I please, your lordship, may I add, my lord, little, if your lordship permit me?
Yes, yes.
My lord, this, my learned friend said that the matter was not hard. The OJC number is 4928 by 97, 4928 by 98, 29 by 97. There is a bunch of cases OJC which were all hard together by your lordship's court, and ultimately common judgment was passed. And where he might be a messenger, I don't deny that. But a common judgment has been, and now coming down to the 140 people who are regularized from the ad hoc employees or daily wagers, and out of till 97 the list was valid, and both these applicants were not qualified. They could not succeed in the interview, and that is why they could not be appointed. My lord, thirdly, I would like to bring to your lordship kind attention. The case was represented by the secretary, general secretary of the union. And here the case has been filed, maybe a technical issue. Your lordship may ignore it. I don't say no. Here the Prafulla Chandra Das.
So that is not a, yeah, that's okay.
I understand. That is why I said your lordship may.
Yes,
so,
yes. All right. We're anyway not with the petitioner.
No, and one Supreme Court has also, the matter was carried to Supreme Apex Court. Apex Court also dismissed the matter. And now they have again, with surreptitious way, they have again come out with a industrial dispute.
All right. All right. The petitions are dismissed. We'll pass the details. All right.
Special vehicle list item number 23.
There is item 2, my lord, that I will not press because he has already retired. Second item is there.
Second item, you say, counsel, the petitioner states that the petitioner is already retired.
Second one.
The petition is disposed of. Right.
May I please? The management is the petitioner challenging the award of the Land Labour Court. By the informed award, the Land Labour Court has directed for reinstating the workman along with full back wages. And at the time of filing the writ petition, the workman was aged about 50 years. And in the meantime, more than 10 years have elapsed.
So he'll get only back wages, sir?
Yes, back wages. There is no finding that she was unemployed anywhere else.
Anyway.
So in view of the latest judgment, you
all right. You say the challenge is the present petition by the Executive Engineer, National Highway Division, Berhampur, is to an award dated 8 July 2010 of the Labour Court, Koraput, industry case number 9 of 2008, whereby the petition has been asked to reinstate the opposite party workmen with back wages, with full back wages, by an order dated 17 May 2011 to impugn award the states. Stop. That interim order is continued. In the meanwhile, the opposite party is already attained the age of superannuation. The question of reinstatement in service therefore does not arise. Opposite party number 2 has superannuation. In that view, the matter, the court is not inclined to interfere in the matter.
Only one thing, Your Lordship, kind on to page 20.
Yes.
There is direction issued to pay the full back wages till the award is executed. So that portion, Your Lordship, kindly modify. But since she has superannuated in the meantime, so Your Lordship, confirm till the date of superannuation.
The back wages will be payable till the date of such superannuation. The petition is disposed of in the court.
Special weekly list item number 24.
One more, Your Lordship, add that this shall not be treated as a precedent.
No, there's no need. I think we do overdoing all this, sir. Yes.
Item 24.
None appears dismissed on opposition.
Special weekly item 25.
Lord, I am for OP number 3, my lord.
All right. None appears dismissed on opposition.
Special weekly item number 26.
My lord, no instruction on behalf of the petitioner.
No instruction disposed of.
Special weekly list item 27.
None appears dismissed on opposition.
Special weekly item number 28.
None appears dismissed on opposition.
Special weekly item number 29.
My name is
recently appeared for the petitioner and my name has not been reflected in the
Can't hear you, sir. Please remove your mask and talk into the mic, sir. Remove your mask and talk into the mic.
Lord, I only pray for 2 weeks time because I recently appeared for the petitioner. I filed for Kaladar, but my name has not been reflected.
It's all right. You are there, sir. Despite your name not being reflected, you are right now present before us. What is the matter about?
Lord, the petitioner was an employee of this honorable court and he retired on 30th April 2007, my lord. At that time, the old pension rule was there. Rule 47 of which provided that a person completing 33 years of qualifying service will be entitled to 50% of the last pay drawn as pension. But after the 6th Central Pay Commission, state government revised the scale of pay of the state government employees, and it came into effect from 1/1/2006. The petitioner who retired in 2007, April 2007, he also got the revised scale of pay. And thereafter, the state government revised the pension and pensioner benefit of post-2006 employees. And may kindly turn to page 9, Annexure 2. In pursuance of recommendation of the 6th Central Pay Commission, so and so, my lord, the report of the Pitment Committee, the government examined matter having regard to the recommendation of the Pitment Committee, the state government have been pleased to revise the pension, family pension, my lord, that is more important, with effect from 1/1/2006. And gratuity and commutation of pension with effect from 1/12/2008 in the manner indicated in the subsequent paragraph. In this revision, my lord, government took a decision that if, an employee after completing 25 years of service will get full pension, that is 50% of the last pay drawn. But in the subsequent paragraph, which is at page 10, here the government prescribed the revised provision for calculation of pension in para 2 to above shall come into force with effect from 1/12/2008 and shall be applicable to the government servants retiring on or after that date.
The petitioner retired after coming into force of this rule, that is from 1/1/2006. But by virtue of this restriction, he has been denied full pension. So in my humble submission, my lord, once the OCS pension rule stood revised with effect from 1/1/2006, the benefit flowing from such revision should be made applicable to pensioners from that day itself. Government cannot select one group and give benefit to one group and deny the benefit to the other group.
Lordship, can you turn to paragraph 10 of the counter affidavit filed by the opposite party number 2?
Paragraph 10.
Yes, my lord. This is by the finance department, opposite party number 2, paragraph 10, internal page 8.
Yes.
May place me.
Policy decision.
Yes, it is a policy decision of the state government. Such decision of the state government should not be interpreted as irrational and arbitrary. It is pertinent to mention here that after fitment committee recommendations and approval of cabinet, finance department, government of have issued circular dated 19/1/2009 indicating therein that a government servant who retired on or after 1/12/2008 shall be eligible to avail full pension on completion of 25 years of service instead of 33 years. Such liberal approach of the state government cannot be treated as irrational. State government has allowed revised commutation of pension with effect from 1/12/2008. That upon quantum of additional pension available to pensioner has been increased with effect from 1/12/2008. Further, also the additional family pension to old family pensioner is effective from 1/12/2008. Enhanced family pension in case of deceased government servant has also been extended up to 10 years with effect from 1/12/2008. State government, looking at its own financial resources, has passed the resolution on the basis of recommendation of the fitment committee.
No, but the fitment committee recommended from 1/1/2006.
Yes.
Then change was to be for anyone who retired after 1/1/2006. Where did this 1/12/2008 come from? There seems no rational basis, sir.
Paragraph 8, though, have stated, but not in specific terms, why this date, cut-off date of 1/12/2000 has been taken.
There must be some logic to it.
Paragraph 8, you can say. Some retired employees represented the state government with prayer to extend the benefits of enhancement of maximum limit of DCRG and adoption of new method of commutation of pension with effect from 1/1/2006 instead of 1/12/2008. While the issue was under consideration of the anomaly committee appointed by the state government, the applicants in OA number so and other identical cases filed OA cases before the land OAT Bhubaneswar challenging the aforesaid resolution issued by the finance department. In OA number so and so and other batch of cases, the land tribunal by the order dated 27/7/2010 issued the following direction. In due deference to the orders of the land tribunal to take a decision by the state respondent, the duly constituted
So this all
anomaly
goes with the pay commission recommendations. Usually that happens from 1st January 2006.
Why this date has been taken?
Suddenly, arbitrarily, you can't just have on 1/12/2008. Where do you get it?
Well, let me grant some time. I will come back. What is the basis of
May I submit, my lord? The same was the principle of the state government with regard to DCRG. Before coming to force of the new rule, the amount of DCRG maximum amount of 2.5 lakhs. But the state government took a decision to enhance it to 7.5 lakhs and extended that benefit to the employees who retired after 1/12/2008. Some employees approached the tribunal. Tribunal disposed of the case with a clear direction to take a positive stand, positive decision. Thereafter, state government took a decision that DCRG and DCRG will be available to all the employees retiring after 1/1/2006. Only with regard to the pension, that restriction is there. They have given revised scale from 1/1/2006. They have given DCRG from 1/1/2006.
Doesn't make sense to have 1/12/2008, sir.
Let's grant one opportunity so that I will come back. What is the basis of fixation of 112?
All right, Mr. Mudali wants one more opportunity to explain what is the basis of fixing a further cutoff date of 1/12/2008 for extension of the benefit of revised pension, consequent upon the revision of pay scales with effect from 1/1/2006. That is request list on 30th June, 30 June.
Special weekly list item note 30.
None appears to Mr.
Special weekly list item note 31.
May I please have in the present case, the applicant before your lordship, my lord, he has filed his objection to the award. Your lordship will you may kindly see the land acquisition award in Annex 7, my lord. To that, I have submitted my objection that I have purchased a portion of the property.
You want a reference to be made under 18 and 30.
Right,
correct? But that must have happened by now, sir.
It has not happened, my lord.
The petition has been pending for 11 years. How can it not have happened? Petition is pending for 11 years, sir. By now it would have happened.
My lord, since he has refused in Annex 7, my lord, so after issuance of notice, there is no reference as yet, my lord.
How can
there is a limitation for section 18 now?
Yeah.
Yes.
Within the period of limitation, he has to lodge the.
What was the date of the award?
The award date,
42 days. 42 days from the date of award.
No, what's the date of the award?
Date of award is 30th 11 2000. 1 minute. 30th 11 2010.
How many days you have to file the revision? Section 18 reference. What's the limitation for that?
42 days.
42 days from the date of receipt of the notice, my lord.
12 to notice.
12 to notice. Here, since my application was rejected in Annex 7, my lord, immediately I have served Annex 8, my lord.
Annex 7 is the award, sir.
Annex 7 is the award on my objection. I have filed an objection that I am entitled to the amount, compensation amount because of the award, my lord. So that was turned down. That is on 30th 11 2010, my lord. So immediately I filed Annex 8, my lord, to make a reference, my lord. And since it was not, no response was made, my lord, I have filed immediately the writ petition.
Lords, may kindly see page 51.
Yes.
The date of 12 to notice is blank. And again, your lordship may kindly see page 53. The date of filing 54. Filing of the section 19 application is not also mentioned here.
Without those details, it's not possible, sir.
The dates are conspicuously absent. So limitation is that is a statutory limitation.
Correct.
Beyond 42 or even 43rd days, the objection cannot be this.
Correct.
18 reference cannot be.
But your lordship may kindly see the language. Either it must be decided, the award must have passed in my presence, or it is communicated to me. Let the language is like this, my lord. So either if it is a notice under section 12 is given to me, then 42 days from the date of notice, my lord. But here there is no communication.
And in add to it, your lordship will find the awardees must have been received the compensation amount in the meanwhile. And the chapter must have been closed because it is a case of 2011.
Correct.
The awardees are also, they are made opposite parties, I think, my lord.
Yes, because in 2010 the award was passed. Immediately
the awardees are also present through their advocates.
the objector, they have also
they have already received the award amount.
Despite of the pendency of the writ petition, my lord.
And there is no interim order here, sir. There is no interim order passed.
There is
here.
no, although there is an IA filed by the petitioners for stay of
IA was
disbursement.
filed
No
and
stay
it
order passed by this court in these proceedings. The award is dated What's the date of the award, sir?
30/11/2010. 30/11/2010.
It is not clear whether the applications seeking reference under sections 18 and 30 of the Land Acquisition Act 1894.
Lord, the date I have mentioned in the writ petition, when I have given annexure 8, that is 15/4/2011. Lord, so may
That's
kindly
beyond
see.
42 days, sir.
Milord, 42 days from the date of notice, Milord.
When did you receive notice?
Milord, there no notice to me, Milord.
No.
Milord, that is exactly the language reads, Milord. Lord, so may kindly see section 12.
Without notice on your own, you filed objections.
Milord,
and you sought a reference.
Milord, because it was turned down, I immediately on 15/4/2011.
It's not immediate, sir. It's beyond 42 days. That's the whole point.
Milord, after receipt of the certified copy, Milord. Milord, after receipt of the, since it was not passed in my presence, it was never communicated to me, Milord.
When did you receive?
That is the requirement. Certified copy I have received, Milord. Lord, so may kindly see.
And it seems there is a civil suit between both the.
Yes, that is why I have filed. In the objection, I have stated a civil suit is pending.
If in the civil suit,
Milord, it was received on 26th.
The compensation has already been disbursed.
Milord.
My lord,
So once a civil suit is there, the compensation is already disbursed, sir. So you can.
Your Lord, so may kindly see. It was given to me on 26th April 11. Prior to that, I have given annexure 8, Milord.
My lord, civil suit is pending. Compensation is already disbursed. So if in the civil suit he gets a favorable decree, he can realize his share from the awardees who have been benefited by the impugned award. There before this honorable court.
It appears that the persons who have benefited under the award have already received the compensation amount. It also appears that the civil suit pending between the persons who have received between the present petitioners and the persons who have received compensation, leaving it open to the petitioners to work out the remedies in the pending civil suit. The petition is disposed of.
Special weekly list item 32.
My lord, sir, it's a no instruction.
No instructions disposed of.
Special weekly list item 33.
My lord, in item 33, my lord, the management has filed this writ application challenging the award passed by the industrial tribunal, my lord. Your lordship may kindly come to running pay. Here, my lord, admittedly, she was a daily wages employee and her engagement as and when required basis, my lord. Your lordship may kindly see, and for violation of 25F, my lord, this award has been passed. Your lordship may kindly see running page 14, internal page 4 of the award, my lord. Towards last, my lord, it starts with, I found that the provisions
for the opposite side.
My lords, I am appearing for the sole opposite party.
For the
sole opposite party, my lord. Workmen.
All right.
May I place, my lord? I found that, your lordship, towards last 1, 2, 3, 7th line from the bottom, my lord. Internal page 4, my lord. Running page 14, my lord.
Yes.
Award, impugned award, my lord, I am placing.
25F has been violated.
My lord?
It says provisions of section 25F has been clearly violated.
My lord, I am placing towards last, my lord. 7th line from the bottom, my lord. It starts with, I found that the provisions of section 25F of the Industrial Dispute Act has been clearly violated by the management in terminating the service of the workman who has seemed to have been completed 40 days. My lord, on a presumptive finding, my lord, and continuous employment is the, my lord, that is the mandatory requirement for the 25F, my lord. And on a presumptive finding, my lord, he saddles this burden on the state, my lord. She himself is not sure that she has continued 24 continuous employment.
My lord,
240 days, sir.
The
240 days,
my lords, working as after death of her husband, my lords.
Did she work 240 continuous days? What proof did you place?
Not a single paper.
1 minute, sir. We are asking him the question.
I'm so sorry.
My lord, both opposite party and petitioner leading the evidence of this before the industrial tribunal. There is no filing any documents, my lord.
Not?
No documents filed before the lower court.
Then how do you justify the finding then? You say the challenge in the present petition is to an award dated 31st July 2010, passed by the Labour Court, Bhubaneswar, in industrial dispute case number 27 of 2004. The dispute referred to the Labour Code for adjudication was as under. Taking correct to view. The Labour Code has, while answering the issues and examining evidence, come to the conclusion that Section 25F of the Industrial Disputes Act 1947 (ID Act) stood violated since the workmen, open quotation, seemed to have completed 240 days of continuous service in 12 calendar months preceding the date of a termination, unquote. Even the learned counsel of the workmen is unable to point out what documents were placed on record before the Labour Court in support of the plea of the workmen that she had served more than 240 days of continuous service. She had performed more than 240 days of continuous service preceding her termination. The most critical finding in the award is based on surmises and conjectures and not on evidence. Consequently, the impugned award is unsustainable in law and is hereby set aside. The petition is allowed with the above terms.
Special equalist item 34.
I am appearing for the opposite party, NHA.
Special equalist item 35.
My lord, no instruction.
No instruction.
Special equalist item 36.
None appears.
Special equalist item number 37.
36, my lord, I am for the opposite party, my lord, CDL.
Item 37.
Item 37, and for the petitioner, in this case, notice was issued, matter relating to release of a compensation due to acquisition of land and the damage of vital vines of the petitioner, my lord. And they have prepared a list where the name of the petitioner is found place, that is Annexure 1, page 6, my lord, at serial number 531, page 7. Kindly have a glance, my lord.
What was the date of this acquisition, sir?
My lord, that is 34/2008, my lord.
What were you doing? You filed it more than 3 years thereafter.
Now, thereafter, he has approached my lord.
My lord, this is relating to POSCO. That project is already closed. And
the land has been acquired by the government.
Land has been acquired again for the second purpose, JSW, and he can approach the concerned authority for that. This list which he is showing, that is no more in
the cause of action as
liberty may be given to
does not survive any longer.
Man.
And therefore the petition is disposed of.
Second one is also same. 38 is also same.
Same.
Special equalist item 39.
My lord, in this case, the order passed by the appellate authority under 127 of the Electricity Act is under challenge, my lord. My lord, the impugned order is, my lord, is under Annexure 25. My lord, without any reason, my lord, the order has been passed. My lord, may I have a glance to Annex page 25. My lord, just by recording the submission and the counter submission of the parties, my lord, though the observation is given rightly, my lord, I am pressing all the seals of a metering system are broken. Energy meter might have been tampered since the meter readings has come slow from the month of 3/10 in comparison to the preceding 3 months and the succeeding 3 months from the date of installing new energy meter. The average consumption is this much per month assessed from succeeding 3 months from the date of installing new meter. The sole responsibility for what's the word of energy meter cannot be thrown upon the consumer since the meter is installed outside the consumer's premises. It is a mobile tower, my lord. He has taken power supply, a TP box was installed. Inside the TP box, my lord, meter was installed. And during verification, my lord, it is found that the TP box is broken. All the meter seals are broken, my lord. That is why following provision under 126 of the Electricity Act, my lord, a provisional assessment was made. And my lord, thereafter a final assessment was made. Against that, my lord, the consumer has moved the appellate authority, my lord. Not when, my lord, admittedly there is tampering of the meter and because of the consumer's interference, my lord. But how could he say that it is outside the premises, my lord? It is a mobile tower, my lord. Without knowing the meaning of that premises, my lord, it also includes a land, my lord. And a power supply has been provided to the mobile tower. And by the side of the mobile tower, he has selected the site and a meter was installed inside the TP box, my lord. Consumer being the custodian of meter, he has no right, my lord, to interfere with the licensed meter. If it is interfered, cannot be said that other than the consumer, someone has interfered, my lord. But the premises, my lord, as defined, my lord, under the Electricity Act, my lord, it is premises includes under section 251, my lord, it includes any land, building or structure, my lord. My lord, how could, my lord, the appellate authority will say that it cannot be said that the consumer has not interfered with the meter. It is admittedly, my lord, he has recorded the finding, but my lord has given a wrong order that he is not liable to pay and therefore has passed the order. Your lordship may see under section 51, under the regulation 51, my lord, of OERC distribution conditions of supply code, my lord, the license is authorized to enter into the premises for the purpose of checking, inspection. My lord, if accordingly, my lord, in access to the consumer's premises, it was regulation 51. Regulation 52 says, my lord, if the consumer disputes with the findings recorded by the investigating squad, my lord, he has a right to approach the designated authority of the licensee within 1 month of such detection, my lord, if he disputes. My lord, in this case, he never disputes that, my lord. The verification report, which is the basis, my lord, of proceeding under 126, my lord, that was never challenged nor questioned before the appropriate authority within the time limit of 1 month as provided under regulation 52, my lord. But my submission is, when the very basis is remained unchallenged, my lord, and on that basis the assessment was made, my lord, the finding of the order of the appellate authority is not only perverse and illegal, but is without any basis, my lord. There is no reason was assigned, my lord, while passing this order, my lord. Your lordship may kindly.
Let him answer.
Before going to the answering the submissions.
Not able to hear, sir.
Before answering the submissions made by my learned friend, I just want to bring it to the record that during pendency of this writ petition, my lord, the business of this ATC, mobile tower business has been transferred to one ATC Telecom Infrastructure Private Limited, and had with effect from 31st.
You're not appearing for them.
But I am not appearing for ATC. Notice has to go.
Lord, it is, the consumer who has entered into an agreement with us, my lord.
That entity is not there, sir.
The entity is not there.
The ATC has filed the appeal, my lord. He has filed the appeal, he has executed the agreement annexure 1, my lord. My lord, if he has transferred it to someone else, my lord, then, my lord, it is his.
What is his? This is not some individuals. This is company's takeover, sir. You have to implement the new company.
My lord, then he has to appear, my lord.
Who has to appear? From where? Who will appear? If you do not want to take steps, we'll say you're not willing to take steps.
My lord, the company who has
from 31st March 2018, it has been transferred and communication has been made to the authorities concerned.
My lord, he certainly he has to take the liability, my lord.
Who is he, sir? What is this company law? You don't understand then. Who is he? First of all, these are companies. There is no he, she.
Then, my lord, your lordship may grant some time. I'll take notice, my lord. Because it is not coming. It is now forthcoming from each side that it has been transferred, my lord.
First of all, don't use he, she so casually. We're talking of companies. All right, companies don't have he, she. They're not individuals. These are companies.
Yes, my lord.
One company has taken over another company.
My lord, is Vodafone SR. Mr. Vodafone SR Space Tels Limited.
Correct.
My lord, he has entered in an agreement by the annexure 1, my lord. He has interfered. He has done everything.
Not he, sir. There is no he. It's a company.
That company, my lord.
Now, once your language changes, your concept will change. Now, this IT company has been taken over by another company. All right. This company does not exist now. He's giving you the new entity's name.
Yes, my lord. Then, my lord, liability will certainly go to him, my lord.
I see. You have declared. You have not even seen the agreement by which it was taken over.
Then, my lord, I will take steps for taking notice to it, my lord. The subsequent company who has taken over the charge.
So what's the name of the company?
ATC Telecom Infrastructure Private Limited.
Okay. Counsel for the opposite party, number one, informs the court that a new entity, that is ATC Telecom Infrastructure Company Limited.
Private Limited.
Company Private Limited has taken over.
With effect from 31st March 2018.
Opposite party number one, with effect from 31st March 2018. He has provided the details to the counsel of the petitioner, who needs time to implead the new entity as a party. That is a request list on. You file an application, will come up earlier, sir. 18th July.
Special Weekly List item 40.
Item 40, my lord, I am there on this thing. This case, my lord, this is a securitization matter, my lord, regarding DRT, my lord, bank auction. But in time, the matter has already been settled and all the dues have been paid, my lord.
All right. Counsel of the petitioner states that the petitioners have been rendered instructions to dispose of the such.
Special Weekly List item 41.
Orders of any type of it. None appears dismissed in office.
May I please?
41.
41 law. That purchaser is the petitioner before lordship. The lease cancellation matter law. The petitioner has purchased the land way back in the
But subsequent
1983.
purchaser, he was not noticed.
I see. The petitioner is the subsequent purchaser from a lessee whose lease has been cancelled by the impugned order of the ADM Kurda.
ADM, yes. ADM
In
Bhubaneswar.
revision case number 735 of 1987. On that short ground, the impugned order dated 21st September 1987 is set aside, and RC number 735 of 1987 is restored to the file of the ADM Kurda, Bhubaneswar, to be proceeded with afresh after hearing the petitioner and any other party interested in the land in question. The matter will now be listed before the ADM Kurda on 2nd May 2021, on which date the petitioner will appear along with a downloaded copy of this order. The ADM Bhubaneswar is requested to dispose of the said revision case within 4 months thereafter. The status quo order passed with this court on There's no status quo order.
No.
All right, nothing. Just the petition is disposed of.
Item 42.
That instead of ADM Khurda, my lord, it should be ADM
Bhubaneswar. All right,
Bhubaneswar.
all right.
Next item is also same.
Same. All right.
Special Weekly List item 43.
None appears. All this dismissed.
Special Weekly List item 44.
Item number 44, petition number 31022 and 31527, both are infructuous.
Infructuous disposed of. All right, all this infructuous disposed of.
Special Weekly List item number 45.
None appears. This is not.
45.
Sorry.
53.
Is
Special
45, my lord?
45.
Yes, ma'am. I am pleased, lordship. Lordship, my lord, the kindly see the page 7. Page 7. The petitioner was before my lord. My lordship can see page 7. This on court while adjudicating disposing the writ petition number 542 by 2011, specifically on the considering submission made by advance by both the bank and the petitioner, has granted liberty to the petitioner to move application before the DRT for cross-examination of the chief manager who has filed the evidence and affidavit in the essay application. But after taking the same, when the application was filed before the DRT, my lord, the DRT is now rejecting the same on the ground that you could have objected the same under section while filing objection 13(3)(a) capital A. Therefore, now you shall not be permitted to cross-examine the
DRT, sir. Challenge the order of the DRT and DRT.
DRT, my lord. Your lordship.
DRT. You challenge the order of the DRT and the DRAT. Did you go before the DRAT?
My lord, I have not gone to DRAT.
Please go to the DRAT.
Your lordship, I appreciate, my lord. Your lordship has that specific direction, and your lordship for a moment can see that what is the nature of direction by my lords. This on court directed.
You go before the DRAT, sir, and point out about our court's direction.
But here is a case, my lord, lordship can appreciate. The fraud itself has been committed by the chief manager.
All right.
Only because 40 lakhs he has siphoned his from the account.
Who are you, sir?
My lord.
Who are you?
I am the my lord petitioner who has availed the loan, my lord, in respect to one account.
No, there's another name for you, sir. You are the borrower.
Borrower, sir. Borrower, sir.
How much have you borrowed, sir?
Only, my lord, I have stated in my para 10 of the writ application, para 10 writ application. Initially, he has availed 3 lakhs for the.
Today, what is the due, sir? Who's appearing for the bank? No one appearing for the bank. You do not know how much you owe the bank, correct?
My lord.
Whenever I ask any borrower's lawyer, sir, how much do you owe the bank? He'll say, I will take instructions. You will also say the same thing, no?
No, my lord.
Today, if I ask you how much you owe the bank, you will say, I will take instructions.
Bank, my lord, on the date of issuance of 13 to notice, they have said 1 crore something because the 40 lakhs has been siphoned.
So you got a stay. How much have you paid? After getting a stay from this court, how much have you paid? Nothing. You got a stay in 2011, correct?
My lord.
How much did you pay after that, sir, in the last 11 years?
Lordship, and here is the issue is something different. Lordship,
I know, it is always different, sir. The issue is always different. 1 crore was owed to the bank. How much have you paid after getting a stay of the DRT proceedings from us?
But here is a case.
How much money did you pay the bank?
My lord, kindly appreciate for moment pleadings a stand I have taken para 10. If I will got that regarding my lordship may not ask question how much you have paid or not.
I see.
Because here is a chief manager himself opened the account without consent of the loanee.
So and you did not avail of any loan according to you?
Yes, my lord.
You have not received any money.
Only one loan. Only one loan that has been already within the limit.
I see. How much money? You don't owe anything at all to the bank.
My lord, I have stated in para 10. Para 10, lordship, what is the action of the chief manager? What is it?
No. You answer the question, sir. We'll come to para 10, para 11, para 12. All that will come. How much do you owe the bank? Do you owe any money at all, or you don't owe nothing?
Well, according to my submission, the petitioner is not liable to pay the said amount as raised in the.
Then you have an excellent case. Then you have an excellent case before the DRAT. All right. According to the petitioner owes nothing to the State Bank of India, and yet has come straight away in the writ petition against the order of a DRAT Recovery Tribunal, which is clearly an appealable order. Permitting the petitioner to avail of the appellate remedy, the petition is disposed of. The interim order is vacated.
At least protected, that may be, my lord.
Nothing protects, sir. You are more than protected. You have not paid a single penny. The bank is not coming after you.
I agree with you, my lord's view, my lord. I get respect, lordship, my lord. A bank who himself committed the fraud, open fraud, and siphoned the person.
Which is the FIR number, sir? Give us the FIR number which you have registered.
My lord, we have already dismissed. Bank has dismissed some service.
No. Fraud against you. You must have filed an FIR.
Well, bank has acted. Bank has taken action against him.
That's enough for you. If it's a fraud, it's a crime or not?
100% crime.
So where is the FIR number for the crime?
Because they have initiated, I have not filed FIR, but they have department, the bank has taken steps
Follow
to
the next
dismiss my
matter,
service. After this, my lord, this
all right,
46.
sir. All right, sir.
So, lordship, protect me for that period
No,
at least grant
you
some
passed
time.
the order, sir. Sorry. Yes.
Item 46.
This is an award by the presiding officer, industrial tribunal. Normally, even though she is an employee of the bank, I usually appear for the PO when notice is issued, so it may not be fair on my part to conduct this case. May may take it up 1 day or 2 days after, so that I can request one of my friends. Or if
this all you must have known long ago, sir.
Or I can, if lordship can get this, but I can do this, Mr. Also, no problem. Because the employee of the Central Cooperative Bank, reference was made by the state government to regard to her dismissal from the disengagement. And the London Tribunal has negated the claim of the petitioner, saying that she could not produce sufficient documents so that she was validly engaged by the bank.
What is her age?
Age, at the time of filing of this case, she was only 26 years of age.
No notice has also gone in this petition so far.
Yes, my lord.
Yes. Yes, notice has gone. On the other side is already entered appearance, my lord.
Who's the other side?
I'm
Mr.
appearing.
Mohanto, Mr. Devendra Kumar Mohanto is there.
I'm appearing for the bank, my lord.
What do you say, sir?
She was never an employee. She was never engaged. No government order was exhibited. Never an employee. Your lordship may kindly come to internal page 2 of the award. Internal page para 3, my lord. The definite stand we have taken. That first party in the written statement has denied that the second party was ever engaged as an employee with assurance to approach her in future and to pay her wages in arrear. It is also denied that she was deputed to the insurance company at any point of time. Thus, according to the first party, when
even the refusal to employ her is verbal.
No.
No, that's what she has said, sir. She has said that verbally she was refused employment.
Yes, that is what I'm saying. She says verbally she was appointed, and thereafter just immediate 2-3 lines below, my lord, for insurance company time. Thus, according to the first party, when the second party was never an employee of the first party, the question of her retrenchment from the service doesn't arise. However, this is important. It is mentioned in the written statement that the second party was an outsourced data entry operator for some time in the past, and she left the first party on her own to join the insurance company, which is a distinct organization. And in the absence of that organization, the present reference is bad and for rejoinder. She was never employed, and this is the finding. She could not produce.
Challenged by the.
Yes, may I please one thing, Lord? Management has not filed any document, Lord.
Why should it file?
No, Lord. I have filed, exhibited many documents, and co-employee has also been examined in this case, Lord. Lord, look at this evidence of that co-examination.
Sure. Tell us.
Lord, page 11, running page 11, Lord, paragraph 6, second paragraph, WW number 2.
Yes.
Is an assistant manager of the first party, that bank. She says that the second party was working as a data entry operator in the bank with effect from 7/12/2004 and continued as such till 10/5/2007, after which she was asked to work in the premises of the insurance company at Nandisai on deputation. This is the evidence. In cross-examination also she has admitted this. She is a regular employee of that bank. Above my rank, she is an
but there's no document to show that, sir. It can't be an oral evidence, these things.
No, I filed 3 documents, certificates issued by the secretary and certificates issued by the president of the bank. But that how has been dealt with by the learned code below. May kindly look at below.
No, this is a certificate. Just read on, sir, that we'll get that. It appears to be written.
I will continue thereafter. She has denied the suggestion that the second party was never engaged to work in the bank in any capacity. WW number 2 has exhibited one document which is marked as Exhibit 7. This Exhibit 7 is a statement made by the WW number 2 herself. It appeared to have been written by WW 2 after the second party was allegedly removed from service. It is not forthcoming from Exhibit 7 as to under what circumstances WW has made this statement and for what purpose. It is also not forthcoming as to whom Exhibit 7 is addressed. It is in the nature of a certificate issued to the second part certifying the period of her engagement in the first party bank. No doubt, WW2 as an employee of the first party and her statement supporting the case of the second party may bear some weight, but solely on her statement, there cannot be a finding that the second party was engaged in the bank. It has never been reported. No document has been filed by the bank. And similarly,
even this document filed by you doesn't support your case of being regularly employed by the bank.
No, I was not a regular employee. I was engaged as a part-time worker from 2004 to 2007, and thereafter I was not allowed to work. So I approached the the labor authorities, and thereafter reference was made. I never claimed that I was regularly appointed.
Right.
I worked in the bank in different capacities. You'll see paragraph 7 and 8. It has been stated that the secretary of the bank, who is the authority, he has certified that I have been engaged in the computer upgradation at different branches, and I have been directed to work there. The learned tribunal says that even though he has directed, nowhere in the certificate it is written that she is an employee. Because once I am directed by my employer to work in different branches of this bank for upgradation of the computer work, Why should the secretary write that you are being an employee, you go there, my lords? And then accepting the law officer's evidence denying that she was never engaged. No document has been filed by the bank, nor they have produced any evidence of the authorities accepting the law officer.
All right.
Paragraph 7 and 8, your lordship will see. Lords, paragraph 7, may I read out, my lords?
No, we've just finished reading the whole thing. So.
Yes, but 2 minutes only, my lord.
No, we have just finished reading the whole para 7, sir.
Yeah, I'm obliged, lords, I'm obliged.
So the point that the court makes is that all these documents show that you are outsourced employee.
No, they never says that who is my employer, lords. Outsourced means it must have been requisitioned by the bank, lords.
Right.
They've never said that to whom they made a requisition. I was lords, outsourced employee, which lords organization. They have not said anything, lords.
Right.
In their evidence also, the law officer gives a 2-paragraph evidence saying that she was never an employee and she was paid
Do
32,000.
you have any pay slips showing that you were paid salary by the bank? As simple as that. That would have proved the whole case.
Yes, the law officer has stated that I have received
pay slips.
No, Lord, sir, that document has not.
That's the easiest document to produce.
I think your lordship said call for the LCR, my lords.
No. That will be discussed in the award if it is there.
No, he has not discussed that, my lords. If your lordship,
have you filed it, sir? That's the question.
no, my lords, I have not filed that. I have got it subsequently. The evidence of the law officer who on behalf of the bank, where it is in 2 paragraphs, he has stated that, lords, for a period of 4 months and against that she has received rupees payment of 32,000. He has admitted that 32,000 was paid to me.
That's all right. Because she herself is another employee and there's no indication under what circumstances gave such a certificate.
Because the secretary's certificate, paragraph 7, the secretary has directed that to work with different branches of the bank for upgradation of the computer work.
Right.
That is all my case, Lord. So, Lordship will consider because
the challenge in the present petition is to an award dated 16 July 2011, passed by the Industrial Tribunal Bhubaneswar in Industrial Dispute Case number 24 of 2010. The dispute referred to the Tribunal for Adjudication was as under. Take from para 1, the award, page 8. On behalf of the petitioner, 2 witnesses, that is WW1, who was the petitioner herself, and WW2, who was an assistant manager of the opposite party bank, were examined. Full stop. On behalf of the bank, 1 witness was examined. Full stop. The petitioner exhibited 9 documents, whereas the bank did not exhibit any document. Paragraph. In order to prove that she has been engaged as a data entry operator by the bank, the petitioner produced a certificate, a statement made by WW2 herself, who was an assistant manager in the bank. Full stop. However, the tribunal found that the statement was not addressed to anyone and it was issued after the employment of the petitioner with the bank ceased. Full stop. The other documents produced by the petitioner showed her being asked to work in different branches of the bank, but did not clearly reveal that she had been engaged by the bank itself. Full stop. One of the documents was a note prepared by a system analyst, which mentioned that the petitioner and 3 others were rendering services during the computerization of the bank, for which the bank had gone in for outsourcing. Full stop. It mentioned that 4 persons, including the petitioner, open quotation, were allowed to render services as outsider personnel. Unquote. The tribunal therefore concluded that the petitioner was an outsourced data entry operator and not an employee of the bank. Paragraph. Having heard and consulted the parties, the court is not satisfied that any error has been committed by the tribunal in its appreciation of the evidence and the conclusions reached. There is no merit in the present petition. It is dismissed as such.
Special weekly list item 47. Item number 47.
None appears dismissal.
Special weekly list item 48.
My lord, in this matter, assessment order is under challenge. I may be permitted to file an appeal.
All right. Counsel petition.
Delay may be condoned, my lord.
Withdraw the present application to file petition to file an appeal.
My lord, original assess.
Yeah, we'll return it. If the
original assessment order and a demand notice may be.
All right.
My appearance may be required.
All right. If such appeal is filed not later than 9th May 2022, accompanied by an application for condonation of delay, citing the reason for the delay as the pendency of the present petition, it will be considered on its merits by the appellate authority. The original of annexures.
Annexure 2 and 3.
Be returned to the petitioner subject to it being substituted by attested photocopy thereof. The petition disposed of with liberty spread.
Obliged, man.
Special weekly list item number 49.
None appears dismissal of prosecution.
Special weekly list item number 50.
None appears dismissal of prosecution. Yeah, IA is dismissed for now prosecution.
Weekly list
50, I am appearing for the opposite parties
right.
in the main writ petition and the petitioner in the miss case. As per instructions received, the refund amount has already been disbursed by the opposite parties. So this miss case has become infructuous.
All right. Counsel, the opposite party states that the amount in question has already been disbursed and the petition is infructuous. It is disposed of as such.
Weekly list.
His name may be recorded because I am concerned with this matter.
Weekly list press admission item number 1. WPC 17994 of 2013.
Oh, you were mentioning the last item, is it? Huh? Oh, the last item 50.
On behalf of Mr. Mishra, my lord, no instruction.
No instruction disposed of.
Item number 2.
May I please, in pursuance of order of this honorable court, my lord, I have filed the additional affidavit, my lord, that has not been come, my lord, and taken up that additional affidavit. I filed on, my lord, 31st/3/2022, my lord.
It's come on board. No?
Order 22/2022.
Right, the additional affidavit filed by the petitioner be brought into court. This is on 19th April.
Weekly list item number 3.
19th.
Item number 3.
I am
none appears to
the opposite party number 1.
But who's for the petitioner? None appears dismissal of prosecution.
Item number 4. Weekly list.
My lord, I am appearing for the parties in this case, my lord. My lord, during the last time, my lord, that lady who had
what have you paid?
My lord, I have already completed the order, my lord.
Meaning what?
My lord,
meaning what?
By paying the amount, my lord.
Have they paid the amount?
Yes.
They paid the amount?
He has paid them.
Oh, I see. All of them?
All of them.
So it only required a contempt notice. Mr. Mohanty confirms that the amount dues has been paid in compliance with the earlier assurance given to the court. An unconditional apology has been tendered by each of the parties. In that view of the matter, the contempt petition is closed. The apology is accepted and the contempt petition is closed. All right. All right.
Weekly list for orders, item number 5.
None appears to switch no.
Weekly list for orders, item number 6.
Memo. Withdraw. Liberty to file a better application. Committee to withdraw.
Weekly list, item number 7.
My Lord, item 7, I'm appearing virtual mode. I've already filed the requisite for the opposite party 5. Case is posted to 9/5/2022.
All
It
right.
has come up because I have not filed the.
All right. Call on 9/5/22. The requisites filed be accepted. Right.
The state may be directed to file the counter in the meantime. They have to file the counter.
Pardon?
It's coming on 9/5/22.
My Lord.
All right.
Weekly list, item number 8.
On behalf of Mr. Mishra, my lord, can you be taken next week? In the meantime, all the defect remove, my lord.
All right. Defects will be removed within a week. List thereafter.
Weekly list, item number 9.
My lord, this is the TIL pertaining to release of vehicle from the police stations and
What is the compliance in this?
Lord, I think may I request the learned member secretary, state legal authority to compile or to calculate the district-wise data.
The member Orissa State Legal Service Authority will compile the district-wise data regarding compliance with the directions issued by this court and place it before the court on the next date. We'll have it early next month, sir. List on 5th May.
Weekly list, item number 10. Item number 10.
None appears to dismiss in opposition.
Weekly list, item 11. Item number 11, weekly list.
None appears to dismiss in opposition.
Weekly list, item number 12.
The petitions at the villagers, my lord. They have in the year, my lord, 2014, my lord, as given a, my lord, ventilated their grievance before the, my lord, ITCO authority, OP number 2, or my lord, construction of, my lord, cold storage and cow shed or other, or my lord, production, manufacturing of agricultural equipments, my lord. And only there are only 2 acres of land are Anabadi land are available in the village, my lord. But without considering the same, the ITCO authority has, my lord, handed over the land to, my lord, OP number 5, my lord, Blackberry Company, my lord. There is no other lands in the area, my lord, Anabadi or agricultural or, my lord, Gochoral land, my lord. 80% land has been given to the company and other companies, my lord. So, my lord, and to that, my lord, they have also constructed the boundary wall, including the land for, of the villagers as well as the petitioners, my lord.
And we made a representation.
Yes, my lord. Before the, my lord.
No, but since when are they operating? After 2014 till 2021, he seems to have done nothing for 7 years.
And subsequently, we have also intimated, my lord.
No.
Thereafter, finally, my lord, on my lord.
No. You can't go on making representations for 7 years and 8 years, sir.
And
when did the cause of action start?
My lord, recently, my lord, on they have without giving any notice to the real, my lord, landowners of the villagers, my lord, they have, my lord, recently, my lord, they are starting construction so that we have made on Annexure 7 series on 4/2/2022 before Collector Khurda, my lord, for ventilating their.
Para 9.
Please come to para 9 of writ petition.
Yes, my lord. Para 9.
You have mentioned there that you made a representation on 17/12/2014. Correct?
Yes, my lord.
Now, next paragraph, come to para 10. You are mentioning about a representation, para 11.
11, my lord.
Representation dated 30/11/2021.
Yes, my lord.
What happened in 7 years?
My lord, nothing was that. Now, recently they have, my lord, started.
Lord, demarcation case has been initiated. So Lords may
and-
kindly come to page 15, my lord. Now the notice has been issued to both the private opposite party company as well as the present petitioners also.
Okay.
Lords may kindly see the
So they
land
can
schedule.
participate in those proceedings.
Yes, my lord. So I don't, Lord, the OP
It
number.
appears that Tahsildar Begunia has already issued notices on 17 January 2022 to the
and not to the original landowners, my lord, to the person, other persons,
No,
my
no, no.
lord.
You are Harichandan only.
Yes, my lord. I am one of the
My lord, your petition
private party.
name is
My
Krishna Chandra
land is
Harichandra.
also adjacent to the boundary wall, my lord. They have also acquired the lands of the petitioner.
Son
as
of
well.
Krishna. Your son only has got it, sir.
No, my lord, mine.
Yeah.
Son-
Serial number 3 is your son.
Yes.
It's not a PIL at all then.
My lord.
Notice has been issued to the son of the present petitioner.
And
As regards
including my
demarcation
name
of
is
the
also
boundary.
there. My name is also there in the ROR, my lord.
This
My name
appears to
is
be,
there.
therefore, a
Krishna
private
Chandra-
dispute and not in the nature of a public interest litigation. It will be open to the petitioner to participate in the proceedings before the Tahsildar. In the above proceedings before the Tahsildar, the petition is disposed of.
Quickly list item note 13.
May it please your lordship. May it please your lordship. My lords may kindly turn to Annexure 2 at page 12. Here, my lords, I file my return of income for the assessment of 18-19, declaring my total income at rupees 13,99,155 on 23rd of October 2018. Thereafter, my lords, a notice was issued under section 148A. There, my lords, lordship kindly, lordship knows after 142021, the new provision 148A was inserted and writ petitions were filed as to the compliance, non-compliance of 148A. Now, what has happened, my lords? Here, the assessing officer behind my back conducted an inquiry and he issued a notice under section 148A, that is Annexure 3, page 13, my lords. Annex that page 14, lordship will kindly see that he has alleged that and that I have purchased, bogus purchase from Mid-East Integrated Steel Limited to the tune of rupees 1,51,42,031 has escaped assessment for the assessment year 18-19. Then, my lords, lordship will kindly see the next page, page 15, Annexure 4 is my reply, my objection. And there, my lords, I have, with annexes, I have demonstrated that it is not bogus purchase. And I requested that lordship will kindly say the last line of my prayer, the assessee further request that before any adverse view is taken in the above matter, an opportunity of hearing may kindly be allowed. Now he, instead of confronting it, that is what is provided under section 148A, he directly issues the order under section 148A, rejecting my contention without any confrontation, which my lords may kindly see the new provision 148A subclause B, provide an opportunity of being heard to the assessee with the prior approval of specified authority by serving upon him a notice to so cause within such time as may be specified in the notice, being not less than 7 days and not exceeding 30 days from the date on which such notice is.
148A order, sir. Still,
Yes.
assessment order is not.
No, I'm not. I hear, my lords, my humble contention is that, my lords, the assessing officer has to satisfy the preconditions before he issues a notice under section 148. Now, Annexure 1 he directly issued the notice without confronting. Lordship, for a minute, may kindly see clause D of section 148A. Lordship, may kindly see. Decide kindly. Hey, boy, Tanya. New act. That is the old act. I am giving it. Old. See that new act. Echoes by.
Give him.
Provide an opportunity of hearing with and I'm sorry, I would have got it Xerox, that provision matters. Yes, 148.
Clause D.
So, clause D matters.
Correct.
Clause D says that he will, I have also quoted it, para page 6. Page 6, I have also quoted it, Mallards, that he has to afford me an opportunity of hearing. No, and I have
It's an appealable order.
No, it is not appealable.
Okay, whenever the assessment is passed, then you
No, assessment, here not an assessment. Here the issuance of notice, that is reassessment proceeding is initiated. Here there is no question of appeal, Mallards. Appeal is provided under section 246A to the CIT appeal. And that is not included. This is only a notice that initiating reassessment proceeding. And it is nothing but a legislative recognition of GK and Driven-Shaft. That you have to hear the objection.
So all I'm saying is, we are still at that stage only. No reassessment order is yet been passed.
No, it is. I am challenging the proceeding itself is illegal because I am saying
all these grounds will be available to you, sir, when you challenge the assessment.
Mallards assessment will take place after my objection is heard. I have specifically objected and said that you kindly afford me an opportunity of hearing. Lordship sees that that prayer, Mallards, that is annexed.
Word hearing used in 148A.
Mallards?
Where is the word hearing used?
Yes, that is there, Mallards.
Let's see that.
Yes. Lordship may kindly see. That is Mallards. B, clause B, 148, clause B, Mallards may kindly see. Provide an opportunity of being heard. There are two B conditions. Before you conduct inquiry, you have to take the
opportunity of being heard means, does it mean actual physical hearing?
Yes, physical hearing.
Why?
Or, yes.
Why?
Provide, yes, Mallards may kindly see. An opportunity of being heard to the assessee with
So
the
you are-
prior
you are giving your
approval.
objections. You are giving your objections.
I have given my objection and without hearing me, Lordship will again see clause D. Clause D says decide on the basis of materials available on record, including reply of the assessee whether or not it is a fit case to issue notice under section 148 by passing an order with the prior approval of the specified authority.
Does this actually mean physical hearing or?
Yes, physical hearing. Physical hearing, Mallards, Lordship knows in 263, the commissioner, when he is exercising the revisional jurisdiction, he has to hear 263 may, the word is used may on hearing. And this honorable court in Ashok Ispat has said may means shall hear.
All right. Who's for the department?
Mr. Chimanka.
Yes, my lord.
Yes.
Page 17, he has already appeared. And page 17, he has already appeared before the. Yes,
78. Where?
Page 17.
Where I have appeared?
He has given the document.
Have you heard me? Yeah, unnecessarily you are. Always he says something born from blue, and he will mislead the court.
No, please.
He has not read the brief, and straight away he is coming that page 78. That is the whole problem with Mr. Chimanka.
No, 78 is not even there. There is no 78 pages.
Yes, which brief he is reading?
Page, Mr. Chimanka.
He made the e-compliance.
Huh?
He made the
compliance, if proceeding
And compliance was moved by object. I have filed my objection.
objection letter, but he has given document.
Objection letter. Have you heard me? That is the mandatory requirement of 148A, and that is the legislative recognition of GK and Davins Act. So many high courts, 2 days before my last Bombay High Court also quashed that 148 initiation of the proceeding.
Yes, Mr. Chimanka.
Then let me take instruction, my lord.
That you should have said in the beginning. Honestly, you have wasted the court's time.
Notice, Mr. Chimanka accepts notice.
Lordship may stay the reassessment proceeding because immediately the faceless
time
is
for
there.
instructions. One of the principal contentions of Mr. Rai, learned counsel petitioner, is that under section 148A bracket small b,
manners,
there's a mandatory requirement of the petitioner having to be single quotes heard, unquote, before the notice is issued under section 148 of the Income Tax Act 1961. And that the said requirement has not been fulfilled in the present case. When you say till the next date of hearing, no further steps shall be taken pursuant to the impugned notice. Based on 4th May.
Malus. 4th May. This is malus, another variant of this corona. We have enjoyed it after 1/4/2021. Much obliged, my lord.
All right.
My lord, I pray item number 10 may be taken tomorrow. My lord, non-appearance dismissed. Actually, I have mentioned at 2 o'clock, my lord.
Oh. What's the matter about?
It's a public interest litigation, my lord.
No, that is right. What is it about?
The petitioner is praying for eviction of.
There's some endowment lands, my lord, that has been acquired.
Illegal encroachers. Have you made them parties?
No.
You have to make them parties, sir. Counsel the petitioner seeks leave to withdraw the present petition to first make a proper representation, naming all the encroachers. And after following up on such representation.
Well, in the representation, my lord, he has mentioned, my lord, in the representation, that is an
No, there's no names of encroachers. Seek appropriate remedies in accordance with law.
My lord, obliged.
Post office withdraw. With liberties.
Weekly list item number 14.
None appears.
No, I am. For the petitioner in third case, my lord, not the first two.
Who's in the first case?
I am the first case, I am the petitioner. My lord, in this case, that is the case of Kendra State. The petitioner challenged Annexure 8. The input order is Annexure 8, passed by the member of Board of Revenue. The learned collector.
38B.
Same 38B withdraw, file suit, all the cases there.
No, in this case, suit is not necessary. Annexure 6 is a civil suit judgment, my lord. The honorable competent civil court already decided right at the person of the petitioner. So, revenue authority has absolutely no jurisdiction to interfere it. That order also not set aside by higher forum. Annexure C in my favor, my lord. That's a civil court judgment, my lord.
Annexure 6.
My lord. LCR also received my
not a title, sir. Just read that order. Annexure 6, read that order. Operative portion. It simply says nobody will alter the status quo. You must have gone for injunction, not title.
But in this case,
this is
the civil
like
court
a
argued my
permanent
title, my
injunction,
lord.
sir. This is not a title suit. This doesn't prove your title.
My counter affidavit may kindly be seen.
The civil court accepted the document as a genuine.
Yeah, misappeal. That's what.
The civil court accepted my document as a genuine and injunction order.
That is against
Injunction order is
interim order.
different from title, sir. Injunction order is not the same thing as title.
That is the interim application, but after the case is disposed of. And the right
If you
title.
want to withdraw and go for a civil suit, you go.
Suit already declare my right title in the court.
It's not your right and
Annexure
title,
6
sir.
my
It's
lord,
just a
Annexure
status
6
quo order.
My lord, this is the Annexure 6 is a miscase order.
That's what.
But LCR received. Final order is available.
Where have you placed the final order?
Final order, my lord.
This is judgment pronounced, sir. This is not.
My lord, it was next week listed. I will file final order. This is a 2004 matter. In the meantime, civil court decided my right title interest and confirmation my position. Suddenly listed after 20 to 21 years. This is a case of 2004, my lord.
What about the second matter?
Second matter, my lord, there is a my case or no instruction in this matter, my lord.
Second matter, he says no instruction disposed of. Third matter,
if we
Lord, here the petitioner challenges the ex parte order passed by the member of Bureau of Revenue by Annexure 2 under Section 38B of the Orissa State Abolition Act, my lord. My lord, the land, the petitioner was recognized as tenant by Annexure 1, page 9, my lord. The lord, kindly page 9 on 26/3/1983, my lord. 23 years after, because at any time is stated in 38B, 23 years after, the member Board of Revenue initiated the proceeding on the report of the collector and has passed the order ex parte without service of notice on me. My lord, your lordship may kindly
there's no interim order here. There is no interim order.
No,
passed
no,
here.
I don't know. No, there isn't.
So by now, all the status could have changed.
It's the same type of case, and your lordship knows that
You want to ascertain your rights, you go in a civil suit,
has
sir.
already been dealt with by the Honorable Appellate Court. And
You
all
go
the
in a civil
cases
suit, sir, if you want to.
are withdrawn.
But
And
fact remains, my lord, it must be within a reasonable period.
Yes, yes.
And reasonable period is not 23 years, my lord.
Anyway, there's no interim order, sir.
And furthermore, my lord,
You
notice
withdraw
has
and
not
go in
been,
a civil suit, sir, to establish your right, title, and interest.
my lord, when I am challenging the Annexure 2, that is passed after 23 years,
Yes, yes.
not within reasonable time,
All right.
and that is an ex parte order without hearing me and without serving any notice
But
on
if
me.
you have any document, you show that.
My lord, I
Without a
have not-
document, there's no point in sending you back.
my lord, because my lord, no notice has been served. There is
Sir,
no
if you have
occasion of me.
something to show, if notice had been issued to you, would you have produced some document? That is the
No, my
question.
lord, no. Your lords, for that, your lords may see page 13, paragraph 3. Collector Jajpur had wrongly identified the opposite party Balawanta Singh, myself, my lord, as son of Madan Singh, and had reported that his whereabouts are not known. But I am son of Mohan Singh.
Sir, what is your document to show any right, title, interest to the land? That is the question.
That is, my lord, a lease deed.
Where is that? Where is that?
Hatpata, my lord, that is not produced.
So you, whenever you think you can produce, that day we can hear you. Till then, you file a civil suit and take your chance there. Either you withdraw, we'll dismiss it on merit, sir.
If your lordship will give liberty to file suit, because suit is now barred
Counsel the
because
petitioner
of this.
seeks leave to withdraw to seek other appropriate remedies as may be available to the petitioner in accordance with law. Dismissed as withdrawn. All right. First matter, you say counsel the petitioner needs time to produce the original decree in the original suit, which according to him has decided the issue in his favor. At his request list on 11th May. No further time will be granted to the purpose.
Weekly list item number 15.
Next week.
Tell us what the matter is about.
In 2012,
So all this, there's no cause of action doesn't survive, sir.
my Annexure 3,
Some construction of road and some khata and all this.
previously in 2012, I have approved before this honorable court, and this honorable court by in page I quoted the order sheet in page 5 that at 28/10/2021, this honorable court directed the collector and Tahsildar to take a decision who are the enforcers. As per that direction, we have requested to the collector and the Tahsildar. The collector and the Tahsildar initiated 27 cases
for eviction.
Oh, then,
Out of
then
27.
already OPLD cases have been initiated.
What's the progress? The
But
latest status report on the eviction of encroachers we placed for the
Counter
court.
affidavit has been filed.
They have,
Latest.
they have
What is the date of the
evicted-
counter?
They have evicted 25. Again, they 25 they have enforced.
All right. The latest status report on the encroachment on the land in question we placed by the Tahsildar. Which area Tahsildar is this?
Balyapal.
Balyapal, before the court on the next day. 29 June.
Weekly list item number 16.
Why do we need so many connected matters, sir, for one issue?
In other two cases, they have stayed the eviction order. Though the Tahsildar has said there is no excess land, I have filed the affidavit. Still then, this honorable court had stayed the eviction proceedings. Other two cases.
Who's appearing the other two? Call out Kanan Bala Mohanty. Anyone appearing?
23263 of 2012 and 23264 of 2012.
None appears. Dismissal, non-prosecution. What about the last one? Tapan Giri?
WC 23635 of 2012.
None appears. Dismissal, non-prosecution. The interim orders are vacated. All right.
Weekly list item 16.
None appears. Dismissal,
In this
non-prosecution.
case, my lord, we are applying for the Union of India, Opinor
All
1
right,
and
all
10.
right.
That is the matter relating to Aadhaar card.
No, we've dismissed for non. Who is the petitioner?
16 sub item 2, permit to withdraw.
Sub item 2 dismissed is withdrawn. Item 1 none appears. Dismissed for non-prosecution.
Appearance of the Union of India.
Weekly list item number 17.
None appears. Dismissed for non-prosecution.
Weekly list item number 18.
Classic item 18 the matter is infructuous.
All right. Dismissed is
18. Weekly list item number 19.
18. 19 permitted to withdraw.
Permit to withdraw.
Weekly list item number 21. Item number 21, weekly list.
None appears. Dismissed for non-prosecution.
Weekly list item number 23.
Come up to 2.
Okay.
23. What were you saying, sir?
I played 2 weeks time
For what?
to argue the matter.
No. What's the matter about, sir?
Matter is regarding the appointment from the post of Group D to Group C. The petitioners has Group D employees.
All right. List on 2nd August.
Weekly list item 24.
None appears. This is not.
Weekly list item number 25.
Your Lordship, this is PIL matter, my lord. Matter relates to dumping and parking of seized material in front and around the Badambadi police station, my lord.
That is already there.
There is an order of this honorable court
Correct.
directing the collector and the DCP to
Correct.
file an affidavit, my lord,
Today I
to
am
file
filing
a
the
compliance
affidavit.
report.
Give him a copy, sir.
Before hearing, they should give a copy, not give. May I pray, my lord? 10 days time may be allowed. I will verify the compliance report. If necessary, I will file counter, my lord.
Photographs.
They've all been shifted out.
Yes.
My lord? Is there only 7 days time may be allowed?
Okay. Affidavits of compliance have been filed. Counsel for the petitioner needs time to verify the details. List on which date did we fix the other one? 2nd May. 5th May.
May I pray, my lord? There is another criminal miscase I have filed prior to filing of this writ application, my lord.
What
That
is
is
that for?
connecting to that, sir.
What is that for?
That I have, the petitioner have filed an application under section 133 of CRPC. That is creating a nuisance, public nuisance.
All that
on the
is now
public.
not doesn't survive any longer, sir. All that. Just look into the photograph, go to that area.
My lord, I will verify within
All
1
right,
week
all
if
right.
necessary. I will file counter.
All right.
Oblige, my lord.
Quickly list item 26.
Item 26, my lord, I am for the OP number 6. Your lordship by order dated 18/8/2021 has directed that from time to time file the special report development of the present work. And in fact, also I filed the report today also for the month of
This is that Mr. Sambit Samal.
Sambit Samal is appearing.
Where is he?
Perhaps, my lord, he was.
There he is. Yes,
My
Mr.
lord,
Samal.
item 20, my lord, I am the chair, my lord.
Joint inspection report is here, Mr. Samal.
No, my lord.
Mr. Monty says you are having a very smooth ride now.
Pardon?
He's saying you're having a very smooth ride now on those roads.
Motorable roads.
No, my lord.
You're not having a smooth ride.
No, my lord.
You seem to be busy walking from some place to the other.
My lord.
There he is. We'll call it in 2 minutes. You just sit down. Just sit down and we'll call it in 2 minutes.
Quick list item 27.
Yes, sir. Item 27.
You're in 27.
To his set, I may be granted to file the rejoinder.
All right. Rejoinder will be filed for the next day. It's on 10th August.
Quick list item 28.
Item 28, Your Lordship, may kindly see order dated 9/2/2022, my lords. Your Lordship have said it appears that there are two references made at the behest of the department involving the same issues that arise in the present appeals. Mr. Satpathy Lawrence, senior standing counsel for the opposite party department, seeks time to give the details of those reference petitions. He should do so within a week. The registry of this court will list these two appeals along with the said references on 4th April 2020. That's why it has. That you noted.
March, my lord, we are not able to receive the
Okay.
instructions.
Mr. Satpathy needs some more time to give the numbers of the connected matters, connected reference petitions. List on 16th August.
August, my lord.
After Independence Day.
At least shortly after vacation, my lords.
Too many matters. Too many matters. All right.
Quick list item number 29.
29, Your Lordships, to here, my lord, notice has been issued on the question. Two questioners involved in this appeal. Starts from.
We'll take it up on some other day, sir.
Yes,
It's already
yes,
4:30.
yes.
All right. List on 17th August.
Quick list item 30.
Again, list on same date. So
List
30,
item-
31, 32, all 17th August.
10th August, after 38.
Okay. Yeah, 17th
I may be
August.
pardoned, my lord. In item number 33, I have instructions to appear for the respondent. And your lordship, there are also 3 other connected matters.
All right. Give us those numbers.
Yes, number, I'm providing those numbers. And your lordship, my small request is item 33 along with those 3 appeals, can it be listed next week?
Why?
Or,
We're having
or
it in
week
August,
commencing
17th
18th.
August. 17th August.
Lordship, Mr. Ishwar has given his consent and we want to finish this appeal. Lordship, week commencing 18th, please. I humbly pray. It will take
All
only.
matters listed on 20th July, my lord. All 3 matters has been listed on 20th July.
It can be preponed, my lord, along with this appeal to 18th of April.
Preponed by whom?
I mean, lordship may direct those 3 appeals to be listed along with item 33.
No, we don't have time. It's too tight, sir.
Lordship, it will take very short time, my lord. All are identical issues. It will take short time, my lord.
Which are all meaning which all matters?
18th of April I'm seeking, along with item 33.
It is not possible. I have to take instruction. So I have given the reply on 20th July.
Let it be on 20th July only. All right. Item 33, I think all of them matters. We'll take
Or
it
at
on
least
20th July.
any day before summer vacation. Month of May will also do, my lord.
Mr. Chimanka, you let it be on some earlier date.
Not possible. I have to get instruction from the Hyderabad.
Oh. We'll have it on the opening. We'll have it on the opening.
Lordship, 33
6 July.
numbers-
6 July.
33 numbers, the similar order may be passed, 86. E-City, 33. Mr. Chimanka has given this copy, which has been.
20th July is there.
In 85, the same order is in 86. I think list along with 86 on 5th July. We'll just advance it by 15 days, sir, 5th July.
Okay.
The next date of 20th July is cancelled.
Oh, bless me.
And list along with the other numbers. What are the other numbers?
Yes, my lord.
My pleasure, Lordship.
Ah.
My lords, right now I received a copy from my learned friend regarding the development. But my lord, according to my instruction, in the last occasion, my learned friend had pleaded before this court that by March 2022 the work will be over. But my lords, till date, the condition is as it is. And moreover, my lord, may I be permitted to read out my paragraph 6 of the rejoinder. Thank you, my lord.
Then we'll take it up on some other day. 4:35. Mr. Samal is still not satisfied with the condition of the road.
No, my lords, the condition is there are many in the entire stretch.
You're not satisfied. Not satisfied, I've said.
Yes. My lord, the satisfaction.
No. Not satisfied with the condition of the road in several stretches.
My lords, around more than 40 kilometers, my lord, they have not completed and still they are collecting the tolls, my lord. My lords, they are independent engineers.
Mr. Mohanty, appearing on behalf of the NHA, on the other hand, has handed over a joint inspection report.
The officers of there, they have inspected and giving the report. How can they manage?
My lords, they are independent engineer in their concessionaire agreement has clearly mentioned.
No, not now, sir. Not now. We'll have it on some other day. List on.
My lords, illegally, three numbers of toll gates, they are collecting 75% of the roads, my lord, they have not completed till date. So why they will collect?
All right. 2017. All right.
And I am appearing on behalf of Union of India, my lord.
All right, sir.
Most humbly, I pray before my lords to accept my interim application, my lords.
Whatever, all applications.
My lords, let that be a stay for the toll gates till the completion.
No.
The last occasion, my lords, they have told before this honorable court that already by March 22nd we will pile up the work.
All right.
But till now they have not done, my lords.
All right, sir. We'll hear you on the next.
Weekly list item 39.
Lordship.
39
I have fixed, my lords.
My lords, items 35 and 38.
In item 39, I have received an instruction that the appellant plus.
No, Mr. Johnny, we have adjourned that to
beg pardon, my lord.
17th August.
I'm grateful, my lords.
Beg pardon, my lords. My lords, the date may kindly be fixed.
Just giving you the date. Giving the date.
27th April.
27th
April. Item 39. 39 will in view of the instruction I have received on 6th March 2022. It is ascertained from the Bazaar committee and villages that appellant is not having any permanent house in his village and he used to sleep in south veranda of the Bazaar. Since last 3 months, he is not available.
Mr. State Counsel, my lord, I am appearing, my lord, before your lordship now in the court. He has come, my lord, pursuant to your lordship's notice. And when your lordship, he has come, he has once appeared on before Honorable Justice. That was my lord. Since it is your lordship's aspect, again, he is also appearing today. He is present in the court. His personal appearance may be dispensed with. A date be fixed for the hearing sometime in August, my lord.
All right. The appellant is present in person. Mr. Dharnidhar Nayak, senior advocate, appearing on his behalf. states, assures the court that he'll be present as and when the court requires him to be present.
Right.
His presence is dispensed for the time being. Right. So you're ready on Thursday, we can have the matter?
Oh, no, my lordship, 2 weeks or 3 weeks time may be given. Very old matter. I have not seen your lordship. 4 weeks at least, sometimes in July.
Let's don't have it in June, sir, fresh from vacation.
Yeah. Well, 1 week after vacation. Fresh from vacation, it will be a problem.
All right. 1 week after vacation is 30th June. 30th June.
My lord, I'm opposed.
May pardon you, lordship. Item 3 of today's weekly daily list, my lord. I went to the another court, my lord, to attend a case. That is why the matter called for.
We don't know what, so you can file an application. What is item 3?
My lord, any date may kindly be fixed.
What is item 3?
Item 3
non-prosecution.
Weekly daily list, my lord.
What's the matter about, you tell us?
Matter, my lord, the petitioner will file this case for, my lord, only for direction to the opposite party to take step for functioning of 190 numbers of Aadhaar enrollment center of BSNL at Orissa Circle, my lord.
So that representation is there?
Yes, your lordship.
All right. The petitioner's representation dated 20th October 2021 be examined by the BSNL.
Yes, your lordship. Opposite party number 2.
Opposite party number 2. And after giving the petitioner a hearing. That is New Delhi, sir.
Yes, Lord.
It's better you are heard by the Chief General Manager. Opposite party number 3. And after hearing the petitioner, a reasoned order be passed thereon.
Yes, Lord.
Not later than 16th May 2022. And be communicated to the petitioner not later than 23rd. All right. This is item 3.
Weekly list item 1. Obliged, your lordship. Deeply obliged. Weekly list item number 40.
Lordship, please, blood. Last but not the least, and the short point is whether it has to go back to the settlement commission.
We'll have it on some other day, Mr. Sharma.
But my only respectful submission would be if your lordships could be kind enough, Lords, 2nd May, 6th of May, and 9th of May.
9th.
Whatever.
Let's have it on 9th May.
Very well.
Right.
9th.
All right.
Great.